All are united today by a common goal to understand the legal responsibilities that shape our clinical practice. In today's fast-paced healthcare environment, we constantly make split-second decisions that can have a profound impact on the patient's outcome. Legal awareness, therefore, today is no longer a luxury, it's a necessity. Legal issues ranging from consent, patient rights, workplace safety, medico-legal documentations are as much a part of our curriculum as the working clinical skills. Whether you work in the emergency department, ICU, operating rooms, or the outpatient clinic, the legal dimensions of healthcare touch us all. From handling sensitive cases like child abuse, mental health care emergencies like suicides, to managing end-of-life decisions, documentation of medical legal cases, or facing the workplace violence, the challenges are always real and they are growing. This conference was envisioned to bring confidence, clarity, and competence to our daily interactions with the law. We are fortunate to be guided today by a stellar lineup of speakers from seasoned clinicians and legal experts to public servants and policy thinkers. Who will walk us through not just the theory but real-world case scenarios and the practical solutions. Today's conference is not just about understanding the law, it's about transforming our approach to the healthcare. Each session has been carefully curated and led by experts who bring a blend of clinical acumen with the legal expertise. By integrating legal experts into our clinical practice, we improve our ability to serve our patients more effectively and ethically, while also protecting our teams and also ourselves. It's about being proactive rather than reactive in a system where legal challenges can arise at any moment. Thank you for dedicating your honorable time and expertise to this crucial conversation. I invite you to engage actively, ask questions, and make the most of the collaborative spirit of this conference. We hope today's session will spark important conversations and leave each one of us feeling a little more empowered and a lot more prepared. Together, we can lead the way in creating a safe, more legal, and sound healthcare environment. So once again, welcome to this day of learning and collaboration. Thank you for being here. Let's make it a meaningful and enriching experience for us all. It's my absolute pleasure and honor to welcome our keynote speaker, Sri Ajay Mishra Garu, retired IAS, Honorary Chairman of the Indian Red Cross Society Telangana chapter, with many more academic and administrative achievements. With a wealth of experience and expertise garnered from his illustrious administrative career, we are truly fortunate to have him here with us today to share his valuable insights on topic, the legal landscape of emergency medicine in India, the challenges and the insights. Please join me in welcoming Sri Ajay Mishra Garu onto the stage.
friends. First of all, I'd like to thank the organizers, the AIG Hospital, for giving me this opportunity here. And what I tell now will be common knowledge to few, because we have senior advocates sitting here, senior, I'll say, world-renowned medical professionals also, chairman of this hospital, Dr. G.N. Reddy Garu. On the law and order side, Shri Sajjanar ji is here, and other senior doctors here. See, the topic, legal framework of emergency medicine in India. If I start on the legal side, first of all, the Indian Constitution, health and law and order, two subjects, they are in the state list. That means most of the legislation, the framework has to be in the purview of the state governments. That is the beginning. Second, there is no specific national law addressing the emergency medicine in our country still. But then our Constitution provides for right to life and liberty for the citizens. Article 21 asserts that no person shall be deprived of their life except according to the procedure established by law. What does that mean? It means everyone has a right to life. The state has to ensure. But then, this has been interpreted by Supreme Court in 1989 in Permanent Katara versus Union of India case, wherein the Supreme Court observed that when accidents occur and victims are taken to hospitals or to a medical practitioner, they cannot be refused emergency medical treatment on the grounds of their ability to pay for treatment. Continuing on this, in 1996, another Supreme Court judgment reiterated this. That was Paschim Banga Khet Mazdoor Samiti versus the state of West Bengal. This interpretation by the Supreme Court means it is the duty of the state to ensure the protection of life, including emergency medical care. As I mentioned, we don't have a medical act from the government of India to regulate these things. But then in US, we have a law which is called EMTALA. It was passed in 1986. It is called Emergency Medical Treatment and Labor Act. Here, even the advanced gynec cases are covered under the EMTALA. The provisions are same, that stabilizing treatment for emergency medical cases have to be done by the hospitals. So this is the medical scenario in the country in terms of legal framework. Proposals are there by different organizations, but then government has to enact. There have been concerns about aggressive behavior, damage to medical institution properties, and attacks on doctors in the past. How they have been addressed, it's a very serious concern. The only national act that we have was in the wake of COVID-19. On 28 September 2020, Government of India notified Epidemic Diseases Amendment Act 2020, which provides for imprisonment from 3 months to 5 years and fine from 50,000 to 2 lakhs to the perpetrators of violence against doctors and medical institutions. In case of grievous hurt, imprisonment from 6 months to 7 years and fine from 1 lakh to 5 lakhs, plus twice the fair market price value of damages to property can also be imposed by the courts. So this is the only act, but this was only in the context of COVID, in the context of epidemics. I mentioned in the beginning, health, law and order are state subjects. So what are the state acts provisions which are useful to the doctors or medical institutions? Our state, that means Telangana. It has passed the Act Telangana Medical Service Persons and Medicare Service Institutions Prevention of Violence and Damage to Property, Act 11 of 2008. So this act, what does it do? It prohibits violence against Medicare service personnel and damage to property in Medicare service institutions. What does it provide for? It provides for imprisonment up to 3 years, fines up to 50,000, plus twice the purchase price of equipments and damage caused to property. It also provides that if the aggressors are not willing to pay, then Telangana Revenue Recovery Act can be utilized against them. The violent incidents are categorized as cognizable and non-bailable. But then the question comes whether these are sufficient or what are the other states doing. The best example is of Kerala, where Kerala provides for what one can call expediting justice. See, the act is there, but then we know the courts, the legal process, that takes much, much longer time. So, as is generally said, justice delayed is justice denied. What does Kerala Act provide for? It says that Inspector of Police has to complete investigation in 60 days of FIR registration. Second important provision, when the victims are being, hearing is going on in the courts, courts have to give hearing dates on consecutive days to examine the victims. So this is to ensure that justice is not delayed and it is done in a time-bound fashion. What are the shortcomings or what can be done further in our Telangana Act? See, the medical staff, the doctors are covered in most of these acts, but the staff, that means the nurses, etc., and other staff are not included in many of the acts across the country. When I say across the country, in other states, including our state. Besides Kerala, Tamil Nadu, Karnataka, Maharashtra, we all have acts, similar acts. Second, the penalty which is proposed is not increased with the gravity of the injury or the gravity of the offences committed by the perpetrators. So, this is the scenario. In this context also, proposals are pending with Government of India to come with a unified act at the central level, but then when it comes, we all have to see. Another concern among doctors is of cases being filed against the doctors for medical negligence. That's a very sensitive issue, if I can say, a very contentious issue, because what is the drawing line between professional error and negligence or rashness? That is a matter of different legal disputes. Courts have attempted to resolve it, but up to limited success only. Cases registered against doctors. This is a cause of concern for most of the medical doctors, how to go about treating the patients to avoid legality criminal cases. As per the data of National Crime Research Bureau, 2017, 198 cases were registered against doctors. Then in the coming years, 218, 210, 133, and 142. So cases in the last 2-3 years, the exact data is not there, but it will be around same 150 to 200 cases. Then comes how many cases have been charge sheeted after investigation. The percentage of cases charge sheeted after investigation is coming down from 64.8% 7-8 years back to about 49.7% 3 years back. How does the Supreme Court judgment come to the rescue of the doctors? Supreme Court in 2005, Jacob Matthew case, has observed that doctors accused of rashness, or negligence may not be arrested in a routine manner, unless, of course, furthering of investigation or for collecting of evidence, or the doctor is not making himself available. The suggestion is also that in such cases where FIRs are there against doctors, at least the SP level or the Deputy Commissioner of Police level officers should be involved before any action like arrest is taken against the concerned doctor. In this case, the government doctors have some respite, if I can say, because they are treated as government servants and prior sanction from competent authority is required if prosecution has to be there in a court of law, because it is their official duty which is supposed to be performed by them. Otherwise, prosecution may not be sustainable. Medical negligence. What does medical negligence mean? It's a very debatable question, but then the legal framework, what does it say? In 2000 in Moni versus the state of Kerala case, the court observed that if the doctor conforms to one of these standards while giving treatment, then it will not be considered as negligence. Because for many diseases, there may be 2-3 modes of treatment which are standard. But then in Dr. Lakshman Balakrishna Joshi versus Dr. Bapu Godbole case in Supreme Court, negligence has been enumerated or defined as basically failure to do duty of care by the doctors. Duty of care has 3 aspects: whether case to be taken or not, what kind of treatment is given, and the proper treatment to be done during a course of time. It also includes diagnosis, operations, including proper anesthesia. I saw the program. There is a separate session on medical negligence and what doctors can be doing. There is one more concern among the doctors, which is Consumer Protection Act. Few years back, the medical service is considered to be coming under the Consumer Protection Act, and number of cases are there which put, if I can say, medical stress on the doctors while giving the treatment or discharging their duties. There are 2 kinds of liability which come to the doctors. One is the civil liability and the other is the criminal liability. The civil liability depends on negligence. The criminal liability depends, besides negligence, on the intent and the nature of or the quantum of injury or the damage or the consequences which the patient has to suffer due to some kind of a wrong treatment meted out to him in the hospital. Why we have to be careful? Another thing. Can anyone tell what is the maximum compensation awarded by a court in India? It is 6 crores compensation. That was in Dr. Baham Prasad versus Dr. Kamal Shah by the Supreme Court. And including interest, it was 12 crores because there was a 15-year delay in justice. It was a case where it involved the death of a patient. But then there are other things which have to be taken into account. The court cases. The senior doctor and the management is also held responsible for acts of junior doctors at times. In Mr. Ramesh Reddy versus the state of Andhra Pradesh, the washroom of the hospital was not maintained up to the mark. The patient slipped, and finally, I think 1 lakh plus compensation was awarded to the patient. In case of a surgical operation which later was proved that it was not necessary, in Lakshmi Rajan versus Malar Hospital, 2 lakh compensation was provided. When it comes to criminal liability, there's a principle in law called res ipta loquitur, which means basically things speak for itself. See, things speak for itself means which is very obvious from the medical and the non-medical side. So in these cases, the degree of negligence is a factor, degree of offense is a factor, and what could be the factor for negligence is, that is in Jacob Matthew versus the state of Punjab, doctor not having requisite skills and not covering reasonable care and competence. Distinction has been made by the Supreme Court in Poonam Verma versus Ashwin Patel case between negligence, recklessness and rashness. So, what is the solution? These are the issues. See, my general observation, I will put it, general. Most of the doctors are good in the clinical aspect. I have no, competence to comment on that. But when it comes to what is called soft skills, emphasis has to be placed on that. Not only the soft skills vis-a-vis the patient, but soft skills vis-a-vis the attendant of the patients. Because the attendant of the patients don't come for treatment, but they are in medical stress, or psychologically at stress. How they are to be dealt with, I have no solutions except for, the professionals will come into that. About emergency Medicare, there is another proposal which Save the Life Foundation has proposed in its 201st report, as they say, which deals with not only what the government should do, but what the other citizens should do, what awareness should be there among to save the lives. Basically, the hospitals, the doctors are to save the lives. As we know today, 403 deaths are happening every day in our country due to road accidents, 403 plus. The deaths due to non-timely availability of emergency medical care for heart and other patients is known. I'll not repeat those numbers, but they are also in lakhs every year. For the emergency cases, this Save the Life Foundation has advocated, it's not yet accepted or drafted into a legislation by the Government of India. It starts with the awareness for bystanders, as they say, first. Then pre-hospital infrastructure. Pre-hospital infrastructure means basically a helpline throughout the country, emergency medical ambulance provisions. Then comes the medical treatment in the emergency department, which is categorized into 5 trauma cases, and further the treatment which is to be given. But then the awareness about the patients, how to deal with them before he comes to the hospital is also required. Who has to do it? Government to start with, other medical stakeholders in the second round. So with this, I thank the organizers for giving me this opportunity. Details will be gone in by different experts who are to address the gathering today. With this, thank you once again.
Thank you very much, sir, for your address. So, moving on, for those of you who don't recognize me, and I believe it's the majority of the people here, my name is Dr. Nitya Shreya Meghna, and I am an emergency medicine physician in the Department of Emergency Medicine at AIG Hospitals, Gachibowli, and it gives me immense pleasure and joy to once again welcome you all to this event today, and we look forward to making this day, as Prithvi mentioned, a very meaningful and enriching one. I'd like to thank our distinguished guests for being here today, and with that I would like to start off by talking a little bit about what emergency medicine is. And I take this privilege to be here, and I thank my department for giving me this opportunity to talk about this great specialty with all of you here today. So I'm here to give you a brief idea about how it started, how it grew, and why it is more relevant than ever in India today. Emergency medicine was not created by physicians, scientists, or anybody in particular. It was pulled into existence by the public itself and by the pathologies that for decades were fallen through the cracks of our system. While caring for the acutely ill, it traces its roots back to thousands of years, with war and illness always there. The need for a dedicated group of people to cater to this cohort blossomed only in the late 20th century, where it was only in 1968 where the University of Cincinnati started its very first residency program in emergency medicine, and it was in 1979 that EM was officially recognized as a specialty in the USA. It was in the 1990s where emergency medicine gained momentum globally, with countries like the United Kingdom, Canada, and Australia adapting and adopting to this new specialty and training their physicians to be dedicated to caring for the acutely ill. And it was only in the late 2000s that India recognized emergency medicine as a specialty today. Coming to emergency medicine in India, it was in 2009 that we, as a country, had the first MD in emergency medicine that was introduced in BJ Medical College in Ahmedabad. And it was in 2013 that the NMC, back then it was the MCI, it officially recognized the emergency medicine as a specialty. Today we stand having about 650 MD and DNB seats across EM in India, and we only elevating hospital casualties into emergency medicine departments, and these doctors being lifesavers, decision makers, and leaders in acute care. While what we do, so emergency medicine, we like to think of it as the front line of healthcare, and its relevance in today's healthcare landscape ranges from it's because of the rising burden of trauma, of cardiac arrest, of strokes, sepsis, toxicology, and not only that, we also we extend into disaster management, pre-hospital care, and we are essentially the first responders responding to somebody as stable as having a small fever to somebody coming in with a cardiac arrest. It is a very rewarding balance of risk, of decision making, and compassionate care to patients. what is emergency medicine again? So this, like I mentioned earlier, we have a very wide range of services to offer for a patient while tending to their acute requirements of healthcare. As ED physicians, we often make very high-risk decisions, and this is usually without knowing the full history of a patient or not having patient records or consent. And this is usually because as doctors in general, we don't meet happy people, but as ED physicians, we almost always never meet happy people. We meet people on what is probably the worst day of their lives, where they are not physically, emotionally, or mentally stable. And today's CME was designed to empower us because of all these reasons. There are so many legal implications in dealing with such situations, and this CME would empower us not just clinically but legally also, so we can save lives while protecting ourselves. As ED physicians, we would like to think of us as the fighter pilots of medicine, wherein we thrive on teamwork, we thrive on teamwork, we thrive on collaboration, we thrive on trust, we thrive on communication and collaboration with other departments. Like we see this, that a single pilot never wins a war, but a well-coordinated squadron does. And with this, I would like to introduce to you our department at AIG Hospitals, our emergency department, wherein we have a 42-bedded ED, which is run by more than 18 qualified emergency physicians. And we have a DNB program that is running, and we have our 4th batch of DNB residents joining us this year. Well, the future of EM, we recognize the limitations, but we look ahead with hope to an intelligent expansion, because in emergency medicine, it is never an I or a me, it is always a we. And some might call it medicine, some might call it art, some might call it science, but we'd like to think of it as a calling and a privilege to smile in the face of adversity, to be able to care for the most distressed cohort of people. And I would now introduce you to our, maybe you can meet our team at AIG, where we have our HOD, Dr. Ratna, leading from the front. And we have with us Dr. Ratna. And thank you so much. And with this, I would take the honor of inviting all our dignitaries onto the stage. I would like to very warmly welcome our chief guest, Shri V.C. Sajjanar Garu, and I would like to thank him for being with us today. And I would request Ratna sir to please escort sir onto the stage. I would now invite our chairman, Padma Vibhushan, Dr. Nageshwar Reddy Garu, onto the stage. I would now invite our vice chairman, Shri PVS Raju Garu, onto the stage. I would like to invite our director, Dr. G.V. Rao sir, onto the stage. I would now like to request Shri Ajay Mishra Garu also to please join us on the stage. And I would now request Srimati Vishwajanani Garu, who is our senior advocate and legal counsel for AIG Hospitals, to please join us on stage. Now I would like to invite for the welcome address Dr. Ratnakumar Natta, who is our head Department of Emergency Medicine at AIG Hospitals, to please address the gathering.
Respected dignitaries on the stage, Mr. Sajjana sir, thank you for accepting our invitation and gracing this event. Our beloved chairman, DNR sir, our vice chairman sir, PVS Raju sir, our director sir, G.V. Rao sir, and Ajay Mishra sir, and Vishwajanani madam. A warm welcome to all of you. Thank you for gracing this occasion. When we thought of doing this legal pulse, when we met chairman sir, like we have this idea sir, because this is the first of a kind we want to address, because there are many physicians in India, all over the world, but we know what to do and we know maybe what not to do, but what are the protections we have, what we ought not to do, we are not clear. So we just want to emphasize a day session in that, throwing some light. I won't say that we will be clear on this, but at least we will try to start throwing some light on the thing, because it's not only for emergency physicians, it's for everybody who is in the medical practice. In one day or the other, they will enter the court steps and they have to face some or the other legal issues. If not me, my colleague, my brother, or somebody else. So today we want to emphasize that, and thank you for coming and gracing this occasion. Thank you so much. Now I would like our chief guest, Sajjana sir, to give away some light on this. Sorry, we will start with lamp lighting, and after that, Sajjana sir will give away the words.
Thank you. I would now like to request our chairman, Padma Vibhushan, Dr. Nageshwar Reddy Garu, to please come and address the gathering.
Good morning, everybody. On behalf of the AIG all the administration. I'd like to thank all of you for being here this morning, and especially our guests this morning, Mr. Sajjanar, Mr. Ajay Mishra, and Vishwajanini Madam, for gracing this occasion. One of the most difficult departments to work in AIG or any hospital is the emergency medicine department. I think we are confronted with patients who are very sick. You have to make decisions which are very important, and you don't have much time. You don't have much help with diagnostics because the patient is just coming in. In addition, you also have to face relatives who are very anxious, sometimes hostile, and of course, legality comes in very importantly. So with all this, I think working in emergency department is a job which is not so easy even for a very balanced doctors. So at this point, I'd like to thank the Department of Emergency Medicine at AIG, Ratna and his team, for I think not only creating an extraordinary department, but what I believe is the best emergency department in the city. In fact, AIG, because of the large number of specialties it has, because it attracts patients from all over the country and around the country, gets in patients who are very sick, very complex problems and so on. Sometimes the demand on the emergency medicine team is very high, yet they are coping up with this. They are doing a great job. In fact, emergency is a window to a hospital, and of course the window becomes extremely important for what I think the patient and relatives think further of the hospital. The problem also is that very often we are dealt with issues which have implications which are not very clear legal. For example, legality and morality don't come together. Morality may not be legal, or what is legal may not be moral. So these issues are things that are going to discuss this whole day during these procedures, and I hope it clarifies some of the issues, because I think when we face these problems which is beyond medicine, it sometimes becomes frustrating for us, because as doctors we feel that we're being unnaturally aimed at. For example, like consumer court doesn't apply to lawyers or judges and so on. Why doctors are being targeted? So these sort of things come in. 90 or maybe 95% of the doctors sir, actually are very law-abiding, and not only that, they have a true intention of treating the patients. But sometimes medicine is beyond what happens normally. Biological sciences have a lot of variability. So therefore, the consequences of what we do may not actually reflect what we want to do. These differences are there, and I think this has to be accepted. Unfortunately, the trust between the doctor and society has come down quite a lot. I mean, remarkably down. Since 40 years back when I was practicing medicine, a patient would come to me sometimes when I'm stuck with some case, wait for hours together, and when you see him and apologize, he'd say, "Don't worry, doctor, you're saving a life, so that's okay." But now a patient comes to me, if an appointment is given at 9:30, I see him at 9:35, he says, 5 minutes of my time is wasted, you think you're the only important person, I have a lot of work to. So this attitude has changed, and part of the reason, of course, is the whole society has changed, but also I think as doctors, we have to change in terms of communication skills. As Mr. Ajay Mishra rightly pointed out, also very diplomatically, that our communication skills are somewhere not as good as it should be. I think in addition to being good doctors, we have to be good communicators, and this is one of the ways of how we can solve this problem. Of course, legal issues are also there, but I think to a large extent, I feel a lot of our problems can be solved with good communication. And once we have this, we can resolve many of the issues that are going to be discussed today. Once again, I'd like to thank the Department of Emergency Medicine and also all our guests for being with us today. Thank you very much.
Thank you, sir. I would now like to request our chief guest, our very distinguished chief guest, Sri V.C. Sajjanar Garu, IPS, who is the managing director, who's currently the managing director of the Telangana State Road Transport Corporation and formerly was the additional director general of the Police of Telangana. I don't think sir needs much introduction. We all know him to be the messiah to the common man and a menace to the criminal. And with this, I would like to thank sir for being with us today, and I would welcome him to address us.
గౌరవనీయులైన పెద్దలు పద్మ విభూషణ్ డాక్టర్ నాగేశ్వరరెడ్డి సార్, చైర్మన్ ఏఐజీ హాస్పిటల్స్, శ్రీ పివిఎస్ రాజు సార్, వైస్ చైర్మన్ ఏఐజీ హాస్పిటల్స్, అజయ్ మిశ్రా సార్, రిటైర్డ్ ఐఏఎస్ ఆఫీసర్, డాక్టర్ జీవీ రావు సార్, Director AIG Hospital, Advocate Vishwajanini Madam, Sharat Chandra Upuluri, Consultant Emergency Medicines, AIG Hospital and Organizing Secretary, Dr. Ratnakumar Natta, Head of the Department, Emergency Medicine, AIG Hospitals and Organizing Chairmen, esteemed doctors, legal experts, distinguished guests, good morning to you all. Andarki peru namaskaralu. First of all, I thank the management of AIG for inviting me to speak today. Also take this opportunity to appreciate the management of AIG Hospital and especially the emergency department for organizing this unique conference CME session. I think nowhere in the country, I think this issue has been flagged, sir. I think as you said correctly, Ajay Mishra sir also said, told a lot of facts that doctors are always at the receiving end, and mostly it is at the emergency medicine doctors, because they are, the people who come to them are not at all happy, they are under trauma, they are under stress and all. So I think this conference will definitely pave a long way to reforms in the country and in the state. Also feel it's a great privilege to stand before you today at this remarkable gathering that brings together two vital pillars of society, that is the medicine and law. The team is also the code law, the legal pulse of emergency medicine is not only timely but essential in ensuring that the medical practitioners can perform their duties effectively while upholding the legal and ethical standards that govern emergency healthcare. Emergency medicine is one of the most critical and demanding fields of the healthcare. It's a very, very high pressure environment where doctors and healthcare professionals have to take immediate decision that could mean the difference between life and death. However, with the growing complexity of medical practices, the legal implications have also become an inseparable part of emergency medical services. As the head of the department was telling that one or the other day, the doctor has to face some or the other legal complications. I think time is up that we all have to know what is law, what are our rights and all. The rising violence against the healthcare professionals and doctors is a very, very growing concern. Almost last 25 years I've been working in the state of erstwhile Andhra Pradesh and Telangana. I've seen number of attacks on the doctors. It is said that the healthcare professionals and the doctors are 5 times more likely to experience workplace violence when compared to other industries. When compared to other industries, we are more vulnerable almost 5 times. Number of cases have been reported all over the country, including the AP and Telangana state during the last 2 decades. Recently, we had an incident at Peddapalli, we had an incident at Gandhi Hospital, where a pediatrician was assaulted. In Andhra Pradesh, we had assault on a doctor in Vijayawada Siddhartha Hospital, and Tirupati, we had in Sri Venkateshwara Institute of Medical Science also there was an assault. So day in and out we see number of assaults happening in our state as well as in the neighboring states. Even though many states have attempted, but it is only 19 states have some or the other protection. The Medicare Services Persons and Medicare Service Institutions Prevention of Violence and Damage or Loss of Property Acts passed and notified in the last 10 years. Even though Ajay Mishra sir has already told about many facts about the act and all, it's unfortunate that even though number of acts have been done, but it has not curbed the violence. Unfortunately, in 2019, the central government made a draft law, a central law, but not made into an act till date. I think doctors like Nageshwar Reddy sir and other medical associations should pursue and should have a central act which can be very, very stringent, which has more teeth also. In Telangana and AP, sir has already told that in 2008, we got an act when a doctor got assaulted in the government maternity hospital in Koti, Hyderabad. There was a huge hue and cry in the state. So the then Chief Minister Dr. Y.S. Rajshekhar Reddy and his government bought an act called as the Medicare Service Persons and Medicare Service Institutions Prevention of Violence and Damage to Property Act 2008. Even though the act has been bought, but the enforcement is a worrisome factor, and the punishment is also very, very less. It's almost about only 3 years and with a fine of 50,000 and some recovery provisions. I think this also has to be looked so that more stringent action can be taken against the accused who are assaulting the doctors. Ajay Mishra sir also told, and Dr. Nageshwari sir also told, that the poor communication is one of the main cause for the violence. I think the doctor has to spend more time with the attendants. That's one of the main cause of violence. The other reasons are the patient frustration, low health illiteracy, poor communication, lack of security. Small and medium healthcare establishments are the main targets, and also because of now lot of political activities there, more political parties, more people, they try to take their pound of flesh, so lot of people also do try to take advantage of the situation. So this violence has led to lot of stress, burnout and reduced morale among the medical professionals, and ultimately affecting the healthcare services. So apart from the above act, we have the BNS Act, the Clinical Establishment Act and other acts also. But I think there is need for more stronger action, then only we can curb the violence against the doctors. Even though cases have been booked against the accused all over the state and all over the country, but no serious action or the follow-up is done about the cases, and many a time, even though police make lot of efforts, but ultimately the doctors and the management or the attendants come to a compromise situation, and many times cases also fail in the court. I have seen this is happening in almost last 25 years, sir. Because I worked in almost 5 districts of Andhra Pradesh and Telangana, and also in Cyberabad. The initial, there will be a lot of saying that action should be taken against the accused by the management, by the doctors and the persons who has been assaulted. But after a few days, when we slowly realize that they already agreed with a compromise and they don't want to follow up the case, which is not a good thing. I think some awareness has to be brought among the doctors, among the association, that at any cost this compromise should not happen. Because this I have been advocating wherever I go. Because once compromise is done, the case becomes weak and there is no deterrence among the accused also. I think we should not. Also, I request the doctors also not to overreach. Many times I see that doctors try to experiment and all, so that also lead to a lot of violence and all. So I think doctors have to follow the protocol. Whatever is said, that has to be followed, and they have to be treated. The patient has to be treated as per the existing procedures and within their own capability and experience, and they should not experiment. Many times I think they try to do a lot of experiment, and nowadays fortunately or unfortunately we have Google Baba with all the patients, with all the public. They immediately, before coming to the emergency medicine or before meeting the doctors, they always Google Baba and try to know what's the medicine, what is the prevention, and if there is something they try to show to the doctor, sir, Google Baba is telling this way, why are you treating this way? So I think that is one major concern. I think this also has to be educated on the public, that whatever is told in the social media or in the Google or in all the website, it's not true. I think some awareness has to be brought. That's what because we have a low health illiteracy in the country, in the state, I think this awareness has to be brought. I think another thing is that we should have a proper communication, and consent is also important, and the consent has to be explained in detail. Nowadays most of the hospitals I have seen that they are following it, but whatever has been told in the consent form, the same procedure has to be followed so that there is no deviation. And another important is the documentation. Many of the doctors are good doctors, they are very, very well known and all, but when it comes to documentation, they are very, very poor. I think whenever there is a violence, police officers, when we try to collect all the evidence, we see lot of gaps in the treatment and what has been told and all. So I think that also documentation, that's what Ajay Mishra sir told about the soft skills, whether it is training, communication skills or the documentation. I think it has to be told to the doctors, because records, ultimately when the case is registered, the records are seized by us, by the police. And I think the hospitals like AIG and IMA and other medical associations should take up some awareness sessions on documentation, so that all the doctors will be aware. And also, the violence doesn't happen at a spurt of a moment. There will be definitely early signs. I think each doctor and around him, the healthcare professionals and especially the security staff should keep on looking for the early signs. So I think each and every hospital should have a small vigilance team. It's with already, because they have a good security system, they should have a small vigilance team. Whenever there are some complicated cases or where complicated persons are to be dealt, I think small vigilance teams can shadow these people. They can know what's happening with them, what is the murmuring happening. So that will definitely help in prevention of the assault. And also we should have adequate security. We have seen that many a times the emergency medicine or there is not adequate security. I think that also has to be taken care. And CCTV surveillance. I think most of the hospitals nowadays have CCTV surveillance, but the monitoring of CCTV surveillance is not done. So I think some command and control room can be established in the hospital, like AIG can have a command and control room, and once in a while they can check all the CCTVs and also know who are the people who are going to create some litigation and all. I think important is to remember the stamp. The stamp is nothing but staring and eye contact. Most of these people who are there, who try to assault, they'll be always trying to have a very, very staring thing, and tone and volume of the voice. Many times these people, they talk in very, very high volume, anxiety, mumbling and pacing. So I think doctors should and the security staff should look for this stamp and also these indicators. I think also we should have a detailed SOP if there is in case of unfortunately there is a violence. I think there should be a detailed SOP with all the management and with all the doctors and with all the departments. And now and then also I think we should not have, but to be ready for the situation, we should have mock drills in all the hospitals, and all the doctors also should be involved in this mock drills. I think, and also training the doctors, healthcare professionals, security staff is important. Many times we don't give too much of importance because now I am on the other side of the policing. So I am now in TGSRTC. So TGSRTC has invested very heavily in two areas, sir. One is on the training thing and also on the health thing, sir, because of the health welfare of the employees. So almost training, sir, each and every driver or conductor is trained every year, and we have almost touched million training hours in the organization because we continuously ensure that even though it's needed or not needed, what are the soft skills, how to deal with the passengers, if there is an emergency, how to deal it, and also to take care of the passengers and all who are in crisis. And also we do give training. So I think the similar thing also can be planned as a regular affair, not only when wherever there is some issue is there, rather than having continuous training has to be given to the doctors, the healthcare professionals, and also to the security staff. Most of the time the security staff are not at all aware what is happening outside, where are the incidents, what's happening, what was the details of the incident and all. I think some awareness has to be brought. I think that will go a long way in ensuring that there are no violence. And also public awareness camps, as Nageshwar Reddy sir was telling that about 40 years back there was a lot of importance to the doctors and all. Now with a lot of things happening and all, I think it has come, there was a lot of respect for the doctors. Now because of various reasons it has come down. So I think public awareness camps have to be taken up to educate the public on respecting the medical staff. I think organizations like IMA or hospitals like bigger hospitals like AIG can take the lead. Violence against the doctors is not at all good for the society. I think every doctor also should be made aware of the violence, and they should also be mentally prepared that this can happen also, and what should be made to prevent it also should be told to the doctors. I think that will go a long way. So I think this definitely, because a lot of issues will be discussed by various professionals, I think this will go a long way in preventing the assault on the doctors. Another area is where we have to look is the medico-legal cases, the MLCs. They are very, very crucial in ensuring justice while providing medical care to the victims and all. I think strong police hospital collaboration is essential for handling all cases like incidents, accidents, assaults and unexplained deaths and all. I think whenever the timely reporting, the transparent communication and proper documentation can strengthen the legal process. Most of the times we have seen that the documentation is not properly done, which is giving a lot of scope to the accused or the people who do the mistakes to take advantage. I think training healthcare professionals in this medical legal medical legal protocols and ensuring the police sensitivity towards the patients also will definitely improve the efficiency. I think special care has to be taken with the POXO cases. I think there is a separate session on the POXO cases. Unfortunately, the POXO cases have increased hugely in the state as well as in the country. I think that has become a worrisome factor for all of us. I think detailed guidelines have been issued by the Minister of Home Affairs. They can be visited on the MHA website, and you can know about it, what are the guidelines and all. I think according to the section 27 clause 2 of the POXO Act, the victim should be immediately medically examined by a lady doctor and all. Many a times we do make mistakes because of the various reasons. I think it says mandatorily, it says that it should be the victim should be handled by a lady doctor, and also handling of the victim by the police and the doctor is also very, very important. And police, we have taken a lot of steps. When I was in Cyberabad as a police commissioner, we have conducted various sessions, and we ensured that all the police are very, very sensitive towards these cases and towards the victim and all. I think apart from the investigation, the evidence collection also is very, very important, because that's only is going to lead to conviction and also will lead to a lot of deterrence. As a commissioner of police also, we ensured that a lady officer is stationed at all the courts. They were made as the liaison officers, and whenever the victim is produced before the judge or whenever there is a court proceedings are there, these liaison officers will take care of the victims and also the evidence and all. We had very, very good conviction in Narsingi when a small girl was raped and killed by a migrant labor, and ultimately that case ended in a conviction of a death sentence, which was first of its kind in the country. And also in Alwal we got a life imprisonment, and nowadays because of various reasons also judiciary also has got sensitized, and POXO cases are resulting in good conviction and all. I think there is a need to also to strengthen the collaboration and the partnership between the police and doctors. Definitely this will go a long way in helping the victims and all. I think regular coordination meetings with the doctors and the police will definitely help, and also the joint trainings. And one already Ajay Mishra, another topic is that Ajay Mishra sir has already touched about the Good Samaritan protection under the MV Amendment Act 2019. This is about the bystanders. Still there is, even though this has been bought by the central government, by the government of India, but still there are a lot of apprehension among the bystanders. We still see a lot of people not attending to these accident victims. In Cyberabad, when I was there, a small attempt was made by educating the people. Thousands of people all along the national highway, right from Shahad Nagar to Nalgonda side and Warangal side, we educated a lot of people, and they were named as the saviors. And ultimately we could also help in saving a lot of people. I think that was one good experiment. I think there is a need to ensure that bystanders are educated, and organizations, medical associations, the legal fraternity and the police should come forward, and they should make a collective attempt in ensuring that the public are made aware of this, about the Good Samaritan and also about the bystanders and all. So even though there is a lot of cases against the doctors and all, but also because there is a lot of, especially when sir has also told about the compensations against the doctors and all. That's one worrisome factor in the country. I think there are no clear-cut guidelines distinguishing between the human errors in the high pressure situations and also about the gross negligence. Because emergency medicine or any other emergency cases, there are a lot of problems will be there. There has to be test. There has to be a there has to be a difference between both the things, whether it's a error or whether it's because of the good faith and all. I think in this also, I think there's a need to have a good the clear-cut guidelines. I think Nageshwar Reddy sir, I think, can take a lead and ensure that one, and also with other medical associations, not only in the state of Telangana and Andhra Pradesh, but also in the country, to get a clear-cut guidelines so that the harassment to the doctors, otherwise they are being, as sir was telling, that they are being dragged to the consumer protection courts and all, and leading to a lot of litigation. I think this has to be taken. I think it's a very, very serious concern. Now with the technology has developed all over, and medical field is also no exception. I think now with the technology and telemedicine have also added a new dimension to the emergency health care, and the telemedicine practice guidelines issued by the Medical Council of India has also now allowed virtual consultations, including in emergency cases also. I think that's one good thing, but however, there are concerns about the patient confidentiality, electronic medical records, and also jurisdictional conflicts issues, which make it imperative for the lawmakers and healthcare professionals to stay updated and aligned. I think time is up that we all should get updated about the technology developments, what is happening all over the country and all over the world. I think so. Now, how do we bridge the gap between the law and the medicine to create a seamless legally sound emergency healthcare system? I think the answer lies in education, policy making, and collaboration. I think ultimately we have to ensure that we have a proper collaborations. I think hospitals must invest in all the training aspects, whether it's medical, legal cases or other aspects of cases or any other soft skills. I think they have to invest heavily in the training things. Some or the other training has to be given to their staff so that they'll get updated. And also the legal professionals should work very, very closely with the medical experts to draft policies that are practical and in tune with the real world challenges. Most of the time when we do bring out guidelines or when we bring out acts, when the act was initiated or the guidelines was initiated, the situation would have been different. Now, when it is bought, the situation would be definitely different. So I think we should take into consideration the real world challenges and all. I think also furthermore that the campaigns must be launched to educate the public about their rights. They have rights definitely, but there are also responsibilities in emergency healthcare scenarios. I think people should be made aware of it. I think to conclude, the code law, the legal pulse of emergency medicine is a subject that requires constant attention and refinement. As India continues to advance in healthcare and legal frameworks, it's our duty to ensure that emergency medical professionals are equipped with necessary legal knowledge to serve with confidence and integrity. I think ultimately we have to give them, because they are the first responders, I think we should give them a lot of confidence and also ensure that they work without any stress and all pain. So I think this discussion, whatever today's discussion, will be definitely a stepping stone towards the more balanced, just and efficient emergency medical system, not only in the state of Telangana, but all over the country. Sir, this is a very, very unique conference, sir. I do attend a lot of medical conferences and also interact with a lot of doctors, sir. I think this is a very, very unique conference, sir. I appreciate the emergency department for taking this initiative. I think first of its kind now, because you have involved all police officials, the lawyers, the doctors, administrators, and others also. I think NGOs like Arun is also there. I think so. I think a lot of people are involved. I think we should come out with some policies, sir, and I think you should take a lead to meet the government and take it forward, sir. And if you require any help, I am there always to assist you, sir. So, and also we can frame some guidelines, sir, so that I'll also follow up with the government, sir, and ensure that some clear-cut guidelines are brought to save the doctor, sir. So I once again thank Dr. Nageshwar Reddy, sir, and Dr. G.V. Rao, sir, and Sri Raju, sir, for calling me and inviting me and for giving this opportunity to share my views. Thank you all. Jai Hind.
Thank you very much, sir, for all of your insights. We were looking forward to seeing you and hearing from you today, and I think all of us are just so very happy to have you with us today. Thank you so much again for being with us today. And we are, in fact, having a whole workshop on documentation, like sir was mentioning, and we have this entire agenda. I'm sure all of you have a copy of this brochure with you. We have it all planned, and we really hope to meet everything that sir has mentioned today. I would like to now request our chairman DNR Sir Garu and our vice chairman Raju Sir Garu and our director GV Rao Sir Garu to please present our chief guest with a memento. Thank you, sir. Thank you. I would like to brief our audience today with a gist of what is planned for the day. We will now move on to our speakers. We have 4 very interesting talks lined up. And apart from that, we would have a panel discussion, which I think most of you and we too are looking forward to. And apart from that, to the end, the post-lunch sessions would include 2 interactive discussions, with one of them being a documentation workshop and the other being a mock courtroom testimony. And we sincerely hope all of you would stay till the end, because this CME was curated with a lot of enthusiasm and a lot of fervor, and we only hope this will be the first of many such events to take place, where we bring together a lot of collaborate doctors, lawyers, the law enforcers, the lawmakers, and also the common man, to bridge the differences between all of us, and so that we all can enjoy a good healthcare system. To invite our first speaker of the day to talk about something very pertinent. Doctors are there to save lives, but who saves them? It gives me immense pleasure to invite our very first speaker for the day, Srimati Vishwajanani Garu. Madam is a senior advocate and a legal counsel for our hospital here at AIG Hospitals. Madam is a postgraduate in law from Osmania University, and she's been practicing in the courts of Telangana over 35 years. And she comes with a very vast experience in different fields. Madam is very vocal on women and children related problems and has been on the forefront to resolve their issues. Today, it's even more special because she's associated with several hospitals and is handling medical negligence too. Madam, I invite you to give us our first talk. Thank you so much for being with us today.
ఇక్కడ లైట్ లేదా పైన లేదా ఓకే Dear doctors, good morning to all of you. Today the topic given to me was medical negligence, balancing care, accountability and justice. I'll start with the quote of Justice Lahoti, who was the former Chief Justice of India, who has said, medical profession is one of the oldest professions of the world and is the most humanitarian one. There is no better service than to serve the suffering, wounded and the sick. Inherent in the concept of any profession is a code of conduct containing the basic ethics that underline the moral values that govern the professional practice and is aimed at upholding its dignity. Medical ethics underlines the values at the heart of the practitioner-client relationship. It must always be kept in mind that a doctor is in a noble profession and their aim must be to serve humanity. So also it was held in Martin D'Souza's case that court observed that uncalled for proceedings for medical negligence can have adverse impact on access to health. While action for negligence can certainly be maintained, there should be no harassment of doctors merely because the treatment was unsuccessful. So it is not that courts have been against doctors or adverse opinions, orders have been passed against doctors. With vast experience of 35 years and being a practicing advocate, I will detail to you in a simple language and practical language so that a doctor does not fear when he faces a crisis. Now, it was an honor when Dr. Nitya has said, we save patients and advocates save doctors. It was a real nice feeling, and true to it, today we will guide you and show you how you can save yourself. In fact, being an advocate, I am disclosing all the secrets of court so that you will be in the process, you will be reducing the workload on police, on advocates, and ultimately on the courts. The burden will be reduced on all these three. only then you are saved from your liability. Now here, first of all, let me tell you what is medical negligence. What is medical negligence as defined? Now here, the correct definition one of the quotes has given is, medical negligence is improper using of unskilled treatment of a patient. The first point is improper, unskilled treatment rendered to a patient by a qualified medical practitioner, causing injury to a patient, and patient suffers because of this. I hope you have got it. It is an improper, unskilled treatment by a qualified medical practitioner wherein a patient you cause an injury to the patient and patient suffers because of this injury. Only then it can be termed as medical negligence. Not all treatments are tainted or termed as medical negligence. It is only when you fall short of that reasonable medical care, or when there is a breach of that defined specific medical care, only then it can be termed as a medical negligence care. Now, what are the legal consequences of medical negligence? It can be a criminal liability, it can be a civil liability, it can be a disciplinary action. Now, criminal liability, the earlier speakers have spoken at length talking about criminal liability. It is when a doctor is criminally made liable for a negligent act which is performed with mens rea, that is a guilty mind. Only then a doctor can be implicated for a criminal offense. Now here a balance has to be maintained between protection, safeguarding medical practitioners, and mind you, when the doctor fails to act in accordance with the standard duty of care expected of him, reasonably expected of him, when he fails in that duty, only then it can be termed as criminal liability. Now, as you were talking about emergency medicine, now minor errors or honest mistakes to save the life of a patient in complex cases cannot be termed as medical negligence. Courts have always come to the rescue of doctors when there are such instances. Immunity is provided to medical professionals, especially in emergency situations when you act in good faith. Now, the only saddest part is these provisions of law are equated or on par with the accident cases. You have where acts endangering the life or personal safety of others, causing harm, causing grievous hurt, causing death by negligent act. All these can be termed as criminal liability. Now, what is the procedure for initiating a criminal liability? A patient can lodge a complaint. Now, I am talking all about practical aspects for you to understand. When there is a violence or vandalism, a patient can lodge a criminal complaint against a doctor that the treatment rendered to him had not been effective and proper. He had not exercised reasonable care and due diligence in treating the patient. Now, and first thing is he will lodge a complaint in the police station. Please do not panic. There is nothing to panic about that situation, because police has to issue notices and investigate the offense or the crime which you have been accused of. And it is only when, as I have said, if you can prove that you have exercised reasonable care, there is nothing to fear. And a precondition, I am repeating, the precondition to initiate a criminal liability is the team of medical experts have to certify that there has been a breach of duty and that you have not acted in good faith. Only then criminal liability will be fastened against a doctor. So not all complaints which are registered and lodged against a doctor are going to be punished, or you are not going to be criminally intimidated because of that. Criminal intimidation might be there, but you will not be convicted of it. You can always prove your innocence and be acquitted out of the case. Your panic, your lack of legal awareness, lack of knowledge only causes half of the problems. And I've heard of some of the cases in the recent past also. The moment a complaint is lodged, some of them doctors have even committed suicides, panicking that something has gone wrong. Please do, there's nothing to fear. As I have said, when police has to investigate, police has to charge sheet you, then a trial will be conducted, and prior to all this, the precondition is a team of medical doctors have to certify that there has been a medical negligence, there has been a breach of duty, there has been a reasonable care has not been exercised in discharge of your duty. Now, very rarely cases get convicted unless we fail in our duty in seeing that, providing all the material to the police, to the court. Now, civil liability, the often used means for a patient is civil liability, where they can claim compensation. Now, this is where medical negligence cases come. Under Consumer Protection Act, most of the cases we see are lodged under Consumer Protection Act, and they try to, as Sir was talking about it, 6 crores was the compensation, and with interest it went up to 12 crores. So they get a huge compensation, and therefore they choose to prefer filing a civil liability before a consumer commission. Now, the patient himself can file the complaint, or any of his attendants or legal heirs in case of a death of a patient. Now, what is the procedure to file a complaint? A patient can pay a nominal fee, where for a 1 crore claim, he can pay a fee of 2,000 rupees and initiate proceedings against a doctor in a criminal court. The moment a complaint is lodged in a consumer court, it is registered and notice is issued to the doctor. Again, there is nothing to fear as long as you have an advocate. So, the moment you, I see some of them worrying that, oh, we have to approach a advocate. Yes, these are all unavoidable situations, rare situations. So, the moment you receive notice, kindly approach your doctor, your advocate, and give your para-wise remarks to the advocate to ensure that a written reply is filed by the advocate. A written reply within time is mandatory and most important for your case. Prepare whatever notes you have, because your knowledge, you are the first person. Neither the advocate nor the police nor the court is equipped or well versed in medical field like you. It is you who has to feed with the material to the advocates, and a written reply is filed. The moment a written reply is filed, then notices, then the next step would be filing of evidence affidavits. During that time, the documents in your custody have to be filed before the court. Now, the documents, I mean case sheet and other material, whatever you have, and complete the case sheet, entire case sheet, the treatment, the nursing notes, the doctor's notes, everything. Please ensure that everything is in proper and it is filed into the court. Now, there are chances of the other side, that is the patient's counsel, cross-examining you. Here again, I would suggest there is nothing to fear. Stick to the truth and the treatment rendered by you. Once you stick to the truth and the treatment rendered by you, definitely you can come out without any issues. Now, after that, then there will be arguments and judgments are delivered. Now, here judgments are delivered, I repeat once again, basing on the notes, para-wise remarks, that is the written reply given by you, the evidence, that is the document part which you are going to supply to the advocates, and third is, and the most important is, the medical literature which you have. Now, medical literature also plays a crucial role, because earlier speakers had said there are 2 schools of thought for 1 line of treatment. Now, what is reasonable line of treatment which you have followed? Because all treatments cannot be followed for all patients. You will have your own reason and rationale and judgment for treating that particular patient. Ensure that particular treatment and is recorded and there in the medical literature. If you can provide us with that, there is nothing stopping you, and no compensations also can be fastened against doctors. Now, the third is disciplinary action. Indian Medical Council, and we have our state, Telangana State Medical Council, which also a complaint can be registered with them, and complaint is registered, and they are actually here to prescribe standards of professional conduct and code of ethics, and they can initiate disciplinary action against you, wherein if it is proved, the name of the practitioner can be removed forever or suspended for some time. Now, the procedure here also is a similar procedure where a complaint is lodged before the TSMC, and then like a regular court, a trial is conducted. Even an advocate can assist you. Trial cross-examination also is done by a team of doctors, committee who sits there, and then they decide, pass an order like in any other civil court cases. So these are the three modes and means by which a liability can be fastened against you. And in all the three, there are, as I told you, criminal liability, there is nothing to worry because a committee has to certify. Civil liability, if you are clear with your para-wise remarks, with your documents and literature, nothing can stop you. So also in case of a TSMC or any other disciplinary committee. Now, what are the instances of medical negligence? Now, what constitutes a medical negligence is wrong diagnosis. Wrong diagnosis can always be termed as a medical negligence. Now, here, as I was talking, as told the earlier speakers have spoken, there might be two schools of thought for the same treatment, but you should be in a position to show that the treatment which you have rendered to the patient was a reasonable and applicable, apt treatment for the patient at that point of time. In one of the cases, I'll tell you, this is Dr. Chandra Rani case, where it was in 2009, Supreme Court has held, in the practice of medicine, there could be varying approaches of treatment. There could be a genuine difference of opinion. However, while adopting a course of treatment, the duty is cast upon the medical practitioner is that he must ensure that the medical protocol being followed by him is to the best of his skill and will with competence at his command. At the given time, medical practitioner would be liable only where his conduct fell below that of the standard of a reasonable competence practitioner in his field. Even death of a patient cannot on the face of it be considered as a medical negligence. So your duty, a heavy duty is cast upon you to take a decision at the appropriate right time. There is another one case also where for a typhoid patient, he was treated for malaria. Such wrong diagnosis, it might take a little time. So investigations and all reports, everything has to be looked into and taken care, and treatment should be aptly and appropriately conducted. Now, delay in diagnosis, this also can cause where you don't get a doctor's appointment, not availability of beds, or some other issues also constitutes medical negligence. Error in surgery. When you conduct an error in surgery, as I have said, two thoughts of treatment is different issue. But you conduct, now here there was a case where a gynecologist was to conduct a surgery, but when she opened the uterus, she found it frozen and informed her immediate family and conducted hysterectomy. The doctor conducted a hysterectomy. Court held that surgery could have been done later with informed consent of patient, as she was a major, and granted compensation to the patient. That is, a surgery could have been delayed. Her consent, because she is a major, and it was a major decision, removal of the uterus, hysterectomy. So therefore, her consent was mandatory, and court granted compensation to the family of the patient. Courts also have held, while performing an operation, in another case, this is Neha Kumari's case, where they have said the child she was a 4-year-old child, where she was complaining of, she had birth defects of spine and whole body as evidenced by a pre-operative CT scan. While performing an operation on the spinal canal, a rod was fitted inappropriately at the wrong level, resulting in non-functioning of the lower limb of that little child. Now, what the courts have held is, we do not find it as a case of medical negligence as alleged. Complaints have not denied that the patient was suffering from ailments from the very birth and that she was operated upon when she was only 4 years old child. And on detailed investigation, it was found that she had multiple congenital complicated problems. So therefore, the opinion taken by the court is rational, and it is your duty to ensure that there is no breach of duty or care by you. Now, leaving any unnecessary object in the body of a patient, such as sponge, bandage, scissors, etc. Many a times I've heard doctors saying it is the duty of the nurses. They count, I was told in one of our cases that swabs and all are counted by the nurses, and they have to give a report. But I think supervision also is mandatory, because in one case it was held the deficiency in service may be due to obvious faults which can be easily established, such as removal of the wrong limb or the performance of the operation on the wrong patient, or giving injection of a drug to which patient is allergic without looking into the outpatient containing the warning, or use of wrong gas during the course of an anesthetic, or leaving inside the patient swabs or other items, and doctor was held liable. So a ribbon gauze was left behind in a septoplasty surgery, and there also the doctor was held liable for leaving behind an object in the body of the patient. Now, error in administration of anesthesia, improper administration of medicines, long-term negligent treatment without looking into the secondary infections. So, as you all are aware, steroids, for example, steroids have to be tapered, and they have to be taken care of by the doctors. Now, if they are not tapered and they are used for a long time continuously with the same dosage, also can cause lot of secondary infections or side effects, whatever you call them. So that also will lead to constitutes medical negligence. Now, a medical professional can be held liable for negligence if they do not have the required qualifications or skills. You might be specialized or competent to treat a particular patient, and when you use that competence to treat another patient, then also it amounts to medical negligence. And also, one incident where we have recently come across is a doctor graduating from Russia has started practicing in India. Now, he claims to have registered, but it was later found that he was not registered. And secondly, whenever you carry your degree, it is mandatory for you to write your qualification and your university, because you are coming from outside. And that if you fail to do, also amounts to medical negligence. And the test to ascertain or assess these kind of medical negligence, the Queen's Bench has held in the case of Bolam versus Frian Hospital Management. It is it's a landmark judgment and called as Bolam's test, wherein you get a situation which involves the use of some special skill or competence. Then the test as to whether there has been or negligence or not is not the test of the man on top of the Clapham omnibus, because he has not got this special skill. The test is the standard of ordinary skilled man exercising and professing to have the special skill. Now, that is important here. I think you should get it. The test is the standard of ordinary skilled man exercising and professing to have the special skill. And a man need not possess the highest expert skill. It is well-established law that is sufficient if he is exercising the ordinary skill of an ordinary competent man exercising in that particular art. Now, the next point is, a doctor does not obtain an accurate medical history which can also lead to misdiagnosis and treatmental errors. So previous surgery and ongoing medical conditions that could have affected the outcome of the treatment have to be noted by the doctors. Now the last is, a doctor does not follow up with the patient after the initial treatment or surgery. If not, so your time constraint or for any other reasons, if you are unable to follow up with the patient, ensure that an equally capable, competent, qualified person is taking care of the follow up of the patient. Otherwise, it also amounts to medical negligence. Now, what are the instances which do not constitute medical negligence? Now, unavoidable complications, as we have first said, if you had a congenital birth problems, complex issues, then there are risks with the treatment. So, unavoidable complications are a known risk of certain treatment. Now, here I'll read out one case. A woman had undergone a sterilization operation and she became pregnant and delivered a child. The operating surgeon or his employer cannot be held liable. The courts have clearly said they cannot be held liable for payment of compensation on account of unwanted pregnancy. Now, the claim is sought insustainable only if there was negligence on the part of the surgeon in performance of a surgery. Cause of failure operation may be obtained. It is what is required is evidence. Here the evidence was obtained from laparoscopic inspection of the uterine tubes by an X-ray examination or by a pathological examination of the material removed at a subsequent stage of re-sterilization. So if you have sufficient proof and evidence, it does not amount to medical negligence. Informed consent. Now, consent, we say, we take it in a casual manner in an English format. Now, here, of course, most of the hospitals are now having Telugu also, but that is not sufficient. Here, especially, you get patients from all over the country. So, what is important is you must ensure that patient's capacity to understand the information is relevant. In his own language, in his native language is important. Either you have a translator or otherwise, and ensure that whatever consent you are obtaining is conveyed to them in their local language and not in a casual manner, taking the consent form in an English form which they do not understand. They will say that whatever they have asked me in that emergency situation, I have signed. That is not going to solve the problem of a doctor. So consent should be obtained in a proper and authentic manner, which is understood by the patient. The language you are using, the format you are prescribing should be understood in the local language of the patient whom you are treating. Now, errors of judgment. A healthcare provider provides the skill of medical practitioner differs from doctor to doctor. As I have said, if there might be two schools of thought for the same treatment, but you should ensure that you have used the reasonably best treatment for the patient which was necessary and required at that point of time. Patient non-compliance. Sometimes patients leave against medical advice. So ensure that you make a record of it properly, and your record is kept in a proper manner. Hospital or equipment failures. We had some issues where during COVID time and prior to that also, where some of the systems fail at that particular time, oxygen failure or whatever. That also has to be recorded and noted properly, so that there will be a proper record of what is happening and what is going on, and so that once it is recorded, that also you cannot attribute it for medical negligence. Pre-existing conditions. Now, pre-existing conditions are very important for you to note. You have to ensure that patient informs, and especially when in an emergency situation they come without any record. They are there with just bringing the patient to you. So here it is your duty again to ensure and elicit information from the patient or their known persons. If you are unable to, make a record and note the reasons for not being able to get information as required by you. That is very important. Now, surgical risks. So, as I have told, there might be some inherent risks in the procedures conducted by you. Now, role of an expert opinion. wherever the courts have held, there may be in one of the cases the court held that this is called a Farangi Lal Muneja case, where the OP conducted, that is the doctor conducted an eye operation upon the complainant. The cornea was damaged subsequently and visibility was lost. The complainant alleged that proper dilation of an eye was not done before conducting the cataract operation. Also, it was alleged that the operation was done in a hurried manner. Patient does not know the need and emergency in which you have conducted the surgery. At that point of time, because of the situation of the patient or whatever it is, the family goes through stress and they make all sorts of allegations. So it is your duty to ensure that everything is recorded, and it will be referred to an expert committee. Expert committee has opined that it was properly conducted and it is not that it was done in a hurried manner, and the claim of the patient was dismissed by the court. Medical literature, as I have said, medical literature forms a major part, because as we have said, for every treatment that you render, if there is a litigation, ensure that the literature is in place. Now, quantum of compensation, as we discussed earlier, has now, it is not small compensation, it is running in from lakhs, it has now shifted to crores of rupees. So we all need to be careful about the drafting and documentation. Engaging a specialist when available is obligatory. Some of the patients always complain that 2 or 3 specialists, now recently we were informed that a senior person was admitted to the hospital. Apart from the knee surgery, apart from his knee, his cardiac, pulmonologist and several other doctors' consultation also was mandated for that patient and his condition. But somehow it was not taken, and it has become a major issue because engaging a specialist when available and taking their opinion of all the doctors, all the consultants also becomes mandatory. Now, vicarious liability of hospital. Hospital is of course taking care of all the doctors because I can vouch for it and say we are defending most of the cases. Now, one complaint can cause panic to the doctors. Now, you can be rid of this panic if you are able to take care a few of the precautions which we are going to suggest today. These precautions will help you to overcome your fears and overcome the crisis or the violence which you are facing with your patients while treating your patients. Now, most of the doctors say we treat about 100 to 200 patients per day, and it is very difficult for us to make a note of all the patients, and some things might miss our view. But let me tell you, when there is a crisis, neither police nor an advocate nor a court can protect you unless your documentation, your notings are proper. Unless their record is proper, fully explained, none of them can protect you. So it is only your records and your documentation which will help you out. Now, first of all is the case sheet. First and foremost, case sheet is the Bhagavad Gita, Bible and Quran for you. I put it to you that way, because the case sheet speaks all the facts, discloses all the facts, the treatment given by you, the treatment, the medication, the nursing staff, the doctor's notes, everything, day to day. In fact, hour to hour or 2 hours or 3 hours also there are notings which will help you get over this issue. Now, but unfortunately, some of the case sheets we see, there is overwriting, there is scribbling on the case sheet. Please do not do that, because that amounts to tampering, and then again defending you at the court becomes very difficult. So ensure that whatever you write is applicable for that day. If you do not want that, strike it out, put your initial and write whatever you want to write on the next date of hearing. But striking out too many things and over it writing and then not putting your initial also will cause lot of problems. Signatures must be done properly. Then investigation reports also must be recorded. You write your vitals. Sometimes the investigation reports are not from your hospital. They come from outside. Please make a note from where you are looking into those documentation, unless you suggest for another report. Now, the present medical condition of the patient, expected procedures and treatment, probable time for recovery, chances of success of surgery, and as expected costs also can be incorporated. Now, there was a case where the nurses were supposed to check the vitals, and they have checked the vitals at 9:30 and they have written the time at 10 a.m. Patient died in between this time, and you have handed over the case sheet. So all such things, and whoever is there handing over the documentation to the patient, please ensure that you take care. Now, in case of detecting a foreign body, it must be sent to the, I'll wind up, okay. The consent form, family member counseling, audio video recording of the patients, then patient's leave against medical advice. Now here, all these results of investigation, I think communication skills are also very important, and as suggested by previous speakers also, proper presentation and compilation, and we have also said advising for a second opinion is also, you can always suggest, because when there are some complicated surgeries which involve huge costs, and when they involve 40 to 50 lakhs for a surgery, and at that point of time, they are already approach, but you also suggesting would also make a little difference for the patient, saying that we have obtained a second opinion and we have come to the patient. And the cause of death, please note it properly as it is noted in the GHMC records. So I put it to you at finally, deviation from normal practice is not necessarily evidence of negligence. To establish liability on the basis, it must be shown that there is a usual and normal practice, and doctor has not adopted that procedure, that the course in fact adopted is one no professional man of ordinary skill would have adopted. Only then it constitutes medical negligence. So therefore, doctors must remember, doctors have, Supreme Court has clearly held, doctors are not immune from legal clutches proceedings in the event of their negligence in discharge of their professional duties. However, it is also necessary to protect them from frivolous and unjust prosecution. So trust me, you are always safe provided you exercise the reasonable care and due diligence. Now, post AIG Hospital Kolkata case, the Honorable Supreme Court in August 2024 has formulated protocols for improving safety and working conditions of medical professionals and constituted National Task Force, and it is our state's privilege and honor that we have Dr. Nageshwar Reddy Garu as one of its members, and you are all aware that interim report has been filed, and yet we are waiting for the further action. So as advocates, these are the practical steps which we would require you to ensure before you go through the treatment of the patient, so that our work is also reduced, and at the same time you are also immune to any liability. Thank you. I'm sorry for it.
Thank you very much, ma'am. I would like to request Sri Ajay Mishra Garu to please come forward to present a memento to our speaker. Thank you, ma'am, for all your valuable insights. It was a truly insightful session, and this is something that we face almost every day. Thank you so much, ma'am. Moving on to our next talk, and this is a very interesting session that we have, which it is a harsh reality where awareness isn't just important, but it's a reality and it's a responsibility. So, speaking about sexual assault and child abuse and the POCSO Act, we have with us Mahinder Reddy sir, who is a professor and head of forensic medicine at RVM Institute of Medical Sciences here with us today. I invite sir to please address the gathering. And sir is an MD forensic medicine from Osmania Medical College, and he's had a very, very illustrious career teaching and training UGs, PGs in Osmania and Gandhi Medical College. Like you can see all of these on the screen here. Sir has been associated with the Kamaneni group both at Narkatpalli and LB Nagar, holding positions such as professor, group director and CEO for over 18 years. Sir is also a NAC assessor, and he's been on the ethical committee of the TSMC for 5 years. Sir teaches not only doctors, but he also teaches at the Telangana State Police Academy, the National Police Academy, and the Judicial Academy. And sir is a medical legal consultant, and he's also edited the 36th edition of the textbook that most of us sitting here would have used in our UG for forensic medicine. And with this, I take the honor and the privilege of inviting Dr. T. Mahinder Reddy Sir Garu onto the stage to address the gathering.
Good afternoon. I would definitely acknowledge this institution, AIG, and the EMD department for taking up one of the most crucial, sensitive, and emotive subject, that is sexual assault and child abuse. We go back to the sexual violence, but today we term it as sexual assault. It's a violation of a woman's bodily integrity, and therefore we call it as an abuse of their fundamental rights. Yeah, in the meanwhile, I think I'll go by the statistics first before I have this slide. 30% of women, adult women worldwide, have experienced physical or sexual violence by a partner or by a non-partner. 5% of adult population, women, has been a victim of severe sexual abuse. I'm sorry, there has been a small technical glitch in my presentation. going back to the statistics, these are worldwide statistics, but in India, we are just minuscule when compared to the world statistics. India's statistical records as taken from the National Crime Records Bureau, which is run by the Ministry of Home Affairs. Yeah, thank you. Yeah, sexual assault is a violation of women's bodily integrity and therefore an abuse of their fundamental human rights. Sexual assault is now an issue of health and human rights. 35% of women worldwide physically or sexually exploited by the known people, their partners and non-partners. 90% of these abusers are known to the victims, and 5% of this population is afflicted, this adult population. What are these? We are not only confining to the sexual penis penetration. The women are subjected to such harassment or abuse which I am not capable of commenting on our cultural values, but the abuse which takes place every day for our daughters, sisters, mothers are stalking, voyeurism, voyeurism, sexual harassment, trafficking and indecent assault. They, including commenting, when WHO, ICMR, MCI, NMC, all of them have clearly mentioned what are these sexual abuses, violence which women face day in and day out. Today, this sexual offense abuses have crossed the limits of gender. We now call it as gender neutrality. Men, boys are also equally subjected to these sort of sexual abuses, especially pertaining to their sexual habits or to their anatomical sex. Children, what is a vulnerable population? Women working in offices, including hospitals, the best of hospitals, students, children going into schools, boarding schools, hostels, and staying in relatives, guest houses, and with other parental support group. These are more prone. And then working women, especially we have in urban 5 cities, IT professionals working at odd hours, they are the more prone. Statistics in India, 20 to 30% of children in the age group of 5 to 12 age group are the highest affected. There is a slight variation here in terms of who are these offenders. West, 90% are supposed to be the known people of the victims who are the offenders, whereas in India, 50%, especially in children, child abuse, sexual abuse, are known offenders, known people. We have realized their own stepfathers, including fathers, brothers, cousins, relatives, and neighbors, and teachers. I'm telling you about the elite. My famous observation, I'm not saying it is famous, but my obnoxious observation is this sort of offenders in India cuts across class, caste, and every elitism. So it is not pertaining to socio-economic or any factor, but this we have surpassed ourselves in our cultural modes. We are the 5th highest incidents of sexual abuse both in women and children in the world. And this is because 5%, 5th highest, not because we are not on the top, it is underreported. The reported cases of sexual abuse in India is just minuscule 5%. You can imagine 95% going scot-free. Here is where the POCSO Act as Protection of Children Against Sexual Offences Act of 2012. It has been enacted in 2012 after long debates, after all these statistics have come into place. POCSO rules, Act has come in 2012. Rules of exactly how it has to be implemented, procedures have been laid out in 2020. It took government for framing exactly what a policeman should do, what an advocate should do, what a judge should do, what a doctor who is working in an emergency, who is working in a forensic medical legal department or in a casualty should do. This article, this is again an outcome of Article 15 of the Indian Constitution, which gives special attention to the children. This act defined who is a child. Obviously, we all know, unlike in Western countries where a child's age group is 12, in India it is 18 years. Till 18 years, a person is called a minor in India, and this act clearly defines a person as a child up to 18 years. And then it defines, this act defines various acts of sexual abuse, like touching inappropriately, which we feel is the commonest mode amongst the Indian culture, but I know there is something wrong. Appropriate, we have been using appropriate touching and inappropriate touching of these children at various places, but I leave it to the August gathering to decide what is appropriate. For the sake of this, I would definitely say every touching is by a non-relative, by non-parents, non-siblings would deem to be inappropriate. Reporting, this act beautifully reports. It's a small 24-page act. It deals with how to report a sexual offense, abuse and investigation procedures, and then what are these atmospheres under which these cases have to be dealt with, child-friendly procedures. And then we are, as doctors, we are concerned about one of the sections of this POCSO Act. I'm here to just sensitize you how effective this has been. Under Section 21, it is mandatory for doctors working in casualty, emergency medicine, pediatrics department, gynecology department, and also in forensic medicine department, when they encounter a patient, whether it could be a child or an adult, who exhibits signs and symptoms which are not clearly, a little abnormal presentation, like disinterested, apathy, vague complaints repeatedly coming to the one of the unique features of these abused, they don't come and then tell exactly what has happened. They come, they frequently visit these healthcare professionals for various other ailments, which I will come to. So I have dealt in the last 1 year, four specialists in Hyderabad who have been charged under Section 21 for not reporting these sexual abuses in children and in women. One gynecologist, a couple came to Hyderabad from Bangalore, and then the man subjected, he bought his woman for termination. It was done in a government hospital in Hyderabad, and then after 1 month, there has been a case filed in Bangalore. The consultant gynecologist was taken to Bangalore for questioning by the Bangalore police. Do you know what has happened? They forgot, they just blindly believed the age given by both husband and wife, that the wife was 19 years. But it turned out that the girl was a minor. Is it the fault of a doctor? Definitely. This act clearly says they have done an abortion legally within 3 months of first trimester as per the requirements of MTP Act. But the only age had been, they blindly believed the age given. But this is what I would like to pose a question to our legal expert. What is the role of a doctor when people come? We blindly trust the information, the history given and the age given. Do we always subject or treat them with mischief or mistrust when they give this sort of an history? Our majority, as I realize when I do a consultation medical legal, these doctors are unnecessarily cheated or misused by these gullible patients. I definitely say our Indian patients are smarter, better educated, and then since we are no match for their wisdom, we fall trapped to these things. And then the punishment for not reporting. I've seen in my own hospital where child was brought by mother saying that the child has received multiple injuries during play. And then we all know what is this battered baby syndrome, non-accidental injuries. And then our smart casualty emergency team got suspicious. They came to us, we have informed the police, and then the mother and father, both of them IT professionals, were caught because there had been differences between those couple. They have been handling these children badly. So it is again a case where a child was abused physically by their own parents. So now there is a gray area between abuse and sexual abuse. This act also clearly spells out special courts to speed up the trial. There are 1069 special courts, fast track courts established in India from 2020. And then they were asked to conduct time-bound trials. And then punishments have been clearly spelled out for touching inappropriately. But there is one lacuna. Madam, legal expert, madam, you should tell us. Even I am confused. There are 6 types of these sexual abuses mentioned. Sexual penetration first. Aggressive sexual penetration. Sexual abuse, aggressive sexual abuse, molestation, and pornography. Which and how does a doctor in emergency has to understand these sections? We will be able to put the facts, observations in the case sheet, but how is a doctor as a knowledge about these legal provisions which we have to adapt? Our job in forensic medicine, this is beyond the capacity for an undergraduate student. For postgraduates in forensic medicine, we have only 200 medical colleges where there is post-graduation in forensic medicine, 3 years, where we are trying to teach them, update them these laws. But the 99% of these abuses, sexual assault cases are handled by MBBS and non-forensic experts whose major job is to handle pediatric problem, gynecology problem, orthopedics. That is where we have some problem in enforcing, in giving out proper evidences during the trial. And then we need to understand when a person complains of sexual abuse or assault, world over, it is presumed that they don't have to do anything. The person named as an offender has to prove his innocence. That is the law clearly laid out in POCSO Act. Still, I'm really amazed. The conviction rate, we will come to that. And POCSO Act, now and then it is being amended. 2019 amendments were brought, especially if you recall that Nirbhaya incident, after which the punishments, death sentence has been awarded. Till that time, gang rape of a 5-year-old child was hardly given 7 years in India. So this POCSO Act is one of the revolutionary acts enacted by the government of India, which I am definitely. And then subsequent to 2012 POCSO Act, we also add Juvenile Justice Act, which deals with how courts, police and doctors have to deal with these juvenile criminals, supposed to be juveniles are alleged criminals below the age of 18. They also are, they've given separate act so that because they are not mature to understand what crimes they are committing. So these are definite amendments which I'm sure we have been trying to update our medical students, but it is not in our curriculum. Only in 2019, we have one of the best members in National Medical Council, who is an expert on medical education technologies. They have been striving hard to update these latest laws which have a bearing on medical profession to help out in criminal justice system. Criminal Law Amendment Act of 2018, about child sexual abuse, as of May 2023, Smriti Irani gave these statistics. Fast track courts are 1029 in 29 states. As of today, 1,69,342 cases have disposed, but still 2,43,000 cases are pending in a span of 3 years. Imagine 3 lakh cases still pending in a span of 3 years from 20 to 22. And then what these are only reported cases, as we call it, tip of the iceberg. And then there is a provision in this POCSO Act, 7 lakhs to be paid. But who pays? Policeman doesn't know in Hyderabad. The judiciary doesn't know in Hyderabad. Child welfare worker doesn't know. Social welfare worker doesn't know who has to give 7 lakhs, which has been enhanced to 50% more base because some of these victims need further treatment where they have been maligned or physically so badly abused after sexual assault. Their treatment goes into, if you recall, areas of Nirbhaya where she was about to be airlifted to Singapore. After having learnt about this, Government of India raised the compensation to 10,50,000. So the compensation paid, this is for the statistic. For us to understand the socio-economic implications, 2021, 1 crore was dispensed. 2021, more than 2 crores, exact figures are there. 2022, more than 3 crore rupees were given to compensation for these victims. Not all these victims, only about 30% of these cases got justice in a trial under POCSO Act. And then there is, we all should remember, like our other numbers, 24-hour child line number, 1098 throughout the India is now where under POCSO Act, any minor under 18 years, whether there is clear-cut history of sexual abuse, even the latest medical council in medicine, we are now teaching it is rape or sexual intercourse doesn't mean complete penetration of the penis into the vagina. We have now reformed, re-educating only after the 2019 batch student admissions, touching in any of the orifices of a human body by hand, by penis, by object, by pen or anything is now deemed to be a sexual assault, which I'm sure even I didn't learn when I was a postgraduate in forensic medicine. This is the latest law after 2019, which we are incorporating. We have taken out extra measure even though there is no provision for, and then we have the problem. Medical education is under Ministry of Health. Law enforcement agencies, police and judiciary are under the Ministry of Home and other company law and justice ministry. So there has to be coordination at that level. Role of doctors, this is more important. As has been enumerated hundreds and thousands of times, please go to documentation. My advice, in spite of legends here, IAS and IPS officers and judiciary, I would say, even if you have not counseled, put it on paper. Self-care, protecting your own skin is much more important than really taking care after having seen the doctors being humiliated in consumer courts and medical council. So documentation, when can you do a documentation properly? If you have taken an history, minimum amount of history taking, I'm ashamed to say, majority of our doctors don't even take 5 to 10 minutes. If a doctor is examining, as somebody was pointing out, we examine 100 to 200 patients. How much of time are you allotting? How many hours of this time you are working? Mandatorily, or it is needed that documentation, writing the history and the plan of management and the treatment, everything needs to be equal time as history taking. Commonly for a routine non-emergency cases, it is 5 to 10 minutes of history taking, and then explaining is another 5 to 10 minutes. Documentation is 5 to 10 minutes. Approximately, Western standards, hardly they see not more than 10 patients. In India, we look after 100 patients on an average for every specialty, both old and new. So these are statistics. And then documentation in an emergency. You have a crisis and you have a sexually abused patient in the casualty. We are trying to save him. The other important core area is to give medical aid, first aid, and then we are asked to do documentation. But it is compulsory. I'll definitely agree, if you don't do the documentation, if you save the patient, you are still negligent and liable for punishment. And then objectivity. So the owner says every society of India can be violent, they can be prejudicial, but the only profession, definitely, we took it upon ourselves when we joined medical college, that it is our noble profession. We swore on Hippocrates that we would be objective. So history taking, when we are writing the case sheets, objectively we should write what the patient says. And this is the most beautiful evidence which court has to rely. If you can jot down what the child or what the patient has stated in the case sheet beautifully, objectively, clearly, concisely and precisely in a time-wise fashion, then that is enough. There doesn't need to be any evidence for a judge. That is what I've clearly learnt. And then beautifully, this POCSO Act clearly states what sort of an ambience under which this child or a woman has to be examined. How a rapport has to be established by a medico. Do we have a medico-social worker in any of our places where we can have talk to the patients who come with such a abnormal behavior into the casualty? Doctors, they are medico-social workers, they are psychiatrists, they are pediatricians, and then they are emergency workers. I'm not trying to defend you. We have taken it upon ourselves. When we have taken it upon ourselves, let us do a thorough job of maintaining perfect ambience, and then rapport has to be established with the victim. And I've personally seen, I've examined about 564 of these rape victims for age determination in Usmania and Gandhi when I was doing government survey. I can definitely tell you, we were so immature, we never were taught about these soft skills, how to talk to them. There is no private room for us to examine those patients. And then you expect us to have a lady attendant. Invariably, I had to call upon my ayah, who is absolutely dumb, and then make her sit besides me when I'm examining and trying to do. So these are clear and precise reporting. We lack that. Definitely, I agree. In the pressure of examination, we sometimes tend to be not precise and clear in our reporting. Consent, as Madam has already beautifully explained, and then today, National Medical Council, NABH, if any one of you go through, there are 58 types of different consents. Even for per rectal examination, there has to be a different consent. That exhaustive, they are present in domain. Go through Ministry of Health, NMC domains. They have even given how many certificates can a doctor give. What are these medical legal certificates? What are these ordinary? OP chit, as we ordinarily see. I'm surprised. Today, NMC has given a formatted OP chit under which what has to be written, What exactly? As I've realized in the last 70 years, every OP set has only treatment, but that is grossly illegal as per this latest laws. Exhaustive history, especially sexual abuse and assault cases, you need 1 to 2 hours for taking an exhaustive history and examination. And age testing, for all these age testing is mandatory for, but I would definitely go one step ahead. Even for elective cases, take Aadhaar card, take identification, take their proof of age and then occupation and their residence. That is, we have to safeguard ourselves. And then finally, one of the most important areas which police department, home department has to train the doctors. I have approached them. They don't care to. Police academies, in spite, they want us to train them, but they don't bother to train medical doctors. When we are doing those, how do we collect? 90% of our doctors in casualty, they don't even know what to collect, is at least in a poisoning case, leave alone a sexual abuse case, and how do you preserve and where do you send it for? I have seen hospitals collecting these specimens. Police doesn't even collect them for years together, and then that is where we get the flag. Police get scot-free, judiciary gets scot-free, the ultimate liability is on doctor. So evidence collection, corroborating history, treating both physical and psychological problems of the patient. These are the 3 golden triads which all physicians, especially emergency medicine doctors should. And finally, these are the major causes. Non-reporting causes, shock of the child or even the adult. I'm really seen lot of women who have been pushed in trains, in bus stations, in public places. They've been handled, touched, and then we have a recent judgment of a Bombay High Court. Touching the breast or a buttock is not sexual assault. Which DKD comes from, I am not able to idealize. But that is where we have, I can definitely comment on that later. Guilt, shame, embarrassment. Nobody believes these victims. And then lack of confidence in criminal justice system. Criminal justice system, we know, judge, police and the doctors. They don't believe, all these victims, they don't believe in any of these 3. They are powerless. And then you can see their loss of control on themselves. Fear, silence. 99% of these people, they carry on their lives in silence. But I've seen their mental trauma after certain ages. Their social life, their psychological life, their personal life, their professional lives is so shattered, unconceivable for us to imagine what they go through. Future problems for the victims, nightmares, fear of touching, depression, anger, grief about loss. You go about these things. It can be basically this sexual abuse and assault. It needs minimum of 6 hours to dwell upon. But since I got 30 minutes, I thought I'd just sensitize you about these areas. But there is lot to learn for us. And then ultimately, if you can identify, empathize with what they go through, these things, nightmares, these children and adults, I've seen them personally, what agony they go through, and imagine what would be their outcome in their future life. So this is where, as doctors, when we train ourselves to heal both physically and psychologically, I think it's a challenge for us, leave alone the rest of the society. Thank you. I'm ready to take up any question today. Yeah, especially my budding young doctors in emergency. I know they get lot of problems. They are good in theory, but practically what they don't even know. They examine a sexual assault victim, and then what do they preserve? Where do they preserve? How long can they preserve? Who has to take this? These are simple things which come across. Yeah, I'm always open. I've really enjoyed, and this is the, as somebody stated, this is the only center in India I've been visiting throughout, which has dealt about this topic. I volunteered in all the gynecology departments, in all the police academies to take classes and volunteer. Nobody has asked me to take a class. This is the only institution which I fully agreed, and then with all of my heart, I definitely said, this is going to be a pioneer in tackling sexual abuse in India. Thank you.
Thank you very much, sir. And I would now like to invite Vishwajanani Madam Garu to please come and present a memento to sir. Thank you once again, sir. I would now like to invite everybody for a tea break, and we can proceed to the pre-function area that is right outside this auditorium, and we'll break for 10 minutes. We will come back here by 11:50 a.m. Thank you.
యాడ్ చేశారు సేవ్ మాత్రం ఖచ్చితంగా క్లిక్ క్లిక్ చేంజ్ అవుతారా
పది చైర్లు కావాలా ఇక్కడ 1 చైర్ 9 లైక్ కొంచెం కర్వ్డ్ ఉన్నాయి కూర్చోండి ఆయనకు ఒక సెపరేట్ మైక్ ఉండాలా వాళ్ళు 9 మందికి ఒక 3 మైక్స్ పెట్టండి షేర్ చేసుకోండి ఇది ప్యానల్ డిస్కషన్ సేవ్ చేస్తాం సేవ్ చేసాం దిస్ వన్ ఇస్ ద నెక్స్ట్ ఇంట్రొడక్షన్ స్లైడ్ పెడతారా
Next CV, please.
We welcome you all back again, and moving on with our sessions, we have a very interesting talk lined up next, and this is something that is often looked beyond, or we don't pay much attention to this, but to give us more clarity about compassion and when not to treat, we have with us our next speaker, Dr. Nayan Sriramula, who is a consultant in our own Department of Emergency Medicine at AIG Hospitals, and he holds an MD, DNB in Emergency Medicine and also a diploma in Medical Ethics and Law from the National School of Law in Bangalore. And I invite him today to address the gathering.
Good afternoon, everybody. Thank you, Nitya, for the introduction. So, we have finally arrived at this discussion where we have been ignoring it for many years, talking about end-of-life care, which is also known as palliative care. I'm Dr. Nayan Sriramala. I'm a consultant of emergency medicine. So 94% of terminally ill patients in India die with pain and distress because they don't receive proper palliative care. And how can we change this? I just want to ask all of you here, senior physicians, have you had to make a difficult end-of-life decision in the last month? I hope you all had that. I mean, all of you senior physicians might have faced such challenge recently only. So let's imagine a scenario here of a patient, Mrs. X, a 72-year-old woman with metastatic cancer. Despite medical advice, the family chose to go with a surgical option, and she was obviously unable to be extubated and put on a ventilator for 14 days. The family refused to withdraw support despite medical futility, and she passed away in ICU after a prolonged illness with a bill of around 10 lakhs. So, do you think this is truly care or just prolongation of suffering? What is exactly palliative care? G.R. Dunstan very well said that the success of intensive care is not to be measured only by the statistics of survival, as though every death is a medical failure. It is in fact to be measured by the quality of lives we have preserved or restored, and also by the quality of the death of the dying in whose interest it is to die and let them die, and by the quality of human relations which have been developed with this death. Palliative care is physical, spiritual, psychological, social support provided to patients and families at any stage of serious illness. So we have seen rise in the ICU admissions of terminally ill patients in India, and there's a study. There are two studies done in 10-year time frame, and the sample size is 4,500 ICU patients. It is published in Indian Journal of Critical Care Medicine. INDICAPS 1 and INDICAPS 2. So this INDICAPS 1 into 2010 was done, and the same sample size, 18% was ICU mortality rate, and discharge of terminally ill patients was 175. However, after 10 years, the ICU mortality rate in the same ICU with the same sample size increased to 25%, and the terminally ill discharges have shot up to twice, which is 350 people have taken LAMA or DAMA, terminally ill patients. So this also can be interpreted in a way that people are not focusing more, or people are not educated about terminal ill care, palliative care. They are more thinking about aggressive therapy. Attenders and family members want to take LAMA and go to a better hospital, a higher center. They are always trying and trying, but never letting go. Here, the general narrative of emergency medicine for this palliative care is that emergency physicians are, they're trained to save lives, but they're not trained to deliver end-of-life care. That should be changed. The training should be changed, and it should incorporate the palliative care decision making also. So that, because this is important, why? Because most people, all of us, even I myself, want to die peacefully in my own home at night, in sleep. Everyone wants to have that kind of death. But no, we don't get that kind of luxury always. Even a slight symptom onset will trigger your family to bring you to the emergency department at late night, 2 a.m., 3 a.m. and you will be, or somebody who is terminally ill will be on the ER bed just waiting to die. So that is why emergency physicians in general should know and focus more about palliative care. So the distribution of death in India is, you can see there's 53% people die at home and 43% people die in hospitals. So very less people are brought to the hospital compared to those who are dying at home. And those who are dying at home are dying in pain, in distress, waiting for their death to arrive. So there should be happening, a pain-free death should come. So the reality, how death looks in India today, is that 80% of Indians are many in the ICU waiting for their death to come. And less than 2% of these patients are receiving palliative care therapy. And families are often prioritizing doing everything they can to save the life over providing comfort. So this is how a normal government hospital would look in India today, where the people are all waiting for the bed. The ventilators are shared among two people. One person is getting the ventilator for the time being, the attender is doing bains, and then they are switching on to the other person. So this is how it is in a government hospital if you go and see. But the physician has to take decisions, and the decision making fatigue is very severe on us. How do we take this decision? Is first we have to assess objectively, and then we have to get an honest and accurate early prognosis of the patient. We have to offer palliative treatment options very early and give them a poor prognosis when we have assessed it. So the consensus will be reached and repeated discussions must happen. We have to ensure consistency from all the caregivers of the team, even the nurses, the junior doctors, everyone should be on one point. We cannot confuse them. And there should be transparency in documentation. The documentation should be proper. Even if they're going lama, we cannot say they're going lama because of financial issues. We cannot say whatever we want to save ourselves from that. So the documentation should be honest, and withdrawal of life support can be done after this consent is taken, written consent is taken, and effective and compassionate care to the patient should begin. And this is different from ICU care because here they have easy visiting hours, easy visiting access, and they have no diagnostic tests, repeated tests, no there's no repeated tubing or etc. There is a spiritual environment provided to the patient and their relatives. So when does treatment exactly become futile, and when does a doctor say that this is futile and we have to give up? So we have to identify this point. So as per Mayo Clinic proceedings, medical futility is situation where a treatment is unlikely to achieve its intended goal, providing little or no meaningful benefit to the patient. Futility can be categorized into different aspects. One is a physiological futility, where the treatment fails to achieve its intended biological effect, such as giving CPR in a patient with irreversible multi-organ failure, or patient who is brought very late to the emergency and unwitnessed arrest has happened, and you are giving CPR to them after, we don't know when the patient has arrested, and continuing ventilator support for many days for a brain dead patient. So with this, I get reminded of this particular celebrity. Is Michael Schumacher, is a 7-time F1 champion. In 2013, he met with a skiing accident where he was left almost brain dead, and he was put on a ventilator for 6-7 months. So he was tracheostomized, he was on ventilator for 7 months. And after 10 years, there was a silence. After 10 years, they spent $18 million on his health. They did some secret, unproven therapies was given to him. After 10 years, they have told that he's responding now. He is able to communicate. But how is he communicating? He's communicating with his eyes. He's just showing some gestures. He's not walking or talking like before. He's just on the wheelchair. So is that what we have done? Is that what prolonging life means? So there's quantitative futility. When the likelihood of success is extremely low in this particular treatment, such as a chemo regime with no proven survival benefit in a particular end-stage metastatic cancer, or there is a qualitative futility. So when the treatment sustains life, but it does not improve the quality of life, but only prolongs the suffering, such as a dialysis in a patient with end-stage dementia, multiple comorbs, who is unable to interact or function meaningfully. patient-centered futility. When we do not align with the values of the patient, the goals or his wishes, the patient is having his advance directive or a will, but the attenders are not accepting that. They want to push it further and try all you can. In fact, we get lot of patients with such aggressive medical wishes, because here obviously all of us are working in tertiary centers. So we receive patients from all corners of India, and they are coming here with hopes that we can save them because their local doctors have given up. So we have a lot of pressure from these patient attenders and family that we should do everything we can, and giving up or telling them that we have to start end of life care will only make us look very weak or unqualified in their eyes. So that is something a physician has a lot of pressure on, to convince the family. There is ethical and legal futility also. So when we are continuing therapy, when it is ethically inappropriate by the healthcare provider, so non-beneficial prolongation of dying, such as prolonging the ICU stay in a patient with irreversible multi-organ failure against medical consensus. So this brings to us the next topic, the law and the dilemma. So what is this dilemma about law? Recently, a PIL was filed, and this petitioner said that right to health is not palliative care. So where should the poor people in the government hospital go to get palliative care for themselves? Is palliative care only the concept of the rich? For this, the Justice CJI D.Y. Chandrachud replied that palliative care is already included in the judgment of right to health, and it will be superfluous to pass another declaration supporting palliative care. So they basically said that, we already provide palliative care as per the right to health. So you have to find it in between the lines of the judgment somewhere. That's what they said. And recently, this month only, India pledged to improve access to pain relief while chairing a UN Commission on Narcotic Drugs. It said that we have to improve access to the terminally ill patient to give them a pain-free death, and also suggested that there are alternatives in Ayush treatment which can be given for pain relief. So what exactly does the law say, and what exactly does happen reality? Right to palliative care, like the Supreme Court has upheld, but only 2% of Indians have access to it, and most terminally ill patients still receive aggressive treatment at the end of their life. Living will is recognized legally, but the Supreme Court by the Supreme Court ruling on passive euthanasia, but there is very low awareness. I mean, even nobody of us will have a living will or an advance directive in place. Withdrawal of support is also legally permitted under strict guidelines and medical approval, board approval, but the families often continue to prolong care, as we have discussed this. DNR status, do not resuscitate, so it is allowed in principle but lacks standard implementation, and it is ignored by the family even if the patient says or signed it. And hospice home-based care, it's still in the papers, but very less people have access to this. 0.4% of patients receive home-based end-of-life care in India. Opioid access is also around 76% of cancer patients suffer untreated pain. Financial burden of ICU care, there is no legal obligation for families to pay beyond their means for futile treatment. That's what the judgment just said. But out-of-pocket expenses for ICU care push 55 million into poverty annually. The family conversation is what we struggle the most. Like Sir has said, the soft skills. How do we develop these? Doctors are trained to treat, not to talk. That was the old norm. But an honest conversation with the relatives and attenders will change the experience they have. The simple protocol is to follow the spikes algorithm, where we are setting the comfortable, non-threatening environment. We are taking their perception about what is happening with the patient. We are inviting for any questions or any important answers they want to know. We are assessing their knowledge about the disease, explaining them further. We are respecting their emotions and respond with empathy. We are summarizing again and again, because when we are giving them a bad news, people often tend to zone out. They will not think and talk at the moment. They will think what is going to happen and how is their family going to survive. So that's why we have to summarize frequently. So we'll just discuss few key communication phrases. How do we determine the patient's decision-making capacity? We have to ask them, will you describe your current condition? Or explain to me why you feel that way. Next, we have to understand, according to patient, what is quality of life for them. In this, we have to ask which symptoms bother you the most, what concerns you the most, so we will know what is quality of life for them. And we have to explain the prognosis. Has anyone talked to you about what to expect about this disease? This is a question we can ask. And do you want to discuss about what the time is left? So while talking to their surrogate decision makers, we can ask them that we will do everything possible in our hand to not provide burdensome therapies such as CPR or intubation, which will prolong the suffering. And we have to discuss palliative care or hospice referral, and we have to tell them that we have a very experienced team which will come and visit you for explaining you about the symptoms and the palliative care options which are there for you. So all of these can be done, and the decision frame which was given by Kahneman in 1981. So people often demonstrate preference reversal depending upon how we frame the question for them. When choices are presented in terms of gains, people are risk averse. And when choices are presented in terms of losses, people are risk seeking, which is basically how stock market works. So physicians used language, they have done a study where they used language of do not resuscitate. And they have said, one group they have said, allow natural death. So after this, more people have chose the second, allow natural death to happen, where DNR was not accepted by the relatives. So there is a physician orders for life-sustaining treatment, and there is a advanced directive which is called as a living will. So we'll go briefly about these. What is the difference? The purpose is, for the first one, is to provide actionable medical order for emergency and long-term care. The next is a general will of the patient, which the patient makes for himself. Both are legally binding, and both are explaining the advanced life care decisions. First one is made with a physician or healthcare provider discussion, but the second one is often with the legal counsel. The decision makers will explicitly tell to, in the POLST, we have explicit advices to provide CPR, intubation, or any other kinds of prolongation. But in a advanced directive, there is no such thing. We have to interpret it later. And both of them are recognized in India. But the thing is, very less awareness is there among both of these. So let's think about this other side of the story, where Mrs. X did not choose palliative care, did not choose aggressive surgical option, but she went for palliative care. She went home with her family, did not take surgery. She was happy, whatever time left, she stayed with her family and home and pain-free. So this is how it would have been for her. Instead of tubes, ICU, intubation, bed sores. So we'll talk about quality of life. WHO defines quality of life as the individual's perception of the position in life in the context of the culture and the value system in which they live, and in relation to the goals, expectations, and standards and concerns. So each person will have different expectation of quality of life based upon their cultural aspects, their spiritual aspects. Everyone have different aspects of it. There is a study published in BMJ Palliative Care. This is the quality of life comparison. They have administered a questionnaire to two groups. One is the palliative care group, one is the general population who are not in the palliative group, terminally ill patients who are not in the palliative care group. Two of these had administered SMILE questionnaire, and they have assessed that those in palliative care are more happy with the quality of life they are getting. So that is around 82% of them have decided that they are getting a very good quality of life, because we have taken into account their opinions, their perspectives. Why do you think the EOL is very poor in India? Apart from the challenges we have faced, there is cultural reluctance. If today, even somebody says, I would be dead if I did that, and somebody, elders in our family listen to that, they will give us a big scolding. How can you talk about death? So that is kind of cultural reluctance to discuss death in India. And there is lack of trained palliative care physicians or professionals. Apart from, if you look at today's scenario in medical field also, apart from anesthesiologists, and emergency physicians and few other trained physicians. Very few have access or the training with care of opioids or pain medicine. This has to be changed. This has to be, and the burden of existing healthcare system, the nurses, especially the housekeeping staff, they are the most overburdened in terms of palliative care, because those people have to attend and make cleanliness to the patient. So they are very burdened, and we're not having a lot of people do that work. So there is a website called Indian Association of Palliative Care. Here, state-wise list of palliative centers near you are mentioned. You can go and see that. So based on that data, there are, in 2019, there were 300 centers available for us, but the demand was 5,000. But in 2024, the centers rose up to 908, and the demand is 6,000 right now. But I have personally checked the website. In Hyderabad itself, there are many centers, but most of those are basically for the namesake, just a board. There are no real centers there. So that's how we know what is really functioning. So we don't need a revolution. We need small practical changes where we all sit down and not ignore this fact. Talk to each other about how to improve end-of-life care in our community. We have to talk to the patient attenders, and we have to tell them that giving up is not failure. For us, there is an action plan for doctors. We have to first identify end-of-life care patients early. We have to initiate discussions early and giving them subtle hints that there is always an option. There is always an option of not continuing therapy. Then we have to manage the pain protocols liberally without any hesitation. And next is to respect the patient's choice. If the patient, even if the senior doctors have seen multiple cases come out of death, they might have saved people with this kind of therapy, but we have to respect them, the patient's decision to not continue any further treatment. As doctors, we are trained to fight death, but sometimes our role is to ensure a peaceful death. The choice is ours, and what will you do differently in your next end-of-life case? Like Hippocrates has said, as physicians, to cure sometimes, to relieve often, to comfort always. Thank you.
Thank you, sir. I would now like to invite Ratna sir, Dr. Ratna Kumar, to give away a memento to Dr. Nair. So moving on to our next session, which I believe is the most look forward to session. We have with us a panel discussion, and we have with us 9 fantastic individuals who are present with us today to talk about something that is no longer just an incident here and there, but it's become the new normal. And yes, we are talking about workplace violence and about handling aggressive behavior in the hospital. To moderate the session, I would like to invite our moderator for the day. He's a consultant in the Department of Emergency Medicine at AIG Hospitals, and he's an MD in Emergency Medicine and the recipient of the President's Gold Medal in DNB. And apart from being an excellent clinician, he's also someone who, if a lot of people who know him would agree, that he's someone who can cut right through the noise. And it gives me immense pleasure and pride to invite the moderator for today's session, Dr. Sharat Chandra Uppaluri.
Hello. Thank you so much, Dr. Nitya. I think that was way glorified of an introduction for me, and most of you will be more mesmerized when you meet our panelists. Okay, let's start with the presentation. Yes. So the topic we are discussing today is handling workplace violence and aggressive behavior in ED. So when the next attack happens, now just as a raise of hands, how many of you have faced violence in some kind, be it in action, words, or even psychological? So many lucky people who have not faced. Come on, man, be honest. See, I see all hands going up, isn't it? So do you think this is a contentious issue to talk upon? Yes. So I'm Dr. Sharat Chandra. I'm a consultant in emergency medicine at AIG Hospitals. So this word, when the next attack happens, you'll be ready or lost. This is not just to, underline our topic today. This is a sentence, I think, that echoes in all the halls of emergency departments, ICUs, OPDs, and examination units and all. Yes? So let's start off. Let's just watch this video. In Nasik, that was a pulmonologist, and look what happened. I think after just one strike, we just lost the count how many times it was done, right? He was struck 18 times with a sickle. A dead body was also struck. Look at this. This happened in our own Andhra Pradesh, neighboring state. On a female doctor. Happened in Sri Venkateshwara Institute of Medical Sciences. And look at the respondents, how nonchalant and how laid back they were. What would you do if your sister or mother faces that? Look at this. And look at the bystanders enjoying the show. And if I just keep doing this, I think one day session is also not enough on how much rampant it is. So many reports, and the recent one being this one. Yeah, still awaiting justice. Yes, so without any further ado, I think we have a perfect amalgamation of different voices from, I think, all the stakeholders in this system. Yes, we have voices from emergency medicine, physicians, critical care persons, law enforcers, advocates, and administrators also. And of course, not last but not the least, media and a public opinion also. Shall we go ahead then? With utmost pleasure, I invite our first panelist, Dr. Ashima Sharma ma'am. She was my own mentor, professor of emergency medicine, and anybody who has listened to her, every one of you would have heard about her, isn't it? She is an amazing speaker and a good teacher also. So it gives me an immense pleasure to welcome her. Thank you, ma'am, for gracing the occasion. Next, we have Shri Ajay Mishra, sir, IAS, retired IAS. He's been the principal secretary at multiple portfolios, and most of you have heard him speaking in the keynote address, isn't it? Imagine what he brings to this session. And we have Vishwajanini Garu. Her crispness, her clarity, I think were all witnessed. Yes, and let's just witness them again now. And again, I have the utmost pleasure of meeting almost a cinema hero, very handsome man, our own Dr. Vineet. He has done an orthopedics, he's been an orthopedician, then transitioned to Indian Police Service in 2017. So he transitioned from joining bones to breaking bones now. Yeah, and let's welcome, sir. It's utmost pleasure I welcome Shri Vineet Ji, MS and IPS, DCP of our own Madhapur, onto the dais as the panelist. Thank you so much, sir, for joining us. Next, and again, it gives me pleasure to welcome Dr. Venkat Kotamraju, sir. He has flown all the way from UK for this panel, and he is a regional chair of Royal College of Emergency Medicine in UK, and he is the senior consultant in emergency medicine and toxicology at Royal Derby Hospital, UK. And he brings his perspectives from around the globe. And we have our own beloved HOD, Dr. Ratnakumar, sir. His fervor for academic excellence and his experience in managing vast variety of cases will definitely bring some insights to this. And we have one more very affable consultant here, Dr. Karthik Ravikanti, sir. He was our own emergency medicine colleague. He led the emergency department here, and he has moved on to critical care, and is a senior consultant there. So as you can see here, sir also holds a law degree he holds a certification in medical law, and he has been an instructor in all these things, BLS, ACLS, PALS and ATLS, and is a very good academician and clinician also. And welcoming, we have a very young and dynamic faculty here. My own senior and my own personal friend and mentor, Dr. Rahul Rohan. You will listen to him now and you will figure it out for yourself, what he brings to the panel. Last but not the least, voicing the public and the media opinion, we have Mr. Arun Yellamati Garu. He is a very, you can see, as you can see in him, his foundation name is also Youngistan. It's been a very famous NGO. You have seen Sajnar sir mentioning his NGO. You can just imagine the kind of work he does. Yes, he has impacted millions of lives. Yes, and he's been covering our AIG's collaboration with Mayo Clinic also as a journalist. So thank you so much, sir, for joining us. And I think, shall we begin the seminar now, the session? Yes, even I'll take my seat as the moderator. Thank you. Hello, am I audible? Yes. So very enriching panel. I hope it's time to dive into the topic. Yes. The first one being, let's address the problem first. Yes. Let's start with Ashma ma'am. Ma'am, you have been leading the country's one of the most busiest ERs in ER and trauma. What do you think are the most common triggers for aggression and violence?
Thank you. When I got this question that I would be coming for this sort of CME and panel discussion, I recollected all those incidents which happened in Nizam's over emergency department over last 12 years. All of them can be bundled under two major topics. One is difference between the expectation and reality. And the second is breach of trust. Well, don't think it is only from the patient side to the doctor's side. These are two parties and it is either side. So let me give you one minute examples of both which happen. So reality and expectation. The patient starts, attendance starts the patient from a village, seeing a movie where doctors are God, and there is no money, never money is being discussed. Or if money is being discussed, then there is a hero out there who tells that life saving is more important, no one can ask money. And so when they reach to the gate of the hospital, I'm talking of private government hospitals, I represent institutes, they do not understand that even the government insurance services require a little amount of money to be paid, then it would be, then only they will be getting the insurance certification done and their treatment would happen under a particular insurance claim. This starts that expectation and reality difference from then itself. Coming to the breach of trust, which I say, there was a patient whom we received from Saudi. He had, young male, had gone on a vacation, had unfortunately had an accident out there, was brain dead. The government flew him from that place. He was already declared brain dead, but they wanted to come back to their place. Place is Hyderabad. Institute given to them to reach was Nizam's. And in Nizam's, it was given to reach to emergency department. Now, when they brought the letter to us, I personally had talked with them and they were very clearly understanding, and they told that they're just bringing because they want all their relatives to see. He's a young man. And what we do is we sympathize with them and we, okay, yes, bring. But once they brought, after that, see, the breach of trust happened from their side. Every day when we were telling he's brain dead, you need to now take him, we need to, got him certified, and we need to just get the treatment over now. There's no further treatment. The same people who were requesting your help before they brought were questioning your ability to diagnose and treat this patient. So I would say all these incidents can be bundled under these two things: the stark difference between reality and expectation and the breach of trust. Thank you.
Thank you, ma'am. I think the gist of it is over expectations. We do notice them, yes. As soon as patient walks, they want entire hospital to be at their service, yes. And the breach of confidentiality. I think very well put, ma'am. Ratna sir, you are leading an emergency medicine very rich in faculty. I think the country is largest in terms of faculty. As a leader of a corporate facility, what do you think are the triggers, sir?
Hello. Yeah. So once again, hi to everyone. So fortunately, I'm leading a generous and a big emergency department, which is abundantly blessed with the qualified people and the resources. I'll tell you what. As an emergency physician, first from the starting, like the overcrowdingness, the resources, lack of communication, no role play, nobody knows what's their defined workplace, or they have multiple restrictions. Sometimes a doctor, publicly they are said that they are like gods, next to gods. But everybody should understand that they are merely human and their feet should be on the ground, because uttering a thing like, I can save him, I can do this, we can do that, this will create unnecessary expectations, and that will create a lot of misharmony, which will lead to a lot of things. And first, the physicians who are working in a hostile environment like an emergency department, first they should know what they have. They should have a clarity what they are dealing with. They should take some time, and then they have to deal with it. Because starting from the registration till the end of the discharge or LAMA or death, we will make a lot of issues. Lack of communications, billings, and everything. So every department should have everyday progress, or they have to meet and they have to greet everything, and they have to discuss the things.
Thank you, sir. So the gist of it being, we should know our limitations. Yes, we can't give false hopes. Know your limitations, involve the experts well, and if not, take the help of your seniors who are more experienced. Yes. So now the question to my sir, Rohan sir. You are a young and dynamic faculty. You have experience from NIMS and also from AIMS New Delhi. Yes. So as a frontline worker, you are working on ground level and not just behind the scenes. Yes. So what are the challenges and difficulties that you face when facing these situations, and will that affect your quality of care?
So before answering the questions, I want to say to everyone, my colleagues and as well as the respecting the dignitaries, the thing is that everyone has to understand that the emergency department is an eye of an hospital. Everybody knows that. So healthcare workers who are working in the department, they are seeing a variety number of the cases, and at the same time they are taking the critical decisions in a critical time periods. So that means already they are working in a high pressure situation. In these situations, if somebody is triggering, some violence is happening, you see how devastating actually. For this question, I want to answer myself. I want to quote myself as an example, because I was been also involved in, I have been threatened by some of the attenders. They have been done verbal abuse to me actually. So what happened is, in the late evening hours, I was seeing the cases. Suddenly 3 to 4 attenders came to me. Just they came to me and they are saying, sir, my patient is there outside, so you have to come and see the patient. Then I went and saw the patient is walking, talking, coming only. She is also saying that, sir, you have to take me inside. What has happened? What is the problem? You know what they said? Sir, we came to OPD. OPD is closed today. So what we want is, today night we don't have any place to stay. So I want to stay in the emergency department, so that tomorrow morning I will go to OPD. That's it. That is a simple statement they have given to me. And you know what I was seeing in the case? I'm seeing that I was posted in the high risk area, that is a red zone, and I was seeing the case of a red area. In this situation, these people came and they was arguing with me. I told, sir, this is not going to happen. The thing is that first you have to understand this is the emergency department. Slowly the momentum is started. I am telling her, telling the attendants that, so this is has to, you have to take care that you should have to go to the, there is a hall, waiting hall is also outside. One attendant came rushing inside. Almost around 5 minutes, you have been not taken the patient inside. What you people are doing? Kadam started shouting at me. Within 5 seconds, I didn't understand what is happening actually. I'm just seeing that everybody is surrounded me. The 4 attendants who are there, everybody surrounded me, and they are throwing everything on me. They started abusing, verbal abuse has been started. They are throwing everything on me. It took me 5 to 10 seconds to understand actually what they are talking. And when I was seeing my surroundings, everybody is also staring at me. Oh man, everything is happening good, okay. Every attendants also started seeing at me. At this point of time, the name plate is written on my coat. They started taking the picture of mine. And you know what the person, actually is a media person. He told, you are not taken my patient, right? Within 2 days, you will be in media. So within a span of time, I was working in the bench of my hospital. I will be in the media, it seems. See how actually my life has changed. Within a span of time, my life has been changed. So I am not understanding what to do. In this, actually, why I am quoting this example is, when somebody is throwing everything at me, I don't know how to act actually, because I have been not trained in that. I hope everybody here is not trained how to act. I have not trained actually how to act actually at this point of time. Sir, I know you think I know how to act. What I was trying to do is, I tried to take out my phone. I wanted to just dial one number. The attendants grabbed my phone. The thing is that I don't know whom to call, first of all. I try to take out my phone, but I don't know whom to call, first of all. So the thing is that I don't know whom to call. These are the challenges which I have been facing. Whether I have to use my nameplate or not, first of all. After this incident, what are the challenges I faced? And after that, whether whom to call actually, how to act in this situation, I don't know at all. I'm completely, my body-mind coordination is completely lost. And I thought that whether I can, because they have grabbed my phone, whether I can use this phone or something else is there in my department, or something else is there where I can go and I can push something so that everybody will come. That is also I'm unaware or not. So the challenges is, first thing is how to act, which has been never has been trained, never has been there in my curriculum, first thing. And the next thing is what to do, whom to call, when to call, whether before the argument, during the argument, after the argument. So I don't know. These are the challenges. And the next thing is, I told you already, I am working in an area where there is a high risk area, I mean like a red area, where I am seeing the cases which are critical time decision making is an important. All these things pushed me that to whether I can able to. Now the challenges have been answered to your question. The next thing is, does it affect the quality of the work, right? Do you think it will not affect the quality of right? I think answer should be from the audience only. What do you say, yes or no? Yes. Definitely yes. My strength is critical decision making as an emergency physician. Critical decision making in a critical time, that is my strength. I lost my strength. That is, I am telling my strength. I am telling now also I lost my strength of critical decision making. When I lost my strength of the critical decision making, what I am committed to? I am committed to do high medical errors. As Madam discussed today, you should not do the medical errors, but the thing again, it is coming to the medical errors, right? So I am very much committed to do the medical errors if I am not taking my critical decision team. And the next thing is that when I am committing the errors, the next thing is that I will be my team. The emergency runs with a team. The team itself depends upon the confidence of each individuals. My team strength is also has been broken. So everything has been broken here. These are the things affecting the quality of life and that quality of the work. Not only the work, at the same time, it is affecting me emotionally also. My senior actually is, after this incident, my senior was there. He immediately he stays beside the hospital. So he came to me and he took me outside. You know what the words actually he said? Congratulations, Rohan. You know why he said to me, congratulations? The first thing he said is, you are experienced this incident very early in your stage. That means already our mind has been fixed. Initially our mind was that there is no violence there is no violence with the doctors. Now the sentence is like that, you are experienced very early. That means our mind is already has understood that we are going to experience the violence in one or the other day in our life. So that has been already, that has been told by my senior, and after that, it took me almost 5 to 6 days to come out of the situation. Thank you.
So I think we all were laughing, but imagine sir's situation when you are actually in that position. Yes, I think the solutions will be answered in the coming sessions. So now, Karthik sir, ICUs, I think, are the second most vulnerable areas for violence or aggression after EDs. So, in ICUs, what are the situations that can escalate to violence?
Very good afternoon, respected chairpersons. First of all, we need to understand most of our patients who are hospitalized to ICU are pretty sick, and violence is predominantly created by family members. We need to understand most of these families are in significant distress. They're in stress, they're in pain, they're in grief. Naturally, even the trivial triggers can fuel to violence. We strongly believe communication is a fundamental key that can sort out most of these conflicts. A poor communication between medical staff and families is one thing I think so which we'll have to stress upon. I focus here on empathy, not being empathetic, not spending significant time with families, not listening to them, not truly perceiving their emotions and feelings is one of the most important factors. You ignore them in our busy schedules. Most often, we utilize medical jargon. It's not how much we know, it's how much the families have understood regarding their current condition, overall criticality, prognosis, and action plan, which is very, very important. I stress one more point here, anticipated consequences. Example, a patient who's been hospitalized to ICU with severe cardiomyopathy. Family's perspective, patient is stable. He's eating, he's stable. And the next day, this patient is having sudden cardiac death. Irrespective of the incidence of anticipated consequences, a clinician must mention what the consequences are anticipated. Example, AKI. We'll have to mention there is certainly a possibility of progressive AKI and the need for renal replacement therapy. Anticipated consequences, stressing is something I think so which is key and fundamental aspects of communications in ICU. Dynamic developments. A clinicians and the team should have a comprehensive understanding of the patient's course and why a current event has happened and why this patient is needing a new interventions. So this is very, very important. And most often we see families stressing upon external factors. There is a phlebitis, there is a wound, there is a bed sore. So we'll have to precisely mention the not important factors. We have a bigger elephant to deal with, bigger factors to deal with, such as weaning from mechanical ventilator support, weaning from life supports, which are fundamental keys. One most factor which we encounter are disagreement with regard to prognosis and care plan. We often conduct something called MDTs in our ICUs, multidisciplinary teammates, where we involve specialists from various disciplines at one platform, which has been moderated or regulated by critical care medicine. We try to give a transparent picture, holistic picture, realistic chance of survival. We mention and we assess them for decision dilemmas. We gain their confidence, which is most important. So most importantly, I would say it is unclear information which creates a mistrust, right? So a clear action plan and trying to counsel a detailed prognosis is a fundamental key where you can prevent major conflicts and major violences is my perspective. Thank you.
So, sir is essentially telling that communication, counseling, and giving them realistic expectations, maybe sort of giving them our point of view. Yes, because something hidden inside we can assess, but they cannot perceive. That perception probably will have to give through counseling. So, Vineet sir, you receive complaints both from doctors and I think bereaved attendants, relatives of the victims. Yes. So, as a law enforcer who has transitioned from healthcare, what is your opinion on common avoidable triggers, sir, from your experience?
So, good morning to you all. The topic is very sensitive, considering the violence against health workers across the globe is an issue, and more so in India. So, avoidable triggers is not becoming doctor in a lighter way. So, my friends and even both of my siblings are doctors. So, with due respect to what the profession they do, as long as we treat patients and as long as humans have life, we have to save them, and we are at the receiving end no matter what. So certain things which we can avoid by doing, like say, having a better communication. See, each hospital and each doctor have their own limitation, depending upon the infrastructure available and also skill set available to individual doctors. So I think that needs to be communicated well ahead. So emergency medicine, of course, there are 30 beds, 40 beds, and there are 30 doctors. You can only as well treat as many have been provided to you. So you cannot treat, even if your skill set are very good, you can't treat 10 patients at a time. So that limitations and that number, if can be displayed that this is the maximum and already reached, while entering only you will know that okay, it's already 30 up. So I have to wait. If someone says that I have to wait, but for no reason, that you have to wait for what? So doctor is yet to come, then why can't he come? So a lot of questions come. If there is a only one-on-one interaction with the person, say he will not be a doctor who communicates, he will be an attender. So this kind of communication, verbal, non-verbal information displayed right at the beginning. So communication is one thing which I think will help in reducing a lot of violence in the first place. So any rational individual will understand if, okay, the infra is this much, okay, the availability is this much, and also this is an emergency. Say in post-treatment, post-surgery or whatever, during those, I mean like video consents, instead of we are always taking a written consent. So now BNS, the latest changes from IPC is also we can record video statements. When that is universal, I mean like it's accepted across, so even doctors, instead of making a written consent, so now we can have a AV consents, like let everything be explained now to all the individuals, the stakeholders, all the relatives, and that can be done. Then the third thing which I feel very important we have left out is even our history taking, nowhere we mention his economic status. So there is something called catastrophic health expenditure. It is which beyond, over and above that, it feels burden to him. So non-insurance patients especially may not be applicable to a setup like AIG, might be in wherever you go, henceforth in second and third tier cities, where it's very essential to know to what extent a person can afford. So generally it is treated as any health expenditure in a annually is 10% of their annual expenditures. So other than that, 50% is what the regular expenditures and 10% is health related for a family. So based on all this, if that person is already running short of it, so you can directly explain him that this is the situation, this is what is going to happen no matter what. So that communication can be put forth. So I think communication in all these ends is the basic thing. Then second, what you can do is once it's started, what to do? You can prevent to the extent of, I think, is that a part of question as well?
Yes, it's coming in solutions. Yeah. So I think sir, what sir has mentioned here is the most important point of critical health expenditure. Yeah. We used to learn in history taking about Kuppuswamy classification of economic status. We never really understood the importance until we came here. Yes. So maybe understanding the expenditure he has already underwent through, or maybe how much he can, his capacity, then not providing an overarching, facilities to him also may help. Yes. So that's probably one of the avoidable triggers when they receive the patients. I mean, they receive the complaints. Yes. So from here, I think we'll have to involve our Arun Garu. Hi, sir. So from a neutral perspective, I think this is the elephant in the room we have to address. Do you think there is a mistrust over doctors, or some over expectation in general? And do you think that this is one of the major factors?
Thank you. Before that, I just wanted to wish everybody a happy Ugadi, happy Eid, and advance Easter. It's so cool to see all, everybody celebrating so many festivals together. Just to add one point there is, it's the relationship between a doctor and patient is the key for everything. You know, I do not know for others, but today morning my mother went to a cataract surgery. So I had to call the hospital, one doctor who I knew, and then told him, you know, my mother is there, can you please take care? You know, so the relationship between a doctor and patient connects a lot of dots. In fact, if you see on grassroots, I also come work in NGO sector. So we see a lot of home workers, etc. They go first to a medical shop or a pharmacist, and that's where they take a lot of help from. And that's when I think for the last time when they're very critical or in a very tight situation, that is when they turn to the hospitals or doctors to you know, get the solution solved. You know, but I do understand, you know, we've been hearing from morning, and my mother also worked in the emergency care. She was a nurse, so I do have a little bit understanding of that aspect as well. But, you know, like sir here mentioned, you know, how important it is to understand the patient's point of view. I do understand. In fact, today morning I was speaking to one of the doctors, and I said emergency care doctors is one of the toughest thing to be. The lifespan of a doctor in emergency care is very tight, you know, and I do understand all the challenges that brings in. But, you know, but coming from the patient's point of view, you know, the patients come in with a lot of uncertainty, fear, and emotional distress when they walk into the building. And to be honest, I've had like bad experiences when I walk into hospitals in the starting point itself, you know, where the security guy puts you down, you know, and there everything triggers, you know, where you're thrown out, where you put down, and the importance of, you know, patient care starts from there, you know, and that's when the energy rushes come in. I'll try and bring some stats here, you know. They say close to 66% of doctors believe patients expect guaranteed results in spite of, you know, tough situations. But they also say 50% of patients who come in, they feel, you know, they're not given proper information of what's happening. You know, there is no clarity of thoughts. Sir mentioned the word, you know, doctor jargon, you know, so that's how a lot of patients feel. There was one more point I thought I'll also bring in is a survey done in 2020 by Association of Healthcare Providers India revealed patients always feel helpless in hospitals. You know, they are helpless, they're nervous. 47% of reporting found that there was no explanations given. You know, like nobody would go and speak to people. So there is so much of unrest already happening. Okay. There's one more, I'm just going to bring in some numbers before I close. One is a public health foundation in India also found that over 60% of Indian families struggle with medical expenses out of pocket. So they have no money. So when they walk into any hospitals or before they walk into any hospitals, they know they cannot afford the money. And when the procedures are so expensive, they want justice to happen to that. You know, and the justice doesn't happen, then there is a chance, you know, some side of unrest, you know, and we've seen a lot of incidents around that as well. One of the things what even Sajjanar sir in morning mentioned is how is the Google Baba. That's the term he used, and he said, but they say 72% of patients who come into the hospital before they read about everything online, and close to 26% actually get it confirmed by the doctors. So they already assume that they know better, and doctors are not available. So here, you know, I feel both doctors and patients are on the same, you know, trying to address the same issue. But, you know, like a lot of people since morning have said is how communication plays a massive role. But I think there is also a lot of empathy that is required, you know, in the entire building, you know, making people understand that both patient and the family of the patient and, you know, doctors, all of them are in the same boat. I think that is something I want to add, but again, there needs a lot of awareness, a lot of campaigns, lot of things. I think I'll come back to the second question there.
So I think what sir is trying to tell is very true. Yes, even if we go as attendants to some place, we are first put down by the security itself. Yeah. And I think what sir said also connects well with what Vineet sir had said, that critical health expenditure, over expectations, as what Karthik sir said. Yes, from there, I think we'll have to bring some international perspective.
Just one thing, I think everybody expects doctors to be Munamba MBBS, you know, so as you know, that human touch is something a lot of people want. Yes.
Agreed, yes. Venkat sir, what is the picture outside India? I mean, is it as rampant as it is here? In what way it differs? And what are some triggers over there?
Patients don't care how much you know. Patients don't care how much you know until they know how much you care. I just came back from doing 2 full days of communication skills workshops. 3 of the panelists said the key factor in violence is communication. Violence in communication or violence for healthcare professionals is not a media headline. It's a silent pandemic. I just want you to help me do this. Clap for me for 5 minutes, please. Can everybody clap for me for 5 minutes? That's a long time. So if you stop clapping now, what did patients do? In pandemic, they clapped for us in COVID, and in emergencies, they assault us. This is hypocrisy. This is hypocrisy. Now, and what do people call it? All emergency doctors, because they experience violence in the emergency departments, everybody says this is an occupational hazard. I'm sorry, punching, kicking, hitting in the with a sickle is not in my job description. And it's neither in your job description. So why do patients behave the way they do? It's a global pandemic. It's not restricted to India. It happens in the UK, happens in Europe, happens in Australia, happens across the world. And the single biggest problem is because the illusion that communication has taken place. People think, patients think, families think that we have communicated. And we have failed to communicate, failed to meet their unmet needs, failed to meet their expectations, failed to meet their perceptions. Even Dr. Reddy earlier, before the tea break, spoke about how communication and documentation is important. So the key factor here is not about us being as healthcare professionals. It's about how we can communicate and document. So I would really say these 5 things, if you want to prevent or minimize. We can't minimize error. We can't prevent violence. We can't prevent aggression. But if you want to minimize this, I would like you to practice these 5 things. Number 1, communication. Number 2, documentation. Number 3, documentation of the communication. Number 4, communication of the documentation. And number 5, communication and documentation. When doctors are attacked, the society bleeds. I cannot provide empathetic and compassionate care unless I feel safe in my workplace. Empathy and compassion are not the same. Empathy plus action. What can I do to help you is compassion. So I want you to think about this. If you want to minimize violence, aggression in the workplace, I only request you to do these two things. I want you people to connect with your patients with empathy and lead them with compassion. Thank you very much.
Yes, I think we found the mantra for the day, huh? Communication, documentation, communication of documentation, documentation of communication, communication and documentation. Let's practice this mantra and let's see how well it works. Thank you so much, sir. Now, let's move on to the administrative, legal and police lens. This is where our senior advocate, Vishwajanni Garu. Ma'am, are there any laws that exist specifically to address this issue? And are there any state implemented legal provisions to tackle this pandemic of violence?
First of all, a balance must be struck between the relationship of a doctor and a patient. Like earlier speakers have said, it's very true that communication and documentation is a very important part. And as I have also said, in communication and documentation, your case sheet is your Bhagavad Gita, which should contain every minute detail so that any advocate, police, or for that matter, even court can come to your rescue. Otherwise, all our endeavors will fail if you fail in your basic documentation part. There are several laws. Being aware of the laws is very important. Legal awareness is important for each and every one of you. Lack of knowledge causes panic to each one of you. So being aware of your rights and duties and your responsibilities will definitely make you a stronger person to deal with. Likewise, public also should be made aware, where because media is also here, I feel even media plays a crucial role, where we should, instead of having that rigmarole serials where we show mother-in-laws and daughter-in-laws fighting and crying and all this, let us show some important aspects where you will be punished if you treat a professional with violence. More such movies, more such serials or films will definitely impact the audience, because the larger masses spend lot of time watching these movies, these serials. So I think that also will create a lot of difference and will make embolden professionals. Now, when we say professionals, I do not exclude myself, because we as advocates, I don't know if many of you have seen, because it was there in all the newspapers, a recent brutal murder of an advocate on the streets for lodging a complaint or on behalf of a client was noticed. And a statewide bandh was also taken place by all the advocates of the entire state. So not only professionals, you, to the extent of your hospital, they have stalked the lawyer while he was returning from his morning walk, and they have brutally murdered him. So all professionals, you might say that we just put it off as a professional hazard. Yes, these are all professional hazards, but at the same time, we need to know our legal rights. Our awareness will make a little difference in protecting ourselves. To what extent we can protect a patient or a client, we must be knowing. Only then we can be successful, I would say. There are several laws to the common man, laws to the doctors, laws to the advocates. Now, for example, as an earlier speaker was talking about BNS. BNS has several laws which will protect each one of us for all professions. Apart from that, earlier Epidemic Diseases Act, which had come post-COVID, this also will definitely protect you, and Clinical Establishments Registration Act, and all these acts also will strengthen you. Be aware of them, read them. None of you know. Talking in these workshops is not sufficient. Read the acts. They are small acts, small enactments, unlike our voluminous acts, where we read commentaries also and burn our midnight oil reading those acts. You don't need to do that. These are all small acts. Please make them available, or we'll also provide some to your departments. Read them, understand them, and be aware of those of your rights. And then we have state amendments also, where we are lucky to have our Telangana Medicare service persons and Medicare service institutions, which is also criminalizes attacks on doctors and hospital staff, where strict legal action against offenders to deter violent incidents in healthcare settings. Now, many a times these offenses also do not go unreported. And as they were talking, compromising issues, settling the issues, and not taking the offender to task also does not act as a deterrent. So many a times we lodge a complaint and then withdraw it. So I think such things also should be curbed and stopped, and we should take. There are other states also which are Karnataka, Maharashtra, Andhra Pradesh also have such laws and acts which will generally protect them. Now, global perspective, as Venkat Garu has said, there are acts, there are, like in countries like US, UK, they also criminalize violence against doctors and nurses. Some measures have been suggested, and I think they are in place in your hospital, I have been told. Security enhancement, like installing CCTV cameras, employing security guards who are sensitized about the patient's problem. You may be seeing 100 patients, but I am coming to you as an individual patient to your hospital. My problem is a Himalayan problem to me, but it may look small to you because you have treated hundreds of such patients. Yet my problem is a Himalayan problem to me. So sensitize every staff. Your IMS, earlier doctor was talking, IMA is a dumb person, I have made her sit next to me. Now let them not be dumb, let them sensitize them to the problems of the patients. Only when there is a proper patient and doctor relationship, probably such sort of incidents can be avoided. Of course, there are errants, miscreants, I don't deny dispute, but to a great extent, if we can empathize with their problem, probably they can be reduced. And awareness camps, like such awareness camps, where not only the doctors are sensitized, as I have said, public also needs to be sensitized. Holding more such workshops to the general public, move out into the areas, localities. As I have said, TV is a good mode. WhatsApp messages, and educate people and make sure that they learn that doctor is our God. Court is our temple of justice. These two places need to be protected. Unless they are protected, we cannot dispense with justice. So please ensure that such awareness programs are more conducted more often, and doctors are taken care, because to get a doctor, it is almost 10 to 12 years of your life you spend. And how difficult it is to have a doctor in our country, the ratio is also very low. So I think having a qualified doctor amidst us, let us protect them, let us take care of them. And that education, that awareness is also important. And there is a proposal to have fast track courts to deal, or special courts to deal with legal cases. But hopefully the acts under this Protection Act also, we hope to have it soon. And such such courts should expedite the problems and avoid rigmarole procedures for the doctors, so that they are saved of their trouble and utilize their time effectively and constructively in treating patients. And as I have said earlier also, please do not panic. You don't need to panic for criminal liability, civil liability, or a disciplinary action, because it requires the highest proof to bring a doctor for conviction. Thank you.
Thank you so much, ma'am. I think the fast track courts which ma'am has mentioned, they need to be fast tracked soon. And I think your words have been reassuring a lot for us also, yes. Now, Ajay Mishra sir, ma'am has mentioned these laws, but still we see violence happening despite these laws existing. Where do you think the systems are failing, sir?
First of all, I'll start with laws do not prevent violence. First thing, I'm not advocating violence, please. But then, I mentioned briefly in the morning address, speedy justice, fast track courts are in the process of thought level till now, not implemented. So, in the legal side, the law side, we have to learn from other states and at least be equal to that, if not ahead of that. Like I mentioned, in our state, what are the provisions? Imprisonment, fine, damage compensation. Bailable and cognizable, non-bailable and cognizable offense is for most of the states. Kerala, it is ahead of us. It provides for investigation to be completed within 2 months. See, speedy justice can be a deterrent, not a case where it took 15 years to decide. So that will not be a deterrent. Second, for the judiciary, when the victim is being examined, it has to be on consecutive days. Not to see today is one date, after 1 month is another date. That defeats the purpose of justice. Like justice delayed is justice denied. So whatever are the good stories in our country, let us first adopt it uniformly. Let us not wait for the government of India to pass an act. One more thing which is there in the proposed bill of 2019 Government of India, some kind of a funding mechanism by Government of India. See, how that takes shape in practice, that is to be seen. So, first. Second, I will say, from my first point, it doesn't prevent, it only deters. The expectation and reality. Few years back, before Google took over the patient's mind, I was seeing a TV interview of Dr. Shetty. His last 2 lines set me thinking. It was, when the patient comes to the hospital, he thinks his expectation is doctor is God. His expectation, he will cure with whatever problem he is coming, imaginary or otherwise. But then, if the doctor starts thinking that he is God, that is the end of relationship. I am not saying anything against any doctor, but then, today's doctor, in emergency medicine especially, has to not only think about the medical clinical treatment, but also about the stress which the patient and the attendants have come up with. This is not taught. No doctor's fault. But this has to be at least taught through sessions like this and other regular sessions in the hospitals, in the medical colleges, etc. I'll have one final thing. This human relationship, how does it, the ideal example which I can see is of Krishna. Please study his life. Please study how he has dealt with in crisis situations. Not violent situations, but crisis situations. We should learn from Krishna how to deal with crisis situations. We are not taught in medicine. We are not taught in 90% of our education. So that has to be an essential part in the days to come. Soft skills are part of it. Thank you.
Thank you, sir. I think very concisely addressed issue, isn't it? Laws do not prevent violence. Only the awareness of them may act as a deterrent. Yes. So, Vineet sir, back to you. What is the role of police in response to these incidents? Are there any protocols existing to tackle these events when you receive intimation?
There is no laid protocols as to how to curb any violence against doctors as such. But since we are the law enforcement agencies, which is against any kind of violence, so definitely certain things which have been followed for others will not be followed for doctors. For example, we will not arrest the doctors no matter what, because there is a Supreme Court judgment in which it says it needs to be proved that a doctor has conducted, some kind of medical negligence has happened before arresting. So no need to panic if someone registers a case. It's better to hand over the case to police so that they will have a control over the situation, and patients also will be in an expectation that police will do something. So you will have a buffer of police to ease the situation. But as such violence which occurs immediately, I think only the preventive measures at the site and at the incident place and whatever emergency response that happens, rather than having all code red, code blues, let us have another code for this as well. I think that will help, because that will mobilize across the hospital, not just at the incident site. So that alarm should raise across the hospital and people rush towards it to help. Because even in where I did in Victoria Hospital in Bangalore, we used to hear next day that such an intern was hit by so and so kind of attender, or some PG was assaulted. So it was the news the next day in a canteen. It was never the day. So if it is reaching the doctors itself the next day, and totally it will be lost in oblivion for the rest of the public. So this immediate response at the site is very important. So police, what maximum they can do is these things which have been discussed here. I think 5 important things which I have noticed right here, and I would like to summarize. If someone can help me in that also will be fine. First is A, B, C, D, E. So A for awareness. So awareness of how to escape from all this for doctors, and also legal, what will happen if such an assault happens. That awareness needs to be given to patients who are in the waiting room. So such kind of awareness board signals can be managed by management and also by doctors in their clinics. So this awareness is very important. Second is B for behavioral changes. Behavioral changes, whatever that can be given to public, as madam told, through media or whatever community programs or such seminars across if the listening, see, doctors have not filled this. That doesn't mean semi-educated or uneducated public may not. Why would they be bothered about doctors? So that's the second thing. So behavioral changes for doctors, how to be empathizing, and how to, there should be a set rules how to conduct medical examination. Then that medical examination is not just the steps that he or she following. There should be even video, audio recording of things should also part of it. So behavioral changes for doctors as well is very much important. Then C and D, I think our one of the panelists clearly mentioned the communication and documentation. So communication of documentation, documentation of communication, well explained beautifully, and A, B, C, D is done. So E finally is empathy. Let's have empathy. What happens is, you see that crowd, unruly crowd, fine, that's really bad. That's as rightly mentioned, violence and doctors itself, the society bleeds. Of course it bleeds, and even society dies if it continues. But the other half of the story is when they come and when we analyze, n number of injustice, whatever the pent up frustration is let out here. We become the soft targets. Doctors are the soft targets. They don't have similar kind of things to go against any system. See, any violence and doctors is a systemic failure. I think that we have discussed in length, which we don't have time here to discuss. It's a systemic failure. But that frustration is let out on one. That is doctors. Doctors are soft targets. So that entire, we cannot, totally any violence cannot be substantiated. But empathy at the beginning itself will reduce a lot of violence that's happening. A newborn, they would have waited for 10 years to have a baby, and that newborn dies in a ICU. He creates some panic, he damages property, hits one also. Good, that's really bad. That is one half of the story that he has hit, that is bad. The other half is this, that He's been waiting for 10 years only to lose a kid there. So when we see in this part of the circle, I think somewhere empathy at the right in the beginning will help, and knowing that how people have come there, I mean, with what background, I think more time needs to be spent in empathizing with them, connecting with them. So C also start by connecting with them, connect with them. What background they are coming from, what do they expect? So communication helps in everything, not just legally. It helps you even in the further course of the treatment as well. So empathy and also emergency response with whatever lights, whatever alarm, whatever we want to do across your own hospitals and stuff. So where other security people also come, police cannot be there with a given number of men, we cannot handle the situation, because in Madhapur zone itself, we have a force of say 700, the population is more than 1 crore. So we'll not be able to go each and every nook and corner. So there should be a specially trained security people in such a case. They are deployed. They can be at the Bay Area waiting for such a thing to happen. God forbid they shouldn't get any such opportunity. But if at all, let them be deployed, and they shall take proper procedure. SOP shall be laid out that immediately a dial 100 is drawn, and these security people will be deployed there, contain the situation, rescue the doctor, and whatever maximum damage control can be done as a first responder. I think you can add as a F as well. I think with ABCDEF,
yes, sir.
I think we can rethink and customize to your own setups and able to contain and also curb it, but totally it requires entire system to work towards it totally in such a way that when they think that we are not gods, we are humans. We have our own relations, we have siblings, we have kids, we have other part of our life too. So whatever we are doing, we are mere professionals. So back then when they were called God, there were the times where that also we have discussed when they were called gods.
Yes.
Now let's be treated as humans, that's good enough. Not to hurt another human is a basic tenet. Let them follow it. I think we can curb as well prevent it. Thank you very much.
So if I ask emergency physicians here what is ABCD, I think from now on you can change your definition. Yes? Awareness, behavior, communication, documentation and empathy. Of course, while doing the airway, breathing, circulation, disability and exposure. Yes? Thank you for that second mantra for the day, sir. Now, let's go to our first response. Okay, we are coming to the end of the discussion here. Ratna sir, what institutional protocols do you think must exist, sir?
So, protocols, right. So when we talk about protocols, I will tell you the harsh truth and the sad reality. When everybody started training, they will be trained and they will be told that the relation is always a fish and water. But the sad truth is when we start our careers and everything, we realize that it is many of the times it is like a fish and fisherman, right? But I'll tell you one thing, when the patient comes, if you don't communicate and document, then the next thing is the attenders will definitely communicate with you, and the police will definitely communicate and document. The law will communicate and document. So let's stop at the first part. Let's communicate well. Let's document well. First thing. Second thing is knowing our limitations and setting the rules. I think everybody is into the, the real estates and investing and everything. So Adam Smith, who started the governing dynamics, which the world is running now, Adam Smith said, everybody should have a set rule and a set goal, but incomplete. Now, Professor Vivian Thomas and Professor John Nash, they completed it by saying that everybody should have a set goal and everybody should have a common goal. Like, whenever we receive a patient, we need to have a common goal that we have to resuscitate this patient, set maybe a glory death or maybe a discharge, a definitive discharge. But this role plays and this team should include from the doctor, from the nurse, from the attendant, everybody should be a game player. We have to communicate, we have to mingle with them. And second thing, most important thing is, we have to make an SOP, starting from a smaller thing to a bigger thing. For example, in our department, facing a little small issues and bigger issues, we have an SOP when to allow a patient to even to a bathroom also. So a simple thing can escalate into a bigger thing, and a bigger things here are always a much bigger like a volcano. It can erupt at any point. So knowing our knowledge, setting a set principles, having an SOPs, good communication, better to the best documentation will avoid everything. And after doing everything, if something goes wrong and something goes right, let's not panic. Let's have the things controlled. Let's go with the management and let's control the things.
Thank you so much, sir. I think in our institute, we also have something called Code Violet. We announce it if we face the, the threat of violence also. Maybe even that, having in institutes where it's possible, where it's feasible, employing search can probably help curb violence also in there. Thank you so much, sir. Now, Rohan, sir, I think one more challenging question. Do you actually have support systems when things go out of hands? And the challenging part is, do these systems actually respond in actionable time?
Sharath, actually you are making me to remember my olden days, where my incident is, you're triggering my incident again.
I think I'm doing that to everyone here.
I think it is helpful for everybody also. It is actually a good thing. Support system, right, you were talking?
Yes.
In our MBBS and everything, we always study about there is a theory, there is a practical, right? But once you come to the reality, what we do, theoretically it is correct, practically it cannot be done. The same thing, the answer to your question is, first thing is, as theoretically the support system is there, yes, definitely the answer to the question is yes, theoretically. Practically, in a real time, if you say, the answer is no. You go to any hospital and ask, you have any security system, they will say definitely yes. But if you haven't experienced this violence, the answer should be, the answer for that is real time no. You know, by the time we are discussing here, how many percentage of the doctors are faced violence up to now? As per the data, I mean, like, it's not my own data, it is an IMA, it says 2023 recently, 75% of the doctors already faced the violence. Okay, in that I am also there. Okay, 75% of doctors already faced the incident, violence in their life. So for the support system, if it comes, yes, the answer to the question is theoretically yes, practically no. Practically, I will talk about the same incident which has happened to me only. The thing is that when the incident is happening to me, the security person was there. He is there definitely, he is there. He is also just seeing to me. And you know what is the age of the security person? Almost is more than 70 or something. What he will do actually? So for the easiness, I will divide this into the before the incident, during the incident and after the incident. Before the incident, the thing is that everybody talking about the protocols and the implementation of the protocols. You know, as per the IMA data, only 20% of the hospitals in India are having the only protocols about the how to mitigate this violence. Remaining 80% there is no protocols at all. Then how do the support system comes? So you have to think about wherever the hospitals you are working, you have to go and think about whether the implementation of the protocols is there or not. So before the incident, I have talked about the security. The security who are present, we know that the age and as well as the security who are present also, they are not trained enough to manage the violence which is happening with the doctors. They are trained only to watch in and watch out, not for the violence happening, what to do in that situation and all. That is the first thing. During the incident, I told, what is the most important thing? Protocols. Where is the protocol? There is no protocol, then where there is no protocol, then how do I activate? There is no support from my side. There is no support from any side. And if it is an after the incident, there is the most important thing. You know, after the incident, the thing is called blame game starts. I will be going and sitting in the room, I am thinking myself that I am emotionally, I am already upset. The administrative part will come and they will say, sir, I think this is yours fault, I think. The blame game starts from there. Do you think the support system exists? I don't think the support system exists. In some of the things, maybe it exists inadequately. That is the first thing. And at the same time, if some of the person, if the person is not having the support system in hospital, he will go to the family and all. Sometimes if the family also not supporting them, then you think about him, how actually is going to respond. And I mentioned that 80% of the time there is no support system, right? 20% there is a support system. I will give the example of myself only. I worked in AIMS New Delhi. In the AIMS New Delhi, there is a thing called as a quick response team. There is a rapid response team. You know what they do? When I start my duty, I am the team leader for the shift. You know what they will do? They will come slowly. You know, they have a separate dress code. We used to call them as the bouncers, but they are actually the rapid response team. Separate dress code will be there. They used to come when the shift starts, and they used to come and speak with the team leader that Dr. Rohan sir, myself, this, if anything is there, you can call me. And they used to make the rounds every 20 minutes. They used to go and they used to come. Rohan sir, I think this is the area I'm thinking that something is cooking up. I think we have to take care of that. So this is the level actually the security system has to be there. They used to come with us. They used to stay with us. They used to do the rounds. The strengthening of the security should be like this. This is an example, the 20%. I was also worked in the 20%. So this is the way actually the system should be there. And the emotional support. Because there is no protocol, there is no rule of the emotional support. If the protocols are there, definitely automatically the doctor will come to the emotional support, right? There is no emotional support, there is no mental support. So for me, if you are asking, theoretically yes, practically no. Whoever the hospitals, wherever it is having, yes, some of the hospitals definitely they are following the protocols, and their protocols are strict enough to make the aims. There is an emotional and as well as the mental support programs also. New Deal. So everything structured in a frame that if something is happened to the doctor, they have been taking care everybody. I am telling, whatever I am telling, this is from the practical experiences. I am not a theoretical person, first thing. And these are the doubts actually everybody is having in the minds of young people who are sitting in front of me. I am speaking whatever you people are thinking because I was also faced the issues, the same thing. So I think the answer to the question, I mean, like it has been justified.
Yes. Shortly put, theoretically they do exist. Practically they are over 70 years. Yes. So yeah, to answer all these questions, let's quickly move to the solutions. I request the panelists to be quick in their answers here. Ashma ma'am, are there any NMC guidelines or SOPs, or what does the NMC say about training doctors in these aspects, in be it de-escalation or tackling violence?
NMC already has started those programs which are under ADCOM. The point is that I got trained in ADCOM after becoming professor, after almost 19 years of my job. But today my daughter who joined MBBS, in first 1 month, every MBBS student is getting understanding ADCOM, that is all about communication, ethics and attitudes of a doctor towards the community, towards their peers. So I am sure that this would, as it will grow, it will be helpful. Apart from that, at individual level, I want to say it is the performance which matters. Performance, not protocols. That is the new mantra. Though protocols will help you, there is no doubt. But that when the violence will strike, it is your performance, which will be obviously based out of some understanding of it. So the mantra in resuscitation is now performance, not protocols. I look forward to if that also would be something to look out for in the case of violence, code violence. Now in code red, it is there. Thank you.
Yes, I think existence of protocols also only are justified if they are performing well on the field. Yes, that is what ma'am is trying to say. And yes, now it is clear that NMC does have a guidelines. And if you go through their requirements for training of emergency medicine, you will also see sessions on de-escalating, tackling violence and all. Thank you so much, ma'am. Karthik sir, now to you again. One idea I got when I was making these questions, most of the patients say they are not allowed adequate time in ICUs to visit their kith and kin. So do you think relaxing the strict visiting hours in ICUs can help curb this aggression? And how do you balance, if at all you can allow this, with the ICU protocols?
As I was mentioning, along with poor communication skills, restrictions with regard to visiting hours is again one of the factors that can precipitate violence by families. Having frequent visiting hours by families may provide emotional support to the patients. It reassures families. But however, on the flip side, you have breached infection control practices. No matter how much you train regarding ICU etiquettes and hand hygiene, sick patients, vulnerable patients, immunosuppressed patients are at risk of secondary infections, and compliance to hand hygiene by families cannot be maintained. One good factor is, by frequent visiting, we can allow a real-time communication between families and medical staff, allowing families to express their concerns and grievances very often. But on the other side, it poses emotional and physical strain to the medical staff. You need to give constant explanations. You need to meet their demands constantly. In the Indian ICU context, we strongly feel, relaxation of visiting hours may not be possible. But however, we can strike a balance. We can have extended visiting hours, though it controlled. At all our ICUs, from ICU 1 to 5, we have 1 hour of visiting hours in the morning, and it is again spaced in the evening. So, by having extended visiting hours, though it controlled, we can allow family during this time to express the concerns. And in the same time, we can expect the families or we can expect the doctors to engage with the families more to clarify their grievances. And we can think of having alternative modes of communications, such as video calls or telephonic requirements, I think, to meet out restricted visiting hours. And this has to be dealt on case-to-case flexibility, because someone who is very sick on multiple life supports and who is unstable, of signed end-of-life care, you cannot say that we have a very strict visiting hours. We may have to customize this policy a bit, and we may have to deal and have more counselings, and we may have to relax in these policies to prevent violences. One more factor, I think, so which can support such scenarios is having a family liaison officer. When I was working in ICU 1 for sick patients in cardiology, we had physician assistants who constantly engage with the families and try to bridge the gaps between the patients and families, which a doctor cannot do constantly. So, couple of solutions in brief or key takeaways would be, if possible, a family liaison officer, having a flexible scenario for sick patients, engaging more counselings, especially the ones of signed end-of-life care, and having an extended, though it controlled hours, and having alternative modes of communication strategies may prevent violence, though we are not relaxing on our policies, would be my perspective. Thank you.
So relying on mental presence rather than just physical is, I think, the gist of it. So one last question, I think, to Mr. Arun Garu. Sir, we often do see an ant-sized event blown into an elephant-sized sensation through media. That is a reality, yes or no? So what do you think is the role of media in sensitizing the public and healthcare personnel?
Yeah, it's a very sensitive question, but just to add a point there, any story, that is reported can either build more understanding or can create fear or distrust among people. It's how you report. Of course, media plays a massive role in terms of education, how they educate people. Like, for example, during COVID time, there was a report by WHO which said after the articles that were written by journalists, they said 30% of vaccinations picked up. A lot of people started taking vaccinations, and also there were a lot of highlights of patients' recovery. What all was good things were being written about, built more trust in hospitals or doctors or medical care, etc. But as a I've done crime reporting, I've written about health, so I have done both of it. I've written on educated materials. I've also written about incidents which were very hard-hitting, which needed more attention. So one of the things role of a journalist is also to highlight patient struggles. How can we create that opportunities for patients to get right help that they require? Some things like, hospital overchargings, like medical negligence, accessibility issues, etc. Like for example, if you've seen during COVID, there was this oxygen concentrator, oxygen less availability. And when media started to write about it, governments took a role and started doing. But I do agree that, there has been sensationalizing of issues. Where the focus should have been more on infrastructure issues and policy makings. I think individual targets have been, a major problem, and that is something a lot of people, a lot of people read centralized, when everything becomes blown up, it's how we react to it. I think that is something that we have to do. There is one thing I want to add is, there's this major gap that needs to be built between hospitals and journalists. There is a nice example of National Health Service, NHS. What they have done is they've partnered with journalists and worked on how together they can bring out some massive awareness sessions on implementing various issues. I think one of the requests, here I would want to encourage, the massive doctors here, big hospitals, is work with journalists, do campaigns that can bring out right information out so that right message comes out. Second, work with NGOs. Also, because we forget the amount of role NGOs play, the amount of grassroots interventions that they do. I represent both. You can come partner with me, but I think that will bring down the centralization of how we can address issues. Yeah.
So essentially, what sir is telling is, media is like a gun. It can be in criminal's hands or Vineet sir's hands. Yes, so I think doctors are like Vineet sir here. So utilization of it more, I think Vishwajani ma'am had also emphasized on it. Awareness, yes, through media, that's how we can use it. So I think there are, of course, more questions, but the answers have already been given through other questions. So I thank you all. It would be really unfair if I don't take questions from the audience here. So, but in the interest of time, let me just take 5 questions. Yes? Yes. You can ask me, I'll paraphrase. There's no. No, it is. I know it's lunchtime, but the topic we are discussing here should be justified and be given justice. So
yeah, sorry.
I
just wanted to ask the panel why. I mean, it's not a good comparison, but we see doctors and the police both are the first responders. Both are considered as first responders, but we don't see as many policemen as get assaulted by the people as the doctors are. The thing here, I think it's a point to question that, like sir said, A, B, C, D, E. The E is not empathy. The E is empowerment. We have to empower the doctors. If a person is coming and hitting the police with what kind of laws he had, he will not think of assaulting the policeman because he knows what will happen if he touches the policeman. But he should also know that someday a doctor is also empowered and powerful so that he should not touch the doctor.
Yes.
So that kind of empowerment should be provided.
Okay, so that's more of an opinion than a question, but essentially what he's telling is we also have to become policemen. Yeah.
It's not proper for him to.
Sir,
I'll only
before
say,
you
no,
answer.
no, just do that. Huh? Say, I am not countering. Few decades back, I was in service. I have seen 11 policemen killed in one action where I was the collector. See, so it's not that, see, there are phases, I'll put it. Today, why less policemen are being assaulted or something? Because of different measures being taken up. But then, and it was in the run-up to elections in 1994, I'm pointing it out, in Warangal district, 45 people were killed in 1 month. And then the challenge was for the police to conduct elections also. So I totally agree that, see, it should not be there. How they can be empowered, we should discuss ways and means for that. See, that will be more effective.
One point to add, as we speak, one of our ACP, he is 55-year-old, he got injured in one of the students, that issue that's going on HCU. Most of us will not be aware what's going on in HCU. Right now as we speak, he got injured, he is being taken for X-ray and he got ligament tear. So it's not that we are at the brunt of it, we take it and we have things to give it back. As sir mentioned, in number of professionals who have died, I think police the most. Even Naxals, when they targeted, even if you take the history of Telangana and erstwhile Andhra as well, lot of police have martyred, and same across the country as well. But anyway, sir has answered a lot of my things. So with due respect to whatever the frustration within us, when we feel helpless, it is there. But there are certain agencies across the government where they are meant to do certain work. So empowering doesn't mean that doctors can hit back, give them a gun license and give them a license to kill. That can't happen, because that will throw entire system into chaos. So rest assured there should be some protection, but how and why, that's why we are here, and at the policy level also that can be done. And I think with more civilized society, I think we would definitely bring it down. It takes a lot of efforts from both ends. It's a trust deficit and we have to bridge it at both ends. People have to understand, empathize what doctors are, what they are going through. And rest assured, with increasing number of colleges, each family will have a doctor and soon they will know what is the pain of a doctor. That's one. And second, there are certain things which we, I think, didn't discuss as of now. And the third E you can say is also ethical practice. What I have shown, I mean, in second 2-tier cities, there is another doctor blaming the other doctor. Oh, had you come to me, I would have operated well with this nail or imported one. You went to him, that's why it has happened. After 2 days, they went and assaulted. So there are certain things which we as a community, what we can do within our hands, and over and above that, whatever needs to be done, I think together as a society, we can stand with shoulder to shoulder each other and protect each other. Thank you very much.
Vamshi sir, your question. Yes, ma'am.
I'm sorry, I'll just add to this ethical practice, what I was talking about. I was telling when a criminal liability can be fastened against a doctor when there is a report from an expert committee. It is again you doctors who certify against another doctor saying that there was medical negligence and there is fastened a criminal liability and civil liability. So just be cautious while you're doing that.
Thank you, ma'am. Vamshi sir, your question.
Well, sir, my suggestion is connecting all the dots. As my beloved colleague Dr. Nayan has mentioned about E for empowering, and Mishra sir, as you correctly mentioned about E and empowering. But connecting all the dots, how do we empower? People, the layman, before he assaults a doctor, he doesn't think. But when the same thing, when it comes to IAS or IPS, he thinks. I wish we had something like IMS, Indian Medical Services. Maybe we can take this as a suggestion. Wish the more policymakers involved in this and empower us doctors regarding making something like IMS, which acts as a protective shield against us.
I'll just say, no. When I was 30 years of age, working here as Additional Commissioner Municipal Corporation, I had many friends like him sitting next to me who could come to my rescue in 5 minutes. I'm not joking. Once I had to go to a colony. I was in charge of raising revenue in municipal corporation. In the evening at 5 o'clock, I was gherraud by 50, 60 people in the colony. Fortunately, I was not physically assaulted, but less than that, everything was happening to me. I did not call the police even though my driver was insisting. I was under gherao for 2 hours. I only tried to communicate with the crowd to the extent possible. So, see, police can come, but then in 90% of the cases, if you see of violence which have been documented, Can the police come in 2 to 5 minutes of the violence happening and being over? Very difficult, any place. So it is a deterrence which has to be put, awareness which has to be put, and that takes much more effort. And then the response of the doctor, bridging the gap between expectation and reality, trust. See, these are difficult tasks to be performed. They are the essence of future where, see, the physical acts will become less and less. So, see, let us focus. Empowering means empowering what? See, that is what I'll ask all of you. What do you mean by empowerment? And then you only tell whether it is feasible or not, whether it is practical or not, whether it is functional or not. In view of thousands of medical establishments, institutions in the state and outside. So the difficult part we have to address and continue our efforts for that.
Like sir said, within seconds, I don't think any human can respond. But I think stringent laws and public being more aware of it, you know, that will probably strike some fear before the public attempts anything. Yes. Any more questions?
Thank you, sir. Having taken all the measures in order to prevent attack on the doctors, even though media's role doesn't come actually in the picture, but more or less on every part, what we see on the TVs and other electronic media, I think everyone will agree with my views that electronic media, they should play more responsible role in controlling not only attacks on the doctors, but in every aspects of problems of societies. Thank you, sir.
Thank you so much, sir. I think we can conclude the discussion here. You have a question? Okay. I think this will be the last question.
Good afternoon, everyone. As a young medical professional, when some patient attenders are assaulting us, can I have the chance to fight back as police are there and legal judicial ma'am is there? I want to clarify that whenever the attenders, a mob is gathering me, if I can fight back, can I fight, or just can I defend, only defend?
Yes. I think your question is understood. I think self-defense is not a crime, and I think yes, right to self-defense.
Can I?
You have a right.
You have the right to self-defense. Vinit sir, I think he'll be better to answer.
Yes, ma'am. There is a right to private defense. You can defend yourself. But is it? I mean, like, of course, if someone is holding a knife at your neck, definitely you will kick back, right? So in that means, if he gets hurt, well and good. But if he's hitting you, you take a knife and stab him.
No. So not to that extent.
So you don't know in that panic situation what we do, and nevertheless that will be taken after the trial only, whether it was done, but you will be booked for murder and you will be taken to jail. You have to endure everything. Only in the court of law, with all the relevant evidence, it will be declared, yes, you did for your self-defense. So until then, you have to bear all this.
Yes.
So
I think
further after that in trial, I think ma'am can.
As we learn, like we have all sympathetic system, either to fight or flight. All the doctors are trained to defend and flight away, escape from the thing. Can we? That was my question.
Yes, I think that has been answered well.
And in this time period, till the legal thing clears you off, you will not be getting your promotion. You will not be invited as an examiner. You will not be able to leave the countries for conferences because ICMR and IMA will not support you. So keeping these things in mind, the government officials, doctors, are always very worried. Many of my colleagues who have worked, I can see them sitting in the audience, and they know what is the most worrisome for us is to call police into the picture. That is the most worrisome, part in that is the truth. I would say that to call police into it, because having an FIR signing over there would be, truly speaking, a headache to carry forward. More easy would be talking with you, giving you a small 1-day leave, making you a little more happy. I'm so sorry if I don't resonate with your expectations, but once you do that, it is definitely difficult for government doctors.
I think this is where the fast track courts will help us, resolve these issues as soon as possible.
No, until proved guilty, everybody is innocent. But what Madam has said is also right. I don't know if how many of you know of it. A recent case in a petty offense, some doctors were booked, and the fear was they are from outside state and they had to leave the state. And they had to carry this tag of the case there, and their fear was, will I get a government job? Will I be entitled to promotions? Will I be offered a job in the first place by another hospital with his backdrop of a FIR filed against me? It is true, there is a fear, all this will be curtailed. But as we have been saying, of course, standing in the bank saying that you have to fight, you have to do this, you have to do that, is all good. But having your documentation and your awareness in proper place, only then please proceed. Otherwise, as Madam has suggested, which I should not be saying as an advocate, you can proceed.
Always prevention better than cure, yes. I think we'll take the question in the lunch session, if you don't mind. Yeah, because of course they'll have their lunch. So I request the panelists also to take 1 or 2 questions in the lunch session. So thank you so much for joining us, and I really thank all the panelists for putting their time and effort. Over to you, Dr. Nitya.
I think that was a wonderful session, and we're extremely grateful to each one of our panelists over here for joining us today and having this extremely engaging session with us. I would like to request everyone to please wait for 2 minutes before we start lunch. I would request you all to please be seated. We have a small announcement. And before that, I would like to invite our COO, Mr. Kepri Jalota. Sir, if you could please come over and present mementos to our guest. Thank you for being here with us, sir, and thank you for all your help with this event. And I would like to request sir to present a memento to Dr. Ashima Sharma. And sir, I would like to request Kepri sir to also present a memento to Ajay Mishra, sir. Memento to Vishwajanani ma'am as well, please. Thank you, Kepri sir. I now request our senior consultant in the department, Dr. Vamshidhar Gupta, to please come and give away a few mementos. I would request sir to give a memento to Dr. Vineet Garu, IPS. Sir, could you also please give a memento to Dr. Ratna, sir? Thank you, sir. I would now request Manohar sir, one of our senior consultants in the Department of Emergency Medicine, to please come over and give a memento to Dr. Rahul Rohan. I also request sir to please give a memento to Dr. Venkat Kotam Raju. Thank you, sir. I now request Dr. Sirisha to please come over and give a memento to Dr. Karthik Ravikanti, please. I would also request ma'am to give a memento to Mr. Arun Yellamati. Thank you, ma'am. And I would request Capri sir to please come over one more time to give a memento to our moderator, Dr. Sharat Chandra Uppaluri, please. Thank you all very much, and once again, we express our heartfelt gratitude to each one of our panelists for being here today and gracing this event and making it so engaging and wonderful. Thank you very much. Can we have a huge round of applause, please? Thank you, everyone. We now have with us Dr. Haripriya Challa, a senior consultant in the Department of Infectious Diseases in our own hospital, and she has a little announcement to make. So I request everyone to please be seated for 2 minutes.
Yeah, I won't take much time before your lunch. This is from the Department of Infectious Diseases. I think most of the crowd is medical crowd, I believe. So we are having a conference on 4th, 5th and 6th. 5th, 6th we have conference, and 4th we have pre-conference workshop. This is basically infectious diseases and pulmonology. So I request all the medical person here to kindly register themselves and spread a word that there is such a conference here. It will be held in the very same auditorium on 5th and 6th this coming weekend. It will be dealing with infections related to respiratory medicine, right from TB to immunocompromised transplant host. We have great speakers and faculty. We have Dr. Randeep Guleria, who headed the country in handling pandemic COVID. So there will be very interesting sessions gonna be. I request everyone to spread the word and please register yourself for this upcoming conference. Thank you.
Thank you, ma'am. And we'll now break for lunch. In the agenda, we've mentioned 1 hour, but please bear with us. We're going to cut it short by 15 minutes as we're already running a little late. So we hope to see everybody back by 2:50, please. We'll start our post-lunch sessions at 2:50 p.m. And I request everyone to please come back because we have very interesting sessions post-lunch. Thank you all. Hello and welcome back to all of you. I hope we're all well fed and happy right now. And we'll move on to our next session. And for this, we have a very special speaker with us for a very special topic. The topic being legal and ethical dilemmas with emergency treatment, payment and consent. This is something that almost all of us have faced in our clinical practice, where patients have so many issues when it comes to payment, when it comes to consent. And to throw light on this, it gives me great pleasure to invite onto the stage Dr. Vemula Anjani Priya, who is an assistant professor of trauma and emergency at AIIMS Mangalgiri. Madam has taken the trouble of coming all the way from Mangalgiri to be with us here today, and it is my honor to invite her onto the stage to address us.
Good afternoon, everyone. I am Dr. Anjani. I am Assistant Professor Trauma and Emergency Medicine from AIIMS Mangalgiri. I did my post-graduation from Narkitpalli Kamineni. Today I am here to discuss about legal and ethical dilemmas with emergency treatment, whether consent is first or treatment is first, and payment is first or treatment is first. So just going through the basics. First, consent. What is consent? According to Section 13, Indian Contract Act 1872, when two or more persons agree on same thing in the same sense, it is called consent. And medical purpose consent is described as grant of permission by patient for an act to be carried out by doctor for diagnostic, surgical or therapeutic procedures. So when we are discussing some topic, we should know why are we discussing about it. So Code of Ethics says that adult patient with decision-making capacity has right to accept or refuse the recommended health care. So as physician or doctor, we have to respect their choice. And consent, so here the consent demonstrates a physician's respect to patient's right to make autonomous decisions. Informed consent has both ethical and legal requirements. So it is must to know the importance of consent. So generally talking, consent is of 4 types: implied consent, express consent, informed consent and proxy consent. Can anyone say what is implied consent? I'll give an example. A patient is coming to you, he has registered OP sheet saying that I want to consult so and so doctor. Is that a consent? Yes, it is a kind of consent. It is an implied consent. He is willingly coming to your registration counter and getting the registration done so that he is going to get examined by you. And suppose patient coming and sitting on the examination table, on dental examination table, his actions or circumstances suggest that he is indirectly giving you consent for examination or treatment. And next is express consent. This is a direct agreement, whether made verbally or written, for undergoing specific treatment or procedures. Where is this applied? In our daily life, when we are taking blood investigations, when we are giving injection, when we are examining the patient, you just tell them that I am inserting an IV cannula, I am going to collect blood. This is all express consent. Here we are not writing anything, but verbally we are telling them and patient is accepting it. And now coming to the informed consent, which is the most important thing. And in emergency, this is most of the time important consent which we take. And this requires a patient to be fully informed about the procedure, what you're doing, risk involved in it, benefits. If patient is not accepting, you need to explain them out to the alternate procedures and who is doing it. All these should be informed and documented also. Documentation is compulsory here. And proxy consent. When a patient lacks capacity to take decision, a legal guardian or representative will take decision on behalf of him. This is proxy consent. And when you are taking proxy consent on the OP sheet, if patient is not there, you need to write that it's a proxy. That patient is not there, only attender is coming. So coming to the key elements, when is a consent valid? First, it should be given freely. It should not be under force by someone, or patient should not be under influence of substance or alcohol, anything which impairs his consciousness or saneness. So voluntarily given, that is freely given, and patient should clearly understand for what purpose he is there. Example, a patient is there, you want to insert central line. You're telling that I'm going to insert central line, sign on this paper. No, he is going to sign, but that consent will not be valid because patient does not know what is central line. You need to clearly explain him what you're doing, what are the risks in it, why are you doing it, and are there any alternative procedure, and document it. And whenever the patient is giving consent, he should be in the decision making capacity. And I'm going to discuss about the decision making capacity in the next slide. Next, coming to the documentation. Documentation should be very clear, who is doing it, and the sign everything, agreement should be very clear. And factors for emergency providers to consider when whether the decision making capacity is there or not. First, check whether the patient mental function is normal or impaired. If impaired, that means patient under the influence of some substance or altered consciousness because of the medical condition or something, and presence of normal mental orientation, that is awareness, orientation, memory, and attention. And patient should understand the specificity of treatment related issues, and check whether his complex decision making is good or not. If any one of this is not good, that means the consent will not be valid. And consent is always reversible. He can withdraw the consent any time during the procedure. One more thing in the consent is language. This should always be explained in the understandable language. Coming to the topic emergency department and consent, whenever the patient is arriving in the emergency department, he is generally giving consent for treatment. Under general consent, all these things are covered. That is history taking, standard examination, routine basic procedures like venipuncture and ABG, arterial blood puncture and analysis. But any procedure which is involving risky and invasive procedures, all these general consent does not cover all these. You need to take informed consent for this. Exception for this informed consent in healthcare situations, that is when there is medical emergency or public health imperatives or doing research in emergency or acute care, and loco parentis. I'm going to discuss each of this separately. In these all these four places, you don't need to definitely have informed consent before or consent before. We'll see why it is like that. In emergency situation, here indirectly the implied consent application will be there, because in an emergency, when a patient is unable to provide consent due to their condition, emergency provider can proceed with life-saving treatment. This assumes that a responsible person would agree to the treatment if they could. So if he was in normal condition, he would have given you consent. So taking this into consideration, we will go forward with the life-saving procedures or treatments. And during the treatment, if the situation becomes better, he's coming to the normal consciousness, you can take the consent and proceed for the further treatment. When patient is in emergency, but he has time to wait, situation is not that emergent, then you can wait, find a decision maker like spouse, adult, any adult child or parent who can give consent in place of him. You are waiting and you couldn't find anyone and the patient condition is deteriorating, then you have to do whatever is best for the patient. So in emergency, implied consent, example, you have received a patient to emergency department who is unconscious. He gives the history was he was hit by car and he has many internal injuries, and after assessment you realize that it requires immediate surgery. But patient is not able to give you consent and relatives are not there or guardians are not there. So here the healthcare team proceeds with emergency surgery as it is assumed that a reasonable person in the patient's position would consent if life-saving treatment. If he can give consent, he would have given. So, but because there is no one, you'll carry on with the life-saving procedures. During the procedure, if patient comes into consciousness, then take a pause, take the consent, and carry on with the rest of the medical treatment. This demonstrates how implied consent allows critical interventions to be made in situations where delayed treatment could result in harm or death. So whatever you're doing in good faith to save the patient, to reduce the morbidity, that is always considered good only, it is never wrong. And when it is involved with public health imperatives, situation where public good may limit individual patients' autonomy. Examples are communicable diseases like COVID or SARS, tuberculosis, or psychiatric patient who was posing harm to the surrounding public. In such cases, consent is not required to treat, and here during treating the communicable diseases and mental law and mental health, the state guidelines should be followed according to the local practices. When patients meet criteria for health department, mandate treatment and quarantine. Example for this public health imperatives, in early 2020s, when this COVID-19 was there, people who traveled from the widespread area who were traveling to India, after landing here, the government has given 14 days quarantine even if the symptoms are not there. This comes under Epidemic Diseases Act 1987 and Disaster Management Act 2005. Here quarantine of 14 days was must for people who are landing in India, and this could curb the spread of virus. Next, coming to the research in emergencies without prior consent. Here Indian Council of Medical Research provides guidelines for such scenarios, emphasizing the importance of, here it comes into deferred consent. If a patient is unable to provide consent during emergency, researcher must seek consent as soon as possible after stabilization. For instance, this could apply in emergency clinical trials of new drugs. Researchers should take ethical clearance before doing this, and public awareness must be created before doing this. Efforts should be taken to give public awareness. Example for this is, if a hospital is there in an area where they receive a lot of snake bites, patients do come in a critical condition or unconsciousness, cannot give consent. Here, considering the emergency situation, the anti-snake venom, if they are developing any new anti-snake venom, they can give anti-snake venom, but ethical clearance should be taken for this. So here the ethical oversight is, the trial will be scientifically valid, risks are minimized and benefits are maximized. So here deferred consent will be applied. And researchers should take effort to engage the community, teach them and explain them that the ASV will be given, so that these people don't create problem after giving the drug. And those are the 4 situations where the consent might not be given preference before the treatment, but there is patient can refuse your treatment in spite of explaining and everything, like informed refusal. Patient may refuse any part of treatment plan, refuse for evaluation, that is clinical examination, and he can leave against medical advice before you do anything. So for this, to avoid all this, check that there is no miscommunication. When you're trying to explain some procedure or some treatment to the patient, if you're highlighting all the side effects, I'll give an example of myocardial infarction. Patient coming to you in window period, you want to thrombolize the patient. If you don't have you're not working in a cardiology center, but you want to thrombolize the case for patient's benefit, you keep on reading all the side effects which happen with the drug and say that these are all possible. If you're still interested, please sign on the paper. He's not going to sign. You have to explain them that either of the procedures will have side effects. Either you go to PTCA or thrombolysis, But whatever best we can do here is this, because we want to save your time. If you try convincing him that way, he's going to give you consent. You reel out all the side effects which are there in the book and say that these are there, no one is going to side. Even if we are there in the position, we are not going to side. So miscommunication should not happen. And address the patient needs. If suppose patient is in pain, try relieving it and then try explaining him. Find alternatives. Suppose he is not ready for a procedure but still ready for admission. Even that reduces the risk of the events whatever happening. So try going on with that admission without procedure, and respect patient choice. Even after trying convincing so much, he is not listening to you. Try respecting him. Let him leave against medical advice, but do document. Other special thing where consent is little bit different, that is loco parentis, situation where individual or institute assumes the responsibility or authority of a parent over a child. This is when you're dealing with child less than 12 years. Here guardian can take decisions for child, and this usually occurs in the school environments, or child left with a guardian. When they have to take healthcare decision, guardian is going to take. This comes under IPC section 89 or BNS 27. This permits a person in loco parentis done in good faith for benefit of a child under 12 years of age, provided such act don't cause any harm. Again they've written such act should not cause any harm to the child. Anything done in a good faith is accepted. Other sections, Indian Penal Code section 90 and 92. Here IPC section 90 or Bharatiya Nyaya Shastra 28 says that consent given under fear, misconception, or by individual incapable of understanding the consequences is not valid. So when you are taking consent, patient should be in full decision making capacity. You have to check whether he is having decision making capacity or not. And IPC section 92 or BNS 30, action done in good faith for the benefit of a patient without their consent. For example, in emergency, when obtaining consent is impossible, actions taken to prevent death or serious harm are not considered offense. Next, Code of Criminal Procedure 1973, section 53. Here, when an accused is got to the hospital and he's a medical practitioner is told to examine, and patient, that accused is not giving you consent. Here we don't need any consent. You can go without consent if the police is getting to you, but few rules are there. Examination should be done by a registered medical practitioner, and the police officer should be minimum of level of sub-inspector. If female accused is being examined, it should be under the supervision of female registered medical practitioner. And scope of this examination would be techniques like DNA profiling, collecting of samples like blood, semen, hair, whichever is relevant to the investigation. This is one which we regularly face in our emergencies. What do you do with the deaths which come to your hospital? Broad deaths. Here we have, I work in a government setup, so people get a broad death and they just want the death certificate of the patient. Is it okay if you give the death certificate without any MLC registration? No. At least place where I practice, any broad death is by default an MLC. Until it was our own previously hospitalized case or treated case, rest of all broad deaths are considered MLC because we don't know the cause of death. Until you don't attend the events of last events, you cannot certify death, you cannot give primary or secondary cause of death. So in such cases, you are receiving, here it mentions only that police inquiry or unnatural death which is coming to you. MLC is not an option, it is compulsory. Most of the time police also don't know that why we are registering MLC, but to be on safer side, it's better if you're suspecting that death or it is looking like unnatural, if you don't know cause of death, you make it an MLC. It is not optional. MLC is not optional in such cases. This is given by Code of Criminal Procedure Section 174. This says only unnatural death, but I think any death should be considered like that. And NABH accredited hospitals, definitely any broad death is by default an MLC until you have previously treated it. Coming to the next one. Yeah, treatment first or payment first. So as a government doctor, I might say treatment is first, but standing in a private setup, if I say treatment is first, money never matters, I think that should not be, because this causes a lot of financial implications on the institute. So let's see what are the government efforts, what are the government's efforts for this. So in emergency situation, always it is legally or ethically it is treatment first. Healthcare professionals are ethically and legally bound to prioritize saving life and provide immediate medical care irrespective of patient's ability to pay. So whether you are in private sector or public sector, anywhere, in emergency situation, treatment is only first before payment. This approach aligns with humanitarian values and is supported by legal frameworks. In India, the Supreme Court has ruled that hospitals, whether public or private, do not deny emergency treatment to patients due to lack of payment or upfront fees. This comes under Article 21, right to life. Article 21 has many parts, but right to life is one of the part of Article 21, which was released by Constitution on January 26, 1950. So example for this is case of petitioner Parmanand Katara, which was filed in 1989. Here a scooterist was hit by a speed car. After this, the patient was taken to nearby hospital, but that hospital was not having any medical legal filing and all. It was a small hospital, so he denied for the medical legal issue. He has denied the case, so he referred the case to one more hospital which is located 20 kilometers away. Meanwhile, while transferring the case has expired. So due to after this, there was a newspaper. This came in the newspaper, and with the public interest, this Paramananda Katara has filed the case. After this, because here the legal issues, doctor could deny the treatment for medical legal issues. So here there is balance between medical ethics and legal obligations and fundamental right to life. Article 21, there is violation of Article 21, right to life. So Supreme Court has given judgment that for the legal issues or for payment, for anything, emergency treatment cannot be delayed or denied. So Motor Vehicle Act 1988, Section 162 mandates the creation of scheme of cashless treatment of road accident victims during golden hour. So now it's not only not denying the treatment, you cannot delay the treatment also. Here they're talking about the golden hour concept. So you have to treat the patient in the right time. You cannot create morbidity delaying it. So this is one more newspaper cutting which was released this year on Jan 9, 2025. The Indian government, even in Telangana and Andhra, they are trying to give cashless medical treatment for road traffic accident victims during golden hour. And when search for the articles, the newspaper cuttings, the Karnataka government has launched Mukhyamantri Harish Yojana. This is for the accident victims. The medical treatment for first 48 hours in Karnataka is free. And this was named after Harish, who has donated his eye before the death. And they also provide 25,000 to the accident victim. And central government has also launched one more scheme. That is, scheme covers treatment cost up to 1.5 lakh for 7 days of trauma treatment after accident. if it is filed within 24 hours. This is applicable for all road traffic accident. This is also in Karnataka. And today, if you people have seen the newspaper, Telangana is trying to open more than 20 trauma centers with a free treatment. So government is taking initiative in to take care of the trauma victims. And the practical implications here are cashless treatment schemes. Initiatives like cashless everywhere schemes allow policyholders to receive treatment at any hospital without upfront payment. This is particularly beneficial in emergencies. And public-private partnership, hospitals receiving government subsidies or lands at concessional rates are obligated to provide free treatment to economically weaker sections. Challenges despite legal provisions, implementations, gaps persist. Issues like lack of awareness, resources, constraints, and administrative hurdles are often delay the emergency care. And it's important for the healthcare system, especially if it's a private sector, to strike a balance between delivering emergency care and addressing financial sustainability. I think if you're talking about treatment and payment, I think insurances, all such schemes would help the hospital for the financial implications. Take-home messages are, according to Article 21, or whether it is private or public hospital, private or government hospital, medical emergency care is the priority. And according to IPC Section 92, BNS 30, any action done in good faith for benefits of a person without their consent, for example, in emergency, obtained consent is impossible. Actions taken to prevent death or morbidity are not considered as offenses. So, if you ask treatment first or payment first, it is treatment only first. And if anything done in a good faith is always not an offense. Yeah. Thank you. Any questions? Mm-hmm.
And the golden hour treatment that has to be provided for free. Is it applicable only for government setups or corporate setups?
No, this is in AP Telangana as such act is not, they have not started the act anywhere. This has said whatever, yeah, the one in the left side, Jan 9th, whatever has they have released, they have said by March 14, 2025, state should have the cashless treatment opportunities. But any news did not come out of that. But today in the paper they are telling that they have opened up the centers. But as such, AP or Telangana does not have any such policy. But Karnataka, even if it is a private sector or government sector, it does not matter. They cover the, they have that scheme of 1.5 lakh coverage within 7 days if they register the case to the police in 24 hours.
So thank you, Dr. Anjani. Obviously, it was very important for you to tell us a lot of points, and I could just see back 7 years or 8 years back when you were there and we had done the road safety mission. And okay, so this point which Dr. Sharath has raised, so only Tamil Nadu is a state where NK48 is applicable. So what is NK48? So NK48 does not say like Arogyashri that you should have a CT scan before we tell that you have a head injury. It says 1,000 rupees for CT scan. So it is so easy for any trauma victim in Tamil Nadu under TAEI that if they reach to an hospital, even right from a CT scan to as simple thing as Ryle's tube insertion has a code. Their trauma codes, their emergency codes are as simple as Ryle's tube insertion, 200 rupees. Foley's catheter, 300 rupees. So that has made things, so nurse, the nurse can, just keep on writing what all has been done, and then it becomes perfectly free for the patient. In comparison, when we do it, we ask them to at least get viral markers done, at least get a CT scan done. I'm sure all of you will resonate with this. Then only we can prove a head injured patient to have a head injury. That is the most difficult part in the present Arogyashri of the state.
One more thing, you are mentioning about the MLC for all broad dead cases. Actually, in none of the hospitals I worked, we do MLC for all the broad dead. I mean, I know it is, we have to do it somehow from the management, or management also, there will be known people for them, and no one wants the MLC. So,
See, one
unless it is suspected. And also, it is not the death certificate. There are two kinds of forms in the emergency department. One is the death certificate that we give for the IP, or when the patient dies after some time. And we do only give the broad death certificate. Where we are not mentioning the cause. We are just telling that he's brought dead to the emergency department. So what are the legal implications?
When you are certifying a death, you have to attend the events of the death. Certification of death is different from giving a broad death certificate. Broad death certificate is only used for transport of the patient, supposingly. Broad death does not give cause of the death most of the time. Whatever forms I have seen, broad death does not give.
Yes.
Most of the time, cause is not there. It is like so and so, he was bought so and so with so and so moles, that which is used for transport purpose. Death certification is different.
So we definitely don't give the death certificate, but we only give the broad death, and patients also, attenders also come only for that.
Yeah,
I mean,
if it's not necessary patient attenders will give you the right information all the time. Suppose a young patient is coming who has not suffered any disease previously, but he was brought dead. When patient attenders say that he just had cough, fever, shortness of breath, how can we trust on that?
Yeah.
Later he might come out with some other history. So evaluating the situation there is very tricky. Okay. Yes.
Postmortem would be done only if the attendant does not, he feels like this. So that is what the fear of the public is, that if we do a MLC, then definitely postmortem is done. And you and I know it, that postmortem will only be done when there will be two opinions. One son says that he killed, the other one killed, other says no, he died a natural death. Then only postmortems are done. Otherwise, the forensic department does not have that much of time, and neither does our police.
Wherever we deal with this broad dead cases and attender does not want MLC, we just register it as MLC. But it is up to the police and the forensic department, depending on the body, whether they have to do it or not. There is always option even after registering.
So
it.
we had a recent such incident. I request Dr. Rohan, my colleague, to tell about this. So this is something which we were also.
See, basically when you do the MLC, that doesn't mean that all the patients will go for postmortem. That is the first thing. Everybody will think that once I have filed the MLC, that means the patient is going to the postmortem. That is the same thing we are conveying to the patient also, patient attendants also. We are telling that we are doing the MLC, so that the next question the patient attendant asks that, sir, is it going to the postmortem? We will definitely say yes. But the thing is that every case of the MLC will not go to the postmortem. That is the first thing. Again, it will be going and will be decided by the case-to-case basis by the police, by the forensic medicine department. That is the first thing. About the broad death certificate. See, broad death certificate, whatever we are giving, that is completely based on the institution policy. Okay, your institution has fixed that there is a broad death certificate. Actually, that is not a legal certificate. The only certificate we have to give is the MLC death certificate. You have seen, if you want to give, you have to directly give the pending investigation. This is the death case which have been seen. That's it. There is no concept of these broad death certificates. This has been now started, the broad death certificate. Everybody, it is there is no records also. If you go and see your hospital also, you go and see that there will be no records for the broad death also. Just you are giving a simple thing and you are sending the patient. That is not actually acceptable. But to make the MLC, if somebody certain cases are coming to ED, you have to sit with your administration people and you have to make your own institutional protocols. If you ask for the guidelines says 100% patient has to undergo MLC. There is no other thought for that. That's it.
I just want to clarify this death thing. There are 3 types of things which you receive this. Patient who enters the ER crashes before you has seen the events, like 5 minutes, you just resuscitate them. That is definitely death in ER, but cause of death is not known. There might be, you can write primary cause yet to be evaluated by postmortem. That is one option. But you cannot write any random cause of death. Next, you have been treating the patient since last 7-8 years. You know the cause of death. You give primary cause of death. Other one is a broad death. Broad death, I don't know the institutional policy here. What we follow is, we don't have even broad death certificate. We just register MLC and hand it over to the police and the forensic. Whether they want to do it, they want to carry on post-mortem or not, it is up to the police and the forensic department. We register MLC, write that form and transfer it to the mortuary. But we don't have any broad death certificate. You're certifying death, definitely that death should be in ER. But in the certificated death, whether you want to give primary cause of death or not depends on whether you have attended the events or not. Who has just come and just collapsed in 5 minutes, what cause of death can we give until there is some previous documentation? In such cases also, post-mortem plays role, and there you can just give query, post-mortem is pending in primary cause of death. But cardiopulmonary arrest is not the cause of death.
Hello.
Thank you.
Hello. I have two questions regarding the broad death too, please. The first is, the patient is broad dead in ER. Should we do CPR or not? Or when to do CPR? And if we are doing CPR, when to do CPR? Why and why not?
So suppose you ask the history, when did the patient collapse? Attenders will say they have just collapsed just now. Then you ask the time, they'll tell half an hour back. Half an hour back is just for them. But for us, 7 to 8 minutes is also so much, because in 8-9 minutes, the permanent damage of brain would have been happened. So obvious signs of life is not there. Pupils are completely dilated, body is completely cold, there are no signs of life. I don't think there's point in doing the CPR. This is according to the case-to-case basis only again. But the patient was just gasping in front of the ER, he came in and then pulse was not there. In those cases, CPR can be tried. If it is revivable, you think, then we try CPR. Obvious signs of deaths are there, rigidity is there, or lividity is there. So much time has happened, there's no point in doing CPRs.
One more thing, madam.
Yes.
If we want to certify the patient is broad dead,
yes,
should we certify immediately or should we carry out some procedures before certifying the patient is broad dead?
No, sir. ECG and all the examination is must before we certify that it's a cause. It's a broad dead. We check the pupils, heart rate, heart sounds, central pulse, ECG. After taking all this only, we certify it as broad dead. Without all these, we cannot certify broad dead.
One more thing, madam. Just now, sir told us audience that if there is a difference of our decision will be decided on the police information report. If our decisions goes against the police information report, sir, we do have right whether to do postmortem or not, or police will decide. Who will decide it?
Police and forensic together will decide whether the postmortem should be done or not, depending on their suspicion whether it is a natural or unnatural death, depending on the history and examination.
So we are the one to decide when we suspect some foul play, we want to do postmortem, and it's in our jurisdiction, right, madam?
It's not the attender, sir. It depends on the doctor and the police, not from the attender.
We can refer the forensic expert, the doctor who is on duty can refer the patient to the, can take the opinion of the forensic
police
expert.
Can take the decision, not the attender. Not the patient attender.
We can take the opinion of the forensic expert.
Yes, sir.
Thank you.
Hello. Yeah. Good afternoon, ma'am. Myself,
Yes,
Dr. Arindam Sinha, emergency physician, RNC Hospital. So it was a well-informed talk. Thanks for giving all the details with all the sections mentioned and the reference of Article 21. So coming back to the slides that you have mentioned, so out of them, one told us about the treatment that has to be carried on basis of good faith and all. So the case scenario that was given here was that okay, we have started the treatment and all, the patients arrived, and and thereafter he is in position to give the consent or whatever the formalities were required. So we are talking about a scenario where all the good things have happened.
Yes.
So just in case the reverse happens, and after that emergency surgery that we have performed, we lost the patient forever, and we till then we don't have any whereabouts about the patient acquaintances or relatives whatsoever. So in that kind of scenario, on whom the honors would be?
Yes, sir. Yeah, I would explain you the situation. Here, there are a lot of internal injuries. Doctor has operated him, we lost the case. Other scenario is we treated him, we have revived the case. If revived, well and good, everyone will appreciate you. But what if we don't revive the case? That is your doubt. In the situation not reviving the case, suppose you didn't treat the case. Like there was an example, scooterist hit by car, doctor denied because of the legal issues, he was scared of legal issues. Then he was filed. You don't attempt at all is definitely an offense. You trying to attempt something, you could not revive it, it is okay. But you don't attempt, definitely it is an offense. And like as ma'am said just now in the previous discussion, people who will decide all these are again doctors only. You have done in good faith with following all the legal, ethical things, procedure is right, still you couldn't revive. I think our doctors are only giving whether it is negligence or not alone. If you don't try reviving it, definitely it's an offense.
So in addition to that, two short questions. One is okay, fine.
Yeah, thank you.
Right, thank you so much, and thank you to the audience for engaging. We would now request Dr. Ashima Sharma, ma'am, to please come over to present a memento to Dr. Anjani, please. Thank you, ma'am. Moving on to our next session, this is the first of the two interactive sessions that we have planned for the day. And this is something that we have been listening to since morning, the importance of documentation and how it's just not a formality anymore, it's a lifesaver. It's the greatest greatest act that you can do for your own safety. And to give us a very well detailed explanation about the do's and the don'ts to navigate between MLCs, death certificates, like how ma'am mentioned just now, we have with us a great team put together, led by our consultant, Dr. Manohar Reddy, and our consultant, Dr. Akhila, our residents, Dr. Prudvi and Dr. Ganesh, who are here and who've worked so hard to put together this excellent workshop of sort. So I invite them to take over and lead us to this to the next session. Sir.
Slide. Good afternoon, everyone. I'm Dr. Manohar. I'm working as a consultant in this hospital, and I would like to discuss an the basics of medico-legal documentation and importance, and it's an interactive session. And I would like to all open your mobiles, and we'll be sharing a QR code scan. So you need to be promptly response to the questions that will be displayed. So we'll have a feedback discussion throughout this session.
Good afternoon, everyone. I'm Dr. Akila, Consultant, Department of Emergency Medicine. Today, to make our session more interactive, we are using Mentimeter. So I would request all of you to scan the QR code. You can just scan the QR code displayed on the screen, or a few of the QR codes are even being distributed. Or you can even enter the code in www.menti.com. And the code is 460-85157. So I would request all of you to join along with us.
Have any issue, we have volunteers at the back. Please raise your hand, they will help you join in. Please don't answer any question immediately. Once the slide shows the question, please answer them. Thank you.
I request all of you to join the poll. So the first question of the day is, have you ever faced medico-legal issues in your department? I request all of you to poll. So as it is shown on the screen, most of you have faced this issue. So we'll go ahead in our discussion. First, we'll start with the first case of the day. It is the mist allergy. So a 58 years old man, he presented to emergency department with shortness of breath and wheezing. He is a known asthmatic in the triage sheet, and the ER is busy, and there is a verbal handover from the night doctor to the morning shift. The incoming doctor, assuming asthma, prescribes IV ceftriaxone and salbutamol nebulization. Shortly after that, the rash, hypotension and respiratory distress. Crash call was activated. It is later discovered that the patient has a documented allergy to ceftriaxone in a previous shift, written in a scanned discharge summary, but this wasn't reviewed or reconfirmed during consent or documentation. So what steps in documentation or consent would have prevented this medical error? All of you can post your answers.
You can just type in and submit the
You can just type in the Mentometer app. So yeah, we got many responses. So I think we'll go ahead and see how proper documentation has to be done. So who should be responsible for verifying and documenting drug allergies? I think you can start polling your answers. As you all can see, it is shown that everyone involved in the patient care. So we'll see the answers by ongoing discussion.
So why medico-legal awareness is crucial in today's medical practice? So medical practice has changed dramatically over last recent years. The mutual trust between doctor and patient has significantly declined. Legal cases and consumer protection against doctors are on the rise. So I am here with this session to discuss and to share few guidelines to safe, ensure and responsible clinical practice for both the preventing and managing medico-legal cases. So the importance, what is the importance of record keeping and documentation of patient care? So we'll have a once again a case so where we can see the response with this.
We'll go ahead with another case. A 42 years old male patient presented to emergency department with severe back pain. After evaluation, the ED doctor orders a single 50 mg dose of tramadol IV. Later, the patient becomes drowsy and hypotensive. He is stabilized and discharged after observation. A week later, he files a complaint alleging that he was given a double dose of tramadol, leading to overdose symptoms. He claims he heard the nurse confirm 100 mg and now suffers from lingering dizziness. So the doctor insists that, and in doctor's defense, he insists that only 50 mg was prescribed and administered. However, no documentation exists of the dose given in the nursing notes. And no timestamp or drug sheet or no counter signature for drug administration. So if you were the judge in this case, how would you rule in this case? Do you go ahead for doctor or for patient, or is it inconclusive? It is almost an equal poll.
So we have an equal response. So what needs to be done, we'll see in the next slide.
So what simple documentation step could have changed the legal outcome here?
One word answer would suffice.
One word answer. You can just post your answers.
Thank you for the responses. So we can see, as with the theme of the presentation, it's the documentation. So it's the doctor at fault for not documenting the correct dose. If we see the last line of the previous case history, there it was ambiguous. It was just written tramadol IV. No proper dose was mentioned, no proper mention of time of administration, nothing was mentioned. It was not countersigned by any healthcare associate like nurses also. So it's the doctor who is at fault.
So have you ever seen such life situations where poor documentation backfired? I think some of you can share your experiences with us.
Please come forward if you want to share any real life experience that happened in your. Then
Yeah, I would like to share two experiences. One, in the emergency when potassium chloride was ordered, the instructions were not written. The doctor has just written IV potassium chloride 1 ampere. The nursing officer is new. She has just given a stat dose of potassium chloride. There was a cardiac arrest patient who came for a very simple green triaged case, had cardiac arrest because the nursing officer has administered it. Because she was a new nursing officer, she did not know how to administer potassium. She has just given it as a stat bolus dose and there was arrest. One more example, I think listening to this, you might think, do such things happen, but it really happened. Same thing, nursing officer, like house surgery, they also have some house surgery kind thing. During that time, one senior nursing officer was posted in a ward with 2 junior nursing officers. So she told her to administer amoxicillin and clavulanic acid. She told 1.2 grams. Then this female, she has written the same thing on the slip and she has given to the patient. The patient attender went to the pharmacy. He got amoxiclav. What amoxiclav he has got is the syrup. Here you get the pediatric syrups where that's in the powder form and both should be mixed and given. She has taken 1.2 ml of that and she has administered. The patient had cardiac arrest on the spot. Such things do happen. Whenever instructions are given, dose should be definitely mentioned, route should be definitely mentioned, and counter checking the drug whether it is parenteral route or oral route if new people are posted in the wards or emergencies, these things can happen anywhere. So drug documentation is very important. Counter signing by doctor is also very important. When you're in emergency situation, when you're telling the drug and repeating the dose, make sure that the nursing officer will repeat the dose and drug back to you. That is one way you can avoid the mistakes.
Particularly in emergency where we see life and death scenarios in front, we don't always do the written documentation. Sometimes we do the verbal documentation, but please make sure that even if it is a verbal documentation, after confirming from the nurse's end, please make sure that you go back to the document and mention it that a verbal order of this much was given and mention it in the case.
Okay, the same scenario was brought into the courtroom. The patient brings in a legal team arguing that the medical negligence has happened with no proper record providing the correct dose. So then the burden shifted to the doctor. So evidence is weak because there is no written evidence of dose administration. So the court concludes, so if it was not documented, it didn't happen. So how to better document could have helped this scenario? So clear dosing written instructions in the doctor notes or drug administration entry with the time and date with the nurse initials. And if you have a medical administration record, you need to have filed and filed it. And if the patient have developed any adverse reaction, so it should be noted in the progress notes. And later with the follow-up of vital sheet would have protected the doctor. So the challenges in medical record keeping in India. So the importance of record keeping is often realized only when we faced medical legal issues. So the quality for critical the critical for the quality care and the legal defenses in the West, record keeping is prioritized, but it is poorly implemented in India. And here it is a pressing note to improve the record keeping with a mindset shift change. So we need to preserve our documents, whatever, even the OP sheets, whatever we prescribed, we need to have a copy of the OP prescription sheet in our clinics. Okay. Many Indian consultants like our OP practicing or in visiting consultants, they used to document and just give the treatment instructions and leave. It's like a routine restaurant style practice where they'll come, they take treatment and they leave, the payment is made, and that's the end. So we don't have any proper documentation record with ourselves. So it is the time, so the era of all-in-one solo practice who handle everything is over. So medical practice these days requires structural record and supporting labs and accountability of each and every document that we have given to the patient. So why medical record keeping, why medical records matter? Good medical records are equal to the best legal defenses. So accurate record keeping is essential for the continuity and the safety of care. Well-maintained medical records serve as the strongest defense against the claims or medical negligence or malpractices. So in legal situations, especially court proceedings, documentation is the crucial evidence. So we can't always rely on your memory and guesswork if you don't have preserved our documents. So we'll go with the next case scenario.
So a 49-year-old woman, she visited emergency department complaining of persistent abdominal pain. After clinical examination, the ER physician advises a series of investigations, CBP, LFT and other investigations, and verbally communicates the urgency. She is discharged after being clinically stable and is asked to return with reports. 2 weeks later, she returns with worsening symptoms and claims that she was never told to get any test done. All documents are missing and the hospital system has no formally written record of the test advice. Her family files a complaint alleging negligence and lack of timely diagnosis and demands an explanation. The doctor recalls the consultation but fails to document the investigations in the discharge summary or note them in the electronic system. So what should be documented when investigations are advised, especially for a discharged patient?
So here we have seen the most of the responses are all of the above. If you see the first option, just verbal advice is never enough. So that is never the answer. And if we see the third option, provide written instructions to the patient. Just providing a written instruction we have to mention it in the discharge summary that labs were ordered and they were sent. Please advise the patient to follow back with the hospital with the reports. So that is a proper documentation. Without the proper documentation, it is not legally valid in the court.
So documentation is always equal to the protection when in court of law. So no written documentation or investigation advised in the case sheet or discharge summary. So no documentation patient communicated or follow-up instructions are documented. And family denies verbal instructions were never given. So how better documentation could have helped this case? So we should have mentioned the advised investigations in the case notes or discharge summary, the copy of investigation requisition forms or the prescriptions in the file, or digital logs in the hospital system confirming what we have advised, or a signed patient instruction slip or an electronic discharge advice including the investigations order should it be included in the discharge summary.
We have seen that in the previous, like in a routine practice, even in a routine clinical setup or in an emergency, it's very common that we just say to the nurse, please send these set of investigations, and then we just forget about that to ever document. But please make sure that you go back and write a simple note saying that a set of investigations were advised and advise the patient to get back to the hospital once the reports are there. So always try to document at least a single word that will stand as a legal standpoint in court. So according to the court, if it is not documented, it never happened. So we will be getting back to our memory to serve as an example. So it's not good. So always try to document.
So what makes a good medical record? So just remember 4 C's. It should be correct, clear, and the document should be chronological and should include a comprehensive history. So the practical uses of medical records. So it can be used in the education purpose, research, public health and planning, and even for legal and insurance purposes, and even as a statistical data also will help for research and audit also.
So do you document a time for every examination? So suppose you are doing an examination at a particular time. Do you document the time?
So majority of our answers are yes. Yes, it is definitely required to mention the time of examination. So we'll see that with the next example. So many physicians complain that they don't have the time to write the sufficient records, which is true with all of our regular practices. We see so many cases in the day-to-day end that we forget to mention or forget to document properly. Just remember that spend the time in the court for 12 weeks, 5 days a week from 9 to 5, or you take the simple few seconds or a minute to document the presentation. We'll see how it implies with the next case.
So 56 years old male patient, he presented with sudden onset dizziness and imbalance, and the time of arrival to ER is 10:30 a.m. So some doctor, he examines Mr. X and performs a neurological examination. The exam is completely normal, but due to the rush in the emergency department, he forgot to document the finding. At 2 p.m., patient deteriorates, he becomes drowsy, he develops slurred speech. A CT was done which revealed posterior circulation stroke. But the mistake that was done here is after initial neurological examination, it was not documented. So patient's family files a negligence case alleging that early warning signs were missed. Doctor explains he did perform a detailed neurological examination and he found it to be normal. He actually performed the examination, but there was no documentation available. Only on the next junior resident, he wrote a note at around 1:45 p.m. after doing the examination.
This is the regular case scenario that we see in our emergency department and even in the normal hospitals also. Here, the initial doctor failed to document a simple note saying that the exam was performed, it was normal. So this one line, if she had mentioned, it would have given a best defense for the lawyer. Just because it was not documented and the next note by the junior resident is at 1:45, according to the court, even though how good you are and how well you examine the patient and how well you did good to the patient, it didn't happen.
So legally, if an exam is not documented, it is considered as, I think you can all poll your answers.
You can see the majority of the results are not performed. Yes, it is completely true. According to the court, it is not performed.
So for the code purpose, whatever is not documented in your nose, it's never happened, regardless whatever you have actually done. So since there is no record evidence of examination documented, the court considered no examination was performed. So key learning is, even if you do everything perfectly, if it is not recorded, legally it never happened.
It's just that we are so fortunate that till now none of us had to face, hopefully, an medical legal case. But just remember that if it didn't document, it didn't happen according to the court's law.
So after this small session, how likely are you to improve documentation? You can just post your answers.
1 is less likely and 5 is more likely. Accepted. Hopefully, we can follow through to this in our regular practice also.
So remember, if it is not documented, it didn't happen. So best practice for safe documentation. So always record exact time and date of each patient and make it a consistent habit. So keep all copies of all investigation reports, especially if it is an MLC case. So in malpractice cases, doctor often realized too late that the reports were only with the patient, leaving them just to rely on what we remember. So during follow-ups also, if a patient misplaces their papers, it will be very difficult to continue the next step of treatment. So sometimes some patients may intentionally withhold or hide few reports, maybe under a possible lawyer advice, which could prove that doctors we were innocent. So for this defense, we always need to keep a copy of whatever the document, even a OP prescription.
Now we'll see the importance of discharge summary records, even in the normal setup and also in the emergency setup.
So why the discharge summary matters? Because discharge summary is the patient's final report card. So it acts as a final document, a summary of the hospital stay, treatment options, everything. It will be included in the case, in the discharge summary case sheet. So we'll see next case scenario, missing summary.
A 64 years old female patient, she was admitted for acute cholecystitis and underwent laparoscopic cholecystectomy, and she was discharged on 7th of February.
So it was a just simple note of admission, discharge, and small about the small note on clinical history and the surgery done only. So what are the issues with this discharge summary?
A week after discharge, Mrs. Lakshmi was rushed to a different hospital with altered sensorium and vomitings. It was discovered that she was taking double the dose of prescribed antibiotic, leading to toxicity. When the family accused the primary hospital of prescribing the wrong dose, the hospital couldn't retrieve the discharge summary. No copy was scanned, filed, or backed up. Only the summary was given to the patient, and hospital copy was not available.
In this scenario, we discharged the patient with an discharge summary record, but the issue is we didn't keep a record of the discharge summary in the hospital. So here we don't know whether we accidentally prescribed a wrong dose or the patient attenders actually withholding the evidence of the discharge summary so that they can file a medical negligence against the treating doctor. So should the hospital retain a copy of the discharge summary given to the patient? Yes, it's always advised to keep the discharge summary. It will stand as a legal standpoint in the court.
So as from the cited example, the legal percussions of not having documentation preserved. When the patient family filed a medical negligence case citing improper instructions, the hospital had no documentation to prove that what was written or explained. So the burden of proof fell on the hospital, but without summary, they couldn't defend the prescribing doctor. So how proper record keeping could have prevented this? A scanned copy or a carbon copy of a discharge summary would have verified the exact instructions that were given in the discharge summary, and notes of the discharge counseling, including the doses of the drugs were explained, should have shown some efforts to prevent the error. So for legal protection through complete documentation would have a strong stood strong in the court. So always remember, patient takes this home, and so we should have a copy, because we don't know what the patient can do with the copy. He can approach a lawyer, or he can sue against the doctor. When we don't have a document with us, and we'll be clueless, and we don't have a defense to stand.
Medication prescription is always a very common error that is always presented. Sometimes in the busy emergency room, we may wrongly prescribe a dose or something. If we have a copy of the documentation here, we will be at the fallback. So a small step where a second doctor who is not related to the case goes through the treating medications just to cross-check the dose of the medication, the timing of the medication, and the route of medication are properly written or not. So extra step where every discharge patient and another treating physician, if they can see the treatment advice, it will be even a better method. Thank you.
So what should a discharge summary should include? So it include date and time of admission and discharge, clinical findings, medical history, investigation done, treatments given, course and the progress of the clinical scenarios. If at all surgery has done and the complications would have been mentioned in the discharge summary. Diagnosis, discharge medications, dietary advice, and follow instructions and precautions post-discharge. So we have an example of discharge summary that have included everything, including dietary advice and follow-up instructions with clear drug doses mentioned. So next, coming to consent. So it's a is it a legal shield for us if patient have consent for a specific procedure? So always obtain a written consent, and even for minor procedure also. Avoid relying on oral consent. It holds little legal value. Ensure the consent form is provided in the patient's native language. In medico-legal cases, patient may claim that they were being asked just to sign without explanation. So consent must be informed. Patient should understand their diagnosis, procedures, risk, and the complications, and alternate treatments should have been explained. So without informed consent, doctors cannot be held legally accountable for violating patient's right. So sorry, doctor can be held legally accountable for violating patient's right. Consent must be signed by the patient unless he is a minor, unconscious, or medically unfit. In those cases, you can always get a consent from the legal guardian or the representative of that patient should sign. And always have a witness, either a nurse or a other attender to be present while signing the consent form.
We'll see two case scenarios.
So a 35 years old male patient, he presented with a complaint of persistent ingrown toenail causing pain and infection. So a minor nail avulsion was done in the emergency department. So the procedure was successfully performed by a ER resident. However, no consent was taken before doing the procedure, and risk, alternatives, and potential complications were not explained to the patient, or no note in the file indicating that verbal consent was taken either. So patient again developed a complication of chronic infection, and he came back after 2 weeks. So he sues the hospital, claiming that nobody explained to him that there could be a permanent damage.
Small correction here, the resident took a verbal consent, but he failed to document that he took the verbal consent, thinking that it is a minor procedure. So who is regularly responsible in this case? Please put. The patient, the resident that they did the procedure, the hospital, as there is no proper documentation of the consent, the outcome was rare, so no one is at fault. So here we have some equally responsible poles. So one thing, the resident, they did the procedure, and second thing, the hospital, there is no proper documentation of the consent. Here we can say that the resident is, he's legally in his training phases. So the hospital is majorly at fault because it doesn't have a proper documentation.
So do you think verbal consent alone is enough for minor procedures? You can just poll.
So as expected, we have two major polls. So it's the third option, always taking a written consent is always 100% good. But if you don't find a written consent, at least documenting that a verbal consent was taken would also legally can help us to take the defense.
So as he sued the doctor in the court, the hospital could not provide any documentation providing the informed consent was given. So the defense argument was not sufficient. So the court held hospital liable, emphasizing that informed consent must be documented, not assumed. So how proper documentation could have helped? So a simple pre-procedure consent form noting the nature of procedure and the possible risk of infections, nail bed deformity, signed by a patient would have served as a legal protection. So even a clear dated note stating in the that procedure explained potential complications to the patient and verbal consent obtained, even if this was mentioned in our notes also, it would have significantly helped the defending lawyer.
So the take home point from this case scenario is that even though it is a regular procedure that we do, if there is a written written consent, then it is a 100% good thing. If not, at least a documenting saying that verbal consent taken, risk explained, that would be sufficient in the legal standpoint.
So, takeaway from this case is consent is not just about ethics, it is also your shield in court. So checklist for consent. Always take written consent. It should be preferably in the local language. Inform about the diagnosis, risk, complications, and procedure or alternate therapies or alternate treatment options should be included.
The need for the taking consent in local language is very much important. We'll see with the next slide.
We'll just go ahead with the next case. A 42 years old female patient, chronic gallbladder pain, and she was advised for laparoscopic cholecystectomy. So she was admitted for elective surgery. The junior doctor handed her a standard consent form and said, just sign this before the surgery. The possible complications were not explained in their own language. Patient signed it without reading, and no one explained the risk, benefits, or alternative treatment. During the surgery, there was a complication. There was bile duct injury requiring a second operation. She later sued the hospital saying that I didn't even know this could happen. I just signed because I was told to. No one explained this to me.
So here we get a lot of patients who don't really understand our language from various places. So here we can say two things. One thing, the doctor might have explained in the local language saying the risk and complication, and then she could have signed, or a whole doctor might be at fault and he didn't properly explain the procedure and he could have taken the consent. Either way could have gone. So here we are just relying on our memory, thinking that whether we have explained the complications, everything about the procedure in the local language or not. So how to go around this, we'll see in the next slide.
So what went wrong? Was the consent was not truly informed? There was no document that explains risk and benefit discussion took place. There was no written note in the file about the explanation of potential complications to the patient and family, and there is no witness signed to confirm the verbal briefing also.
if a patient signs without understanding, is it still a valid consent?
So yes, the 28 poll, no understanding is essential. It's definitely essential. And we can say that sometimes we explain the procedure, they sign the thing, but if it is not documented that the procedure has been explained in the local language, and if you don't have a witness signature is always the bypass, where if there is no proper people who don't understand the primary language as the consent is written, then we can explain the procedure that it's been in their local language, and just take a counter sign just from either the attender or a nurse who is beside us or another any healthcare professional, so that we can bypass in the legal standpoint.
So how better consent and documentation could have prevented this? So verbal explanation of procedure plus risks in their patient own understandable language, and a note in the file about the procedure risk and alternative treatments were explained, and the patient's questions patient asked were answered and gave verbal consent. Signed and dated consent form specific to the procedure, not just a blank one. So witness, preferably a nurse or the second attender, confirming that the explanation were given. If all these were documented, definitely the case would have stand according to the doctor.
A simple note where patient asked questions and the explanation was given, this will have a very strong legal handhold in the court. So that only, then if they sign, we can say that patient asked questions about the procedure. We can do that only if they understand about the procedure. So that simple line in our consent form would play a major role. First thing would always be having a consent in the local language. If it is not possible, then at least mention this line, patient asked questions and the further explanation was given. And third thing, having a secondary signature as a witness, that would always help us in the case.
So the essential checklist of the informed consent. So patient should be clearly understand the medical condition. So plan of treatment or procedure was clearly explained. Alternative treatment options were given. Risk and possible complications of both the planned or alternative treatments would have been explained. Communicate the chances of success or failure of the proposed treatment or procedure. Identify the identity of the treating doctor or surgeon should be disclosed. And inform the patient of any serious risk, including death or permanent harm, whether with the procedure or if they chose not to go ahead with the procedure. And specific unique risk specific to that procedure should always be documented. And patient should have clearly explained about the hospital facilities, including operation theater conditions, and staff capability should be explained to the patient and patient family. And if a patient refuses to refuse the sign for the consent form, that also should be documented.
Taking a denied consent is also very much important. Sometimes they can say that they didn't deny the procedure. So writing a simple note, the risk and complications are explained and the patient didn't consent for the procedure. This simple note also will have a very good legal standpoint in the court. We'll see the next case.
So 58 years old male patient, diagnosed as acute ischemic stroke. He initially went to a district hospital as there was no on-call neurologist and and no ICU beds. They referred that patient to a tertiary care center, which is 45 minutes away. And during the and he just referred to higher center for further management. Unfortunately, during the transit, we lost the patient. So
there was no mention of reason for referral, whether the hospital, whether the receiving hospital is contacted or not, and the patient or family consent is taken or not. We see these scenarios very commonly in our Indian setup. USA has a very good referral system where they are transferring a patient. The doctor who received the patient needs to call the receiving hospital, make sure that everything is there, only then write a proper transfer summary, and then the case should be shifted there, and he has to make sure that the case received in the receiving hospital also. All these legal standpoints have a very strong role in the US, but in India we see very commonly where a patient is being referred from an outside hospital, simply referring to higher center for further management. No doctor will be informed, no other things will be done. But if the patient really goes to court, the transferring doctor will always be at risk for legal suing. Okay, what went wrong in the case, we'll see.
So the receiving hospital did not have a neurologist on call and the ICU was full. The family claimed that they were unaware of this and blamed the referring doctor for not confirming the availability of bed beforehand. So the receiving team refused admission and Mr. Ramesh's condition deteriorated en route to another hospital. So a lawsuit was filed against the primary doctor alleging negligence and abandoning the patient crucial window time period.
So who do you think is primarily responsible? Is it the referring doctor, receiving hospital, hospital administration? Is it patient family, or is it a shared responsibility?
Yes, as expected. So majority of you think it's the referring doctor who is at fault. But in India, we don't have a proper referring channel through that every doctor can go. So hospital administration is also at fault in a way. So it's not just the doctor who is referring the patient, it also the hospital that should have a proper referring channel, so that if there is no proper beds are not available, if a particular doctor is not available, so legal standpoint between the doctor and the hospital always carries a role. So shared responsibility will be a better answer.
So has anyone faced a similar real life situation?
You can either type in Menti, or someone would like to come front and explain if anyone faced a medical legal case just by referring a patient and something bad happened.
Hello, I was working with Ministry of Health Saudi Arabia for 16 years. Whenever we used to refer the patient to higher centers, every ambulance used to have one sister and doctor with incubator if neonate is there, and ventilator in adult patients. And whenever we used to transfer our patient to higher centers, the place I was working at, the higher center was almost at 150 kilometers. We used to travel, our vehicle used to pass through the mountains. And when we used to take the patient to the higher centers, doctors, they used to see the patient, and only after their signature, they used to call up the referral hospital, and only after that patient will be accepted. If patient dies on the way, we were held responsible. 3-4 times same thing happened with me. One patient died, but the inquiry was, it held, and it was not my fault. So even after spending 16 years with Ministry of Health Saudi Arabia, so strict regulations there, I think you know how to work in kingdom, but nothing went wrong with me, and because I did my best, so everything went peacefully. Thank you.
I don't know whether we should say we are just truly fortunate, or it's just fault of the system as whole. So we don't have a proper referring channels. So referring channels is always important for the doctor and the hospitals to be at the safer side in the legal standpoint. I think it's better we formulate a new rule for the transferring in the future.
So would this case be defensible in court? Why or why not?
You can type in the responses. Do you think it will be defensible in the court? If we find a good advocate, yes. So definitely, if the if the patient goes to court, we are definitely legally responsible. We should be answerable. So referring a patient, if we don't have services, is not at fault. Making sure that we call the referring hospital, making sure that they have the services is always a good point, but still we need further more legal representations.
So for legal importance in the court of law, the primary doctor had no document evidence of having offered multiple hospital options or communicating with the tertiary care center or explaining the risk of transfer involved or ensuring the pre-transfer stabilization or getting informed consent from the family or sending complete investigation report. So since there was no document, the court assumed no steps were taken for transferring, so severely weakening the doctor's defense.
It's just not about only documenting that we are referring the case. These all points should be there before we can say we will be at the legal defense. So it's always better we have a proper documentation channel.
So how better documentation could have prevented this? So clearly written transfer note detailing like reason for referral, need for like a neurologist or a ICU requirement, or receiving hospital name and the person whom you have contacted, and the confirmation of bed availability, and pre-transfer vitals and the treatment which was given in the referring hospital should be clearly mentioned. So the consent form signed by the family acknowledging the reason for referral and the treatment options and the transport risk would definitely help legally for us. So always communicating log like time, date, and designation person to whom you have spoken to the receiving hospital should be documented, and all the copies of investigations including the transfer form should be kept with us.
As with the discharge summary record, we also need to have a transfer summary record also, so that if they go to court, we'll have a documentation and we don't have to rely on our memory.
So document tips for the patient transfers. So offer the patient or their family multiple options for referral or transfer. Ensure the patient follow process is well coordinated. Always retain copies of all transfer notes and the investigation reports. Clearly document the clinical reason and justification for transferring the patient in the medical records. So always remember reason for referral and the contacted person of the hospital, and patient family consent should be there in the record document of our hospitals if you are transferring a patient. So next we'll have one more case scenario, the empty emergency room.
A hospital advertises 24/7 emergency services on a signage and website. At 3 a.m., a 42-year-old man arrived with chest pain. The security guard says that there was no doctor on duty and asked the patient to wait till morning. The patient collapses in the waiting area and is rushed elsewhere, later diagnosed with myocardial infarction. The family sues the court for false representation and medical negligence. So, is the hospital liable for misleading public representation? So, the hospital advertised that there was 24/7 services, but actually there was no doctor available at 3 a.m. in the morning.
So this is a very common example even in India, similar to the transfer note. So we have seen so many boards outside in the small clinics or in a hospital saying 24/7 emergency services are available. But if they fail to provide the emergency services 24/7 with a doctor who is available 24/7, this, if the patient goes to the court, will be at the legal.
So, is the hospital legally responsible if no emergency doctor is present despite advertising 24/7 emergency services? You can just poll your answers.
So definitely it is misleading the public. So how to bypass this point also we'll see in the next slide.
So always better documentation could have helped. So a clear signed on-call duty roster should be available, CCTV timestamp of the patient entry and tries attempted should have helped the case, and incident report with the staff members, and clear policy displayed like emergency services available on call, maybe specific time period like 12 to 6 p.m. If I've mentioned, could have helped the case to protect doctor. So key takeaway from this case, like advertising 24/7 services. So we are legally bound to serve 24/7. So hospital must provide prompt services even if such services are promoted. So no doctor present is equal to gross negligence. So failure to have a qualified respondent at a clinic critical times is seen as a serious oversight. So especially if harm or worsening condition or even death could happen because of delay of doctor. So staff presence is not equal to the medical care. So only having a security or administration doesn't fulfill the emergency care promises. So when you have labeled as a 24/7, make sure it is available with a designated team of doctors, nurses, and administration available 24/7. So next we have a case scenario.
So 62 years old male patient visited to emergency department complaining of dizziness. Due to high patient load, he had to wait 2 hours before getting attendant. During this time, he requested water from a nurse. The nurse responded curtly saying this is not a restaurant and walked away. The patient humiliated and left against medical advice. Three days later, Mr. Suresh was admitted to another hospital with hypertensive emergency. His son filed a legal complaint stating that the earlier hospital staff was negligent and abusive, directly causing delay in treatment. So there was no documentation of the incident, no record of LAMA discussion, or no note or interaction or behavior issue. The hospital had to issue an apology and faced investigation for patient mistreatment.
Staff conduct is also one of the thing that happens in a busy ER or in a natural setup. We can sometimes get angry at the patient, but if they go lama and something bad happens to the patient, we'll be at the legal standpoint.
So if you were the hospital administration, what 3 steps would you have taken to prevent the legal risk in such situations?
So hospitals are liable for the actions of their staff, especially if poor conduct leads to harm or emotional distress to the patient or family. So even a small behavioral issues can snowball into a legal liability if not addressed or documented. So lack of documentation weakened the hospital defense as they had no internal record of interaction of patient or refusal of care. So how better documentation could have helped this case? So a simple entry like a patient requested water, staff informed of waiting time, the patient appeared dissatisfied but remained stable could have helped this case. So or patient a documented AMA form with witnessed should also should have helped this case. So staff conduct. So rude staff is equal to patient dissatisfaction and it will lead to legal complaint. So staff is equal to the extension of your care. So every patient complaint, have you ever heard of a patient complaint you ever had a patient complaint because of your staff behavior? By law, an employer is legally accountable for the actions of their staff. It is both your right and duty to supervise the employees under your care. So always verify and maintain original qualification and the experience certificate of your staff. Hire only qualified personnel for all roles. Discourteous behavior by staff, including a ward boy, sweeper, or nurse receptionist, can trigger patient complaints. Patient's frustration with a staff member often becomes a complaint against a doctor or a hospital. Remember, your staff represents you. Both the praise and blame for their actions will reflect on you. As we are running out of time, we're just skipping few topics. రావట్లేదు టచ్ కాదు. So, as mentioned in the previous talks also about the clarity of death certificates, and we'll be discussing how to fill it in a correct form. So, there is no actually death certificate. It's a medical cause of death that we are giving. So, we have both Form 4 and Form 4A that usually will be given in the hospital. So, Form 4 is for the hospital, in-hospital deaths that happen, that includes medical cause of death. And the same Form 4A, it is like out of hospital cardiac arrest or death. So even for broad death also you can give. But the Form 4A should be given by the treating primary doctor who was aware of the patient previous condition, and he can certify Form 4A. So, and this is the death report. When you face like broad death patient arriving to an emergency, we can just simply report the death instead of doing MLC, or whether it is a natural, or definitely if there is a foul play, we have to do an MLC, and we have to inform the police. So, but if you suspect there is a no foul play and simple it was a peace death, so we can just report death. So this option, report death, can be done by a hospital, or even the person himself can document the death report and could submit to the municipality office. So the police would verify the cause of death, and then the death certificate will be issued by the municipal corporations. So here there is an option of cause of death, was it certified or not? You can just simply mention no. So the burden of facing all the legal complications, including MLCs, would be relieved if we just report from our side. So there is no concept of broad death certificate anywhere in the legally.
So whatever certification we are giving is just medical certification of the cause of death. It's not the death certificate. Death certificate should be issued by the magistrate. So the patient or the family people who that passed away, they should take this Form 4 or 4A or the Form 2, and they need to go to a magistrate. There they will give the death certificate. So the certification that we are giving is just medical certification for the cause of death. It's not the death summary, death certificates.
So always for filling the death certificate, only the attending physician should write the death certificate, and he need to be aware of the terminal event of the patient. Then only if he have clearly identified the cause of death, then only he can give death certificate. If not, again it will land up in doing an MLC case. So the death certificate has 2 sessions. So part 1 has cause of death, and part 2 the other significant conditions contributing to the death. And again part 1 is divided into 3 lines, like immediate cause, antecedent cause, and underlying cause. So if a single condition clearly explains the death, only one line like 1A would be sufficient.
So here we have a simple case. A person known case of diabetes died due to septicemia after a perforation happened due to chronic duodenal ulcer secondary to leading to peritonitis. So what is the most appropriate option for 1B? We are getting some equal polls, but the correct answer for this is the peritonitis. We have seen in the first previous note, we have seen 1A, 1B, 1C, and also we have a part 2. So here the 1A is septicemia. So that it's the immediate cause of death. It was secondary to peritonitis. So 1B is peritonitis. Peritonitis is the correct answer. 1C would be the chronic duodenal ulcer. Second case, a person died of uremia due to chronic bilateral renal failure as a result of hypertension as a consequence of CKD. What is the most appropriate for 1C? So here 1C can actually be hypertension or chronic kidney disease. Some can say that part 2 should include chronic kidney disease and part 1C should include hypertension, but it can go either way. Yes, hypertension or CKD would have a proper thing. 1A is the most important thing that always needs to be filled.
So what not to write in the death certificates or medical legal cause of death certificate. When multiple conditions are involved, filling out certificate carefully and completely. So start with part 1A. So it should be the immediate cause of death. Do not list a mode of dying like cardiac arrest, respiratory failure, or cardiopulmonary arrest. These are not cause of death. These are manner of deaths. So immediate cause of the immediate cause resulted from another condition must be entered as a part 1B, antecedent cause. If there is a third step, you can add 1C like underlying cause. And finally, it need to be get as a tabulated as official column, official cause for the death. So use clear diagnostic terms, not like terminal events. So when you have a patient like broad death or out of hospital death certification, who can issue certificate in out of hospital cardiac arrest? So all natural cause of deaths, if the registered practitioner or family doctor or recently treating doctor can check with the history and he can certify medical cause of death. So if no doctor is available, as mentioned previously, you can just report the death report and inform the authorities like municipality, and further steps will be taken care of by the municipality, like they will inquire about the suspicious leading to the death, and if there is no foul play, and municipality with police team can verify and give a death certificate. So out of hospital deaths, if it is like sudden or unnatural, like accidents, suicide or homicide or any suspicious foul play, so always it warrants to inform and document MLC. And always death certificate will be issued by the forensic team, not an emergency doctor.
For this opportunity. So we have seen that medical cause of certification of the death is the thing that we can give, which is form 4 or form 4A or the form 2. So if a person who is treating the patient, if he knows the history and everything, even if the death appears to be natural, there is no, even if the broad dead, if he knows about the history and everything, he can certify the death, issuing the medical cause of certification of death. If you have a doubt whether it happened or not, then definitely MLC should be notified. Thank you. Any doubts?
Thank you, everyone. You can have, if any questions, you can just raise in the Mentimeter, or you can raise now.
Thank you very much for that session, Manohar sir, Akila ma'am, Prudvi, behind the scenes, Ganesh and Yagna sir. And I would now request Ratna sir to please come and present a memento to Manohar sir, please. I would also request Ratna sir to present a memento to Dr. Akhila. I would also like to request Ratna sir to present a memento to Prudvi, please. Thank you, everyone. So for the next session, we would like to call this the culmination of everything that we have been learning and hearing since morning. And we have very enthusiastically put together a little play, a mock courtroom trial. And before we get to that, we'll break for a quick coffee break. We'll come back in 10 minutes, after which we'll have the mock courtroom trial. So we hope to see you all at 4:50 again. We'll start off at 4:50. 10 minutes. Okay. Okay, 4:55. We'll meet again at 4:55.
Okay, certificates. Okay, charge ఉంటుందా? 44%.
From side to side, side, side to side. If this was
నెక్ దగ్గర పట్టుకోవాలి
Welcome back, everyone. And we're here gathered for the last session of the day. And we are very excited to present this very last segment that we have, which is a mock courtroom trial. So this was curated with the idea of what if all that we do falls apart? What if we do have documentation? What if we do have consent? What if we do communicate? What if we do document that communication? What if we do it all and yet we are dragged to the court by some unfortunate event? What happens then? What happens then? What does the lawyer do? How do the lawyers come to our rescue? How does it all play out at a court? Fortunately, I don't know many who have actually gone and been in that situation themselves, but let's hope we all have an idea of how it really looks like. We have a fantastic team here who have brought all this together, and we hope that we would be able to take you through a real courtroom scene. So please put your hands together for this mock courtroom trial that we have very enthusiastically put together. No,
The scene begins with flashing club lights and loud music in the background. A person visibly intoxicated stumbles out of a nightclub. The person swaying unsteadily approaches his car, fumbles with his keys and manages to start the ignition. His vision blurs and his hands struggle to keep control of the wheel. Suddenly the car swerves dangerously. As sirens blare, an ambulance arrives at the wreckage site. Emergency medical technicians rush to the scene, swiftly assessing the injured patient and loading him onto a stretcher. Entering the emergency department,
Doctor, we have a patient here who clearly seems intoxicated. He met with a car accident. His vitals are BP 100/60, respiratory is 40, saturation is 95 and room air There are some chest bruises.
Thank you. We'll take over the patient from here.
The patient is now wheeled inside as the emergency room staff prepares for further evaluation. Inside, a busy ED monitors beeping and staff moving quickly.
Nurse, would you please check at the vitals and let me know?
Yes, sir. Saturations are around 92 and breathing around 40 breaths per minute. Blood pressure of 100/60 and pulse rate around 120 beats per minute.
Dr. Kshitij, would you please auscultate and let me know the findings?
Sir, there are decreased breath sounds on the left side. Patient is currently hemodynamically stable with GCS of E4, V4, M6. Pupils are reactive and there are multiple injuries on his chest region.
Okay, let me auscultate.
Doctor! Help! Doctor!
Oh yes, there seems to be a severe chest injury and I suspect we have a case of a pneumothorax and prepare for an ICD.
Doctor, we have chest X-ray on bedside on standby and ICD equipments are ready.
Good.
Suddenly, the patient's family rushes into the ED, their faces filled with worry.
Tammudu! Tammudu!
Doctor, ఏమైంది?
డాక్టర్ గారు నొప్పి అంటున్నాడండి, ఏదో ఒకటి చేయండి. ఏమైందండి? Good evening. Hold on. I'm Dr. Vamshidhar, a consultant here, and your brother seems to have a very bad accident and he sustained a very bad chest injuries.
మీరు ఏం మాట్లాడుతున్నారో అర్థం కావట్లేదండి.
అయ్యా మాకు తెలుగు తప్ప ఏం అర్థం కాదయ్యా, మాకేం అర్థం కావట్లేదు అయ్యా, ఏం చెప్తున్నారు? Yeah. He sustained a very bad chest injuries and then I suspect we have a condition called pneumothorax. We need to place a tube in his chest called ICD.
అయ్యా మాకు తెలిసిన డాక్టర్ ఉన్నారు, ఆయనతో మాట్లాడండి, ఆయన మాకు చెప్తే మేము సంతకం పెడతామండి.
మీరు ముందు ఫోన్ మాట్లాడండి, మా డాక్టర్ గారు లైన్లో ఉన్నారు, ఫోన్ మాట్లాడండి. మీరు ఫోన్ మాట్లాడండి, మీరు ముందు ఫోన్ మాట్లాడండి, మా డాక్టర్ గారు ఉన్నారు. You think I have time enough to do all these things? I'm here to do what I'm supposed to do.
సంతకాలు అంటారు ఏంటి? నాకైతే ఏం
I'm not supposed to. I am here to do what I'm supposed to do. I'm here to place the tube. I don't have time enough to explain you the condition. అమ్మా అదేదో గూగుల్ గమ్మ బర్బుల్ గమ్మ అంటారు కదా, అది కొట్టు చూడు ఒకసారి, నువ్వు చూడు.
లేదన్నయ్యా, ఏం చేద్దాం ఇప్పుడు?
We need to place a tube inside it and for which we need your consent. Kindly sign the document. Kindly listen to what I'm saying. I do not have time enough to explain you. We need your consent for that and we need you to sign the documents. Dr. Kshitij, get the document signed.
చెప్పేది ఒక నిమిషం వినండి అయ్యా.
You think I have time enough?
మాకు మీరు చెప్పండి.
I do not have any time for having a discussion.
ఇప్పుడైతే మా వాడు మాట్లాడుతున్నాడు కదా, మా అన్నయ్య.
మా అన్నయ్య బాగున్నాడు కదా.
ఇప్పుడైతే మేము సంతకం పెట్టట్లేదు.
పెట్టొద్దమ్మా, నువ్వు పెట్టబాకు. No, you need to have the sign. You need to sign the documents. అయ్యో నొప్పి అంటున్నాడండి, నొప్పి అంటే ట్యూబ్ అంటారేంటి? That is what.
మాట్లాడుతున్నాడు కదా, సంతకాలు ఎందుకు పెట్టాలి ట్యూబ్ కి?
Patient is currently stable but we cannot predict when the condition may worsen.
లేదండి, మేమైతే సంతకం పెట్టాలనుకోవట్లేదు.
ఏమండి వచ్చిన దగ్గర నుంచి ట్యూబ్ అంటున్నారు, వర్స్ అంటున్నారు, మాకేం అర్థం కావట్లేదండి. మా డాక్టర్ తో మాట్లాడమన్నా మాట్లాడట్లేదు మీరు.
Suddenly, the patient starts gasping for breath, his condition worsening.
Dr. Kshitij, I think the patient is collapsing. Prepare for intubation and prepare for an ICD.
Yes, sir, sure.
Lokesh, help me with the ICD placement. Jyoti, help Vamsi sir with the intubation.
The patient lands into a cardiopulmonary arrest. In an attempt to stabilize, CPR is initiated, the patient is intubated, and emergency needle decompression is performed, followed by an ICD. Despite all these efforts, the patient does not make it. He doesn't survive.
Time of death 3 a.m.
Now the family rushes back into the ED. The grief now quickly turning into anger.
ఏమైందండి? ఏమైంది? చనిపోయాడా మా తమ్ముడు?
మాట్లాడలేదు ఏంటండి? ఏం చేశారు? ఏంటి ట్యూబ్ లేంటి? మేము వద్దన్నాం కదా. ఎందుకు చేశారు? Come this side. Let me have a word with you. Come this side. కాదు వర్డ్ ఏంటండి? మా వాడు మాట్లాడలేదు ఏంటి? Come this side. Let me have a word with you.
పొట్టలు పెట్టుకుంటారు మన వాడినయ్యా.
ఏంటండి? ఏంటి అసలు ట్యూబ్? మేము చంపేశారా? ట్యూబ్లెస్ చంపేశారా? వద్దన్నాం కదా మేము.
వదిలిపెట్టదన్నయ్య వాళ్ళని
As I clearly kindly listen to what I'm saying. Kindly listen to what I'm saying.
మేము కోర్టులోనే వింటాం.
Kindly listen to what I'm saying.
విందామన్నయ్య ఆగండి.
Your brother was wheeled in a very bad condition.
ఫస్ట్ ఆఫ్ ఆల్ మాకు అర్థం కావట్లేదయ్యా మీరు చెప్పేది. మీరే చంపేశారు వాడిని, మిమ్మల్ని వదిలిపెట్టాం మేము.
Kindly listen to what I'm saying. Stop making a drama here.
లాగుదాం కోర్టుకి, అప్పుడు చూసుకుందాం డ్రామాలేవు.
రామ్మా, మనం ఇక్కడ ఏం మాట్లాడద్దు, మనం కోర్టులో మాట్లాడుకుందాం రండి.
The family storms out of the ED. The atmosphere is dark and somber. The doctor now finally seeks legal advice. Let's see how the scene proceeds inside the lawyer's office.
Good evening, sir. Thank you for the time. We had a patient, a young patient, who came to us in a very bad condition. We tried our best to save his life, but unfortunately the patient died, and we need your help.
Okay, doctor. Can you tell me what was the patient's condition when he came to the hospital?
Well, the patient's condition was pretty stable when he came, but pretty soon the patient's conditions deteriorated, and we tried our level best when he developed the condition called tension pneumothorax, and we intended to put a tube that would help his condition to get better, but fortunately the patient died.
Okay. Did you counsel the attenders about this procedure?
Oh yes, we did.
Did they give their consent for the procedure?
No, they refused the consent.
They refused the consent.
They refused the consent.
So, doctor, did you document that they refused for the consent?
Yes, sir, we've clearly documented.
So, the condition that you are telling about, was it tension pneumothorax?
Yes, the patient presented with a condition called pneumothorax, which then worsened into a life-threatening condition called tension pneumothorax, for which an ICD had to be placed. And in this meantime, before we could save him, the patient died.
Okay. So, the treatment option that you provided, ICD, if I'm right, is it the standard treatment protocol for the condition?
Yes. That is an international standard protocol driven by ATLS protocols, and this is the treatment for that condition.
Oh, fine then. I think we have excellent legal grounds to win this case here. Let's see them in the court.
Thank you so much.
So finally, there has been a complaint filed against Dr. Vamshi by the family for allegedly acting with negligence under section 304A IPC BNS 106, which states that whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide is punishable. Now let's see how the legal proceedings go. Now inside the courtroom.
CC number 10 of 2025.
All rise.
All rise. All rise. All rise. All rise.
The judge arrives.
CC number 10 of 2025. Dr. Vamshidhar Azaro. Dr. Vamshidhar Azaro. Miss Sushma Azaro. Miss Sushma Azaro. దేవుడి మీద ప్రమాణం చేసి
అంతా నిజమే చెప్తాను
నిజము తప్ప మరేది చెప్పను.
సో సుష్మా గారు, ఆ రోజు హాస్పిటల్లో ఏమైంది చెప్పండి.
యాక్సిడెంట్ అయిందన్నారు సార్.
హాస్పిటల్కి రమ్మన్నారు. వెళ్ళేసరికి మా అన్నయ్య బాగానే మాట్లాడుతూ ఉన్నాడు సార్. ఛాతిలో నొప్పి వస్తుంది అన్నాడు. తర్వాత కొంచెం ఆయాసం వచ్చింది అన్నాడు. డాక్టర్ ఏమో మాకు తెలియని లాంగ్వేజ్ ఇంగ్లీష్లో మాట్లాడుతూ ఉన్నారు. తెలుగులో చెప్పండి అయ్యా అన్నా కానీ ఎక్స్ప్లెయిన్ చేయలేదు. ట్యూబ్ వేయాలన్నారు. మా డాక్టర్తో మాట్లాడండి, ఆయన చెప్తే మాకు అర్థమవుతుంది, అప్పుడు సంతకం పెడతామంటే టైం లేదన్నారు. తీరా చూస్తే చచ్చిపోతున్నాడు అని చెప్పి చచ్చిన శవాన్ని మా చేతికి అప్పగిచ్చారండి. అంత చచ్చిపోయే స్టేజ్లో ఉన్నట్టయితే ఆ ట్యూబ్ అయితే ముందే వేసి వాడిని బతికించవచ్చు కదా, శవాన్ని మా చేతికి అప్పగిస్తారా? ఎంతవరకు న్యాయం అండి ఇది? చాలా బాధాకరమైన విషయం అండి ఇది.
థ్యాంక్ యూ, యువర్ ఆనర్. సుష్మా గారు నమస్తే. ఆ రోజు మీ తమ్ముడిని హాస్పిటల్కి తీసుకొచ్చినప్పుడు మీ తమ్ముడి కండిషన్ గురించి డాక్టర్ మీకు చెప్పారా లేదా?
చెప్పారయ్యా.
మీ తమ్ముడి కండిషన్ చాలా క్రిటికల్ కండిషన్లో ఉందని చెప్పారా లేదా?
చెప్పారండి.
మీ తమ్ముడు బ్రతకడానికి ఒక ట్యూబ్ వేయాలి, వేస్తేనే మంచి జరుగుతుందని మీకు చెప్పారు కదా?
చెప్పారండి, కానీ మాకు అర్థం అవ్వలేదు. ఆయన చెప్పింది మాకు అర్థం అవ్వలేదండి.
అర్థం అవ్వలేదు, కానీ మీకు ఒక పేపర్ ఇచ్చి సైన్ చేయమని చెప్పారు, కానీ మీరు చేయలేదు.
పెట్టలేదు, మాకు అర్థం కాక.
మీరు అర్థం కాక సంతకం చేయలేదు. యువర్ ఆనర్, ద డిఫెన్స్ వుడ్ లైక్ టు submit their evidence. Here is a copy of documentation where the doctor clearly mentioned that the patient attenders refused to give consent and they also refused to sign a refusal form too. Okay. సో సంతకం చేయడానికి మీరు డిలే చేశారు, అవునా?
మాకు అర్థం కాలేదండి. మా డాక్టర్తో మాట్లాడితే మేము సంతకం పెడతామన్నాం, ఆయన ఎక్స్ప్లెయిన్ చేస్తే మాకు, కానీ వాళ్ళు మాట్లాడడం డిలే అయింది మా దగ్గర నుంచి.
ఓకే, సో మీరు మీ డాక్టర్తో మాట్లాడాలని చెప్పి సైన్ చేయకుండా డిలే చేశారు. సో మీ వల్లే ప్రొసీజర్ డిలే అయింది, అవునా?
అవునండి.
మీ వల్లే డిలే జరిగింది కాబట్టి మీ వల్లే పేషెంట్ చనిపోయాడు.
కాదండి, అలా అనకండి.
మీ వల్లే పేషెంట్ చనిపోయాడు.
లేదయ్యా, అలా అనకండి.
Objection. Badgering the complainant.
Objection is sustained.
Thank you.
That's all, Your Honor.
Is there any evidence from prosecution?
No, Your Honor.
No. Whether you have any evidence from defense?
Yes.
Doctor side?
Yes, Your Honor. My doctor would give.
You can examine the doctor.
Thank you, Your Honor.
Pramanam Chair. I will swear in the name of God.
I will swear in the name of God
that I will
speak truth but
nothing else.
Thank you, Your Honor. So, Dr. Vamshi, do you agree that consent is required for procedures?
Yes, I agree.
Okay. And do you also agree that consent is not necessary for emergency conditions?
Yes. But when we received the patient was received in a stable condition and immediately the patient deteriorated. Before we could do something, the patient died.
Okay. And like the file says, this simple pneumothorax progressed to something called a tension pneumothorax. Am I right?
Yes.
And how often does this happen, Dr. Vamshi?
It occurs pretty often, but we do not have a count of it and we never knew when it happens.
I see. So you're saying you don't know when it happens. Are you competent enough, doctor?
Objection. The competence of doctor here is not under question.
Objection is overruled.
Dr. Vamshi.
I am a board certified emergency medicine physician with over 11 years of experience and I am pretty competent and confident about doing this and performing this procedure. And if I am allowed to do this procedure, I would have done this again, but at 30 seconds earlier.
Okay. So, like I see here, you intubated the patient, which means placing a tube in the throat. Am I right?
Yes, you are right.
Okay. So, with all your experience, may I ask you, do you agree that the likelihood of this condition worsening only increases after intubation?
The likelihood of worsening increases, but we have optimized the ventilatory settings according to the current condition.
Okay, but you do agree that the likelihood increases?
Yes, it increases.
I rest my case, Your Honor.
Your Honor, I would request the court to allow me to cross one more witness for further questioning.
Request is allowed. Call the witness.
జడ్జి గారు మా తమ్ముడిని చంపేశారండి బాబా.
ముందు ప్రమాణం చేయి. దేవుడి మీద ప్రమాణం చేసి,
దేవుడి మీద ప్రమాణం చేసి
అంతా నిజమే చెప్తాను,
అంతా నిజమే చెప్తాను,
నిజం తప్ప మరి ఏది చెప్పను.
సుధాకర్ గారు నమస్తే.
నమస్తే.
ఐఎమ్ రియలీ సారీ ఫర్ యువర్ లాస్, కానీ ఐ వాంట్ టు ఎస్టాబ్లిష్ వాట్ ఎగ్జాక్ట్లీ హ్యాపెండ్ ఆన్ దట్ డే. ఆ రోజు జరిగిన వివరాలు తెలుసుకోవాలనుకుంటున్నాను.
మా తమ్ముడు మాట్లాడుతున్నాడండి, నొప్పి అన్నాడండి, సంతకాలు అన్నారండి, ఫోన్ మాట్లాడమన్నా మాట్లాడలేదండి, చివరికి చంపేశారయ్యా బాబు.
మీ తమ్ముడిని అరౌండ్ ఏ టైంకి హాస్పిటల్కి తీసుకొచ్చారు?
2-2:30 గంటలకు తీసుకొచ్చారండి. మేము అప్పుడు లేము, ఇక్కడ వచ్చాడని తెలిసింది, వెంటనే వచ్చాం.
ఓకే, 2 గంటలకు వచ్చారు. డాక్టర్ మీ తమ్ముడి కండిషన్ గురించి మీకు ఏ టైంకి చెప్పారు?
రమారామి అదే టైంకి చెప్పారండి, 2-2:30కి చెప్పారండి.
ఓకే, డాక్టర్ మీ తమ్ముడి కండిషన్ నుంచి మీకు చెప్పినప్పుడు మీ తమ్ముడు ఎలా ఉన్నారు?
నొప్పి అని ఏడుస్తున్నాడండి.
మాట్లాడుతున్నారు, బాగానే ఉన్నారు. తను బాగున్న సమయంలో డాక్టర్ మీకు ఒక ఫామ్ ఇచ్చి సైన్ చేయమని అడిగారు, అవునా?
సంతకం అంటున్నారండి, ఇంగ్లీష్లో ఏదేదో మాట్లాడుతున్నారండి, మాకు అర్థం కాలేదండి.
సరే, మీరు సంతకం చేయనందుకు డాక్టర్ మీ మాటని గౌరవించి ప్రొసీజర్ చేయకుండా దాన్ని డిలే చేశారు, అవునా?
ఆలస్యం వద్దని అనుకోలేదండి, చేయమంటున్నారు, మాకు అర్థం కాలేదు, మేము చేయలేదు.
కానీ పేషెంట్ కండిషన్ బ్యాడ్ అయినప్పుడు డాక్టర్ వెంటనే ప్రొసీజర్ చేశారు, అవునా కాదా?
అవునండి, చేశారు.
సో పేషెంట్ బాగున్నప్పుడు మీ పర్మిషన్ కోసం వెయిట్ చేసి బాగాలేనప్పుడు ప్రొసీజర్ చేశారు, అంతేనా?
మాకంత అర్థం కాదు బాబయ్య, మాకు తెలియదండి.
దట్స్ ఇట్, యువర్ ఆనర్.
Can you present your arguments?
Yes.
Your Honor, the victim, a 32-year-old young man, he walked into the hospital that day with a simple breathing issue. And the doctor delayed a life-saving procedure despite establishing that the condition could progress and become bad. Your Honor, saving a life is much more important than legal or consent formalities according to Parmanand versus Union of India in 1989. And here, this is a case of clear gross negligence and the family deserves justice. According to IPC 304A, which is now BNS 106, it states that anybody who is involved by negligence and causes death is criminally punishable. Therefore, I request that the doctor should be punished and the family deserves justice. That's all, Your Honor.
Defense.
Your Honor, while the loss of life is very tragic, we must focus on evidence rather than emotion here. When the patient was brought to the hospital, he was very stable. He was speaking. It was a simple pneumothorax at that time. During that time, my client, Dr. Vamshi, has explained the patient's condition to the attenders and he requested consent. He respected the patient's right of autonomy according to the Article 21 of Indian Constitution. But they refused. They delayed for the consent, and again, my doctor, Vamshi, he has respected their decision and did not perform the procedure. But when the situation escalated, when the patient became bad, he did not wait for any consent anymore. He immediately jumped into the action and performed a life-saving procedure with a good faith of saving the person's life. This act of doctor is clearly protected under section 92, which states that when a person in a good faith acts to save a person's life, the outcome of that procedure is not in the question. He cannot be held responsible for the outcome. And Your Honor, I would like to quote one landmark case here, Jacob versus State of Punjab 2005, in which the Supreme Court has clearly mentioned that when you want to criminally allege a doctor of negligence, the burden of proving the negligence lies on the prosecution. Here, my doctor, with no malice or no intent, acted in only one way, in a good faith of saving the life of the person. So, to conclude, I would like to say, my doctor respected the patient's autonomy according to Article 21. The act that he has performed is well protected under section 92. The wisdom given by the Supreme Court in the verdict of Jacob versus State of Punjab clearly states they have to prove the negligence here. I don't see any negligence on my doctor's part. He has done his job at the right time. So this judgment would be an example for many life-saving doctors out there. So I humbly request the Honorable Court to rule this judgment in favor of my client, thereby acquitting Dr. Vamshi. Thank you.
Now it is time for announcing judgment of this case. Before pronouncing the judgment, what I understood in this case is, generally no doctor will be negligent in discharging their duties. They will take care of the patient. In this case also, the court feels that he did his job very well. He informed the patient and attenders about the emergency of the case and also requested them to sign on the papers for further course. But in this case, the attendants did not understand the language of the doctor who spoke in English. That made all the gap between the attendants of the patient and the doctor. So what the court feels in this case is that the management of the hospital is directed to take steps for appointment of facilitators to inform the whatever the doctor wants to inform about the procedure or further course of the action in their vernacular language, so that the gap between the attendance of the patient and the doctors can be reduced to some extent, so that they also can give consent immediately. So after this finding, the court is going to pronounce the judgment. In this case, what the court feels, the patient condition was very cogent and very fine at the time of admission, except the pain he complained. Meanwhile, some conversation took place between doctor and the attendants of the patient regarding the procedure, but they were arrogant because of the unable to understand the language what he spoke. They worried about the procedure, whatever the doctor informed, they could not able to understand the procedure said by or informed by the doctor. So they waited for some time. Meanwhile, the patient condition was deteriorated. In that situation, the doctor has taken drastic step and performed whatever the procedure to be done, but unfortunately the patient died. In this case, except the communication gap between the doctor's attendant and the doctor, nothing negligent was there on the part of the doctor, the court feels. But however, from next time onwards, the doctors or management is directed to take appropriate steps to inform the patients in their manner. However, the court feels that there is no guilty of the doctor in causing the death of the patient. Hence, it is hereby the accused is acquitted from all the charges leveled against the accused. The prosecution has failed to prove the guilty of the doctor beyond the reasonable doubts, which is most required point in the court of law to prove the negligence of the doctor. Hence, the accused is hereby acquitted for all the charges leveled against him by the prosecution.
Thank you, Your Honor.
Thank you, sir. Thank you so much.
So to summarize this case, to summarize this case, a trauma patient with pneumothorax deteriorated into tension pneumothorax in the emergency department. The doctor tried to obtain consent for the ICD, but the patient's family did not understand the severity and refused consent. The doctor did the procedure under emergency necessity, but the patient was declared dead shortly after. The family alleged medical negligence and unauthorized treatment. So let it be an interactive session, and the questions to the audience: what could have been done better in this case to avoid trial? Can anyone answer? Opinions from the audience? Please raise your hands if you want the mic. So firstly, as the Honorable Judge said, improved documentation and communication from the doctor's side. The doctor could have communicated in a better language which was understood by the patient, so that which would have made the attenders give consent for the procedure in order to save the life of the patient. The patient would not have deteriorated if the ICD was placed earlier. The second thing was use of language barrier solutions like translators, pictograms, escalation protocols. Senior review or second opinion would have been most important in this case. Effective communication strategies, and then finally the emotional debriefing with the family post-event would have prevented the trial. So in medicine, we are trained to save lives, but rarely are we trained to defend them. What you just witnessed is not a fiction, it is reality, raw, unpredictable, and deeply human. A young man, a preventable accident, a cascade of critical decisions made in seconds. And somewhere between the chaos of the emergency room and the grief of a family, a line was crossed, not of negligence, but of misunderstanding and of mistrust. This mock trial scenario, which is refusal, is not about assigning blame. It is about uncovering the truth hidden between good intent and a tragic outcome. It challenges us to confront uncomfortable but necessary questions. What happens when time-sensitive decisions collide with emotional resistance? Does a physician's duty to act override a family's fear to consent? Can saving a life cost you your career? The courtroom may be where the verdict is passed, but the real trial is fought in the hearts of the healthcare workers every single day. And here's what we must remember. In emergencies, hesitation is as lethal as error. Communication is as critical as intuition. Documentation is not just a formality, it is your legal armor. And empathy must never be lost in urgency. To the doctors watching, you are not invincible, but neither are you disposable. Protect your patients, but protect yourselves too. With clarity, with compassion, and with record keeping. To the public and future healthcare leaders, trust is the bridge between science and survival. Understand that not every decision comes with the luxury of time to discuss, dissect, or delay. In those moments, your doctor may be the only one standing between life and science. This case might end in a courtroom, but many such stories never make it there. They end in hospital corridors with broken families, exhausted physicians, and unanswered questions. So let this mock trial not be just a simulation, let it be a lesson, a mirror, and a call to action. Because the next time the alarm sounds, it won't be a script, it will be real, and you must be the one holding the tube or signing the form. Thank you.
Thank you so much. And now we'd like to invite Manohar sir on stage, please, to give away mementos to Dr. Vamshi. And I'd like to ask sir to also give a memento to Dr. Sirisha. Thank you, sir. So to bring the entire day into a summary, I would now like to invite our consultants, Dr. Srilekha and Dr. Karthik, to come and give us the day's summary.
Hi, myself Dr. Srilekha. Okay, today you had gone through a very long session. Okay, as medical professionals, we take care of the lives, but we had to know about the legal aspects, and that is equally more important. Just we'll make the gist of the points that we has gone through since today morning. Okay, Karthik, can you just enlighten about the workplace violence and POCSO law.
Hello all, myself Dr. Karthik. Whether coming to keynote points, coming to medical workplace violence, this is inevitable in any hospital, any work setup. We have to know what should we do. Okay. The thing is, one thing can be avoided, like continuing, conducting the medical drills, continuous trainings, and placing a code for separate code for violence, and mock drills to be conducted. And there are laws for protecting the doctors, but the only thing which can be protected us is us only. Okay. And for that, we have to improve some awareness. We have to create awareness in patient attendance. We have to just change the behavioral changes, including us, and we have to maintain proper communication regarding what is our approach and what to be done. Everything to be clearly mentioned to attendants. Okay. And another thing is clear documentation can be protected us and protect us from in any situation. And coming to sexual abuse and POCSO Act, anything, any behavior, illogical behavior and illegal behavior regarding a minor female will be considered as a sexual abuse. Okay. And coming to POCSO Act, there are some 1069 codes placed specially for that act. And yes.
Okay. Today, the most enlightening and the most eye-opening session and the most engaging session is the mock courtroom trial. And it has given us the clear insight of what happens in and out of the emergency department. Okay. I just want to simplify few things regarding the consent and everything. Okay. Every time the consent should be well documented and it should be in the same language. Okay. And we have to maintain the medical records and the transfer records. Okay. And we need to get the professional indemnity insurance. Regarding the death certification, we should not use any vague terms like heart failure or so. And communication with the patient by the staff, that is the staff conduct, that is most important. Why? Because this will ensure the trust among the patient and the staff. And well documented discharge summaries regarding the mentioning about the medicines and how long they have to use. And we should avoid any misleading the representations like public representations or anything, the advertisements like 24/7 will be available. In spite that there are no any doctors available, this should be avoided.
Srilekha Madam, can you please mention the keynote points regarding consent? Consents taken.
So regarding the concerns, we should know what are the different types of concerns available. Like it should be in the written format, and it should be in the same language. And regarding the patients, if the patient's age is less than 18 years, and what is the policy, that should be noted. Okay. And the witness also is most important. Primary and the secondary witness should be there.
Mainly in consents, there are exceptions for consent in like medical emergencies. Any medical emergency, consent is not required. When the patient came into conscious or whether the patient attendants come, then you can take the consent. But in emergency situation, consent is not necessary. And before taking consent, patient should be, or consenting person should be in full competency to give the consent.
According to the Motor Vehicle Act, I think so in the first hour, the golden hour, there need not be any consent. The treatment must be given. In spite of any financial issues or anything, we should not take into account, and we should deliver the treatment.
Madam, can you please give a key points on end of life care?
See, end of life care, the palliative care, which is most important, which is still not appropriately followed in the India. Okay. 80% of the patients die in the ICUs and 2% only get the palliative care. See, prolonging the patient's life, giving the aggressive treatment doesn't ensure the any improvement in the quality or anything. It will cause lot of financial burden and lot of other risks to the families. Okay. So first we need to ensure that whether prolonging the aggressive care is it beneficial to the family and to the patient.
We have to think of expenditure also and the financial constraints of the patient, and we have to clearly mention about the benefits and risks of continuing the treatment. And coming to medical legal negligence, proper documentation is the only thing which can save us in the legal issues. Okay, and whenever an FIR and complaint is lodged on us, first thing you should do is do not panic. We should consult a lawyer and a reply to be placed, and we have to make the proper documentation, and we have to provide all the documentations which are required to the court. And we receive only whenever punishment is, we are truly believed as guilty. Okay, a team of doctors will be there. They will court sessions will be conducted. Then only we will be proved as guilty, and then only we can receive the punishment. So we should not panic. We should make the documentation properly. We should stick on to only one point, which is truth and which is to be done. So that thing only can be saved us from medical negligence. Thank you.
Thank you.
Hello. Okay. Thank you, Srilekha ma'am and Karthik sir. Vamshi sir, could you do the honors of giving them those, please? Karthik sir, please. Srilekha ma'am. The moment who came out was Srilekha ma'am's. I think they can do a mutual exchange later on. Srilekha ma'am. Well, I think this is what dilution looks like. Many people funneled out, but nevertheless, thank you all for staying us with till the end. You think we need to, honor and recognize one more person? Our comparer, right? Yeah, who took all the struggles in designing and everything. Let's join our hands to welcome Dr. Nitya, and I request Ratna sir to give our anchor for today a token of appreciation in the form of a memento. Thank you so much, sir, and thank you, Nitya. Now, Adarsh, can you come on to the dais and deliver the vote of thanks?
Good evening, everyone. Sure, it was a day packed with insights and discussions and a wealth of knowledge, and I know our brains have had quite a workout today. So before we reach full capacity and before we have doctor on doctor violence, let's just end this good discussion today. First of all, on behalf of the entire organizing team, it is my privilege to extend our heartfelt gratitude to all those who contributed to making this event a grand success. So we first are deeply honored by the presence of our chief guest, Sri VC Sajanar Garu, IPS, and we sincerely thank him for gracing us with his presence today. Our sincere appreciation goes to all the AIG heads, DNR sir, PVS Raju sir, and GV Rao sir for their support, presence, and for providing us a platform to learn, for help and grow and conduct such meaningful events. And a special thank you to our marketing team led by Sahu Garu and Mr. Amit Chaudhary Garu for their invaluable role in securing our esteemed chief guest, and assembling an outstanding panel. So our panel members included Dr. Ashima ma'am from NIMS, Srimati Vishwajanani, and Sri Dr. Vijay Kumar, Sri Dr. Vineet G, MS Ortho IPS, and our very own organizing chairman, Dr. Ratna Kumar sir, senior consultant and HOD of emergency medicine, AIG Hospitals, Dr. Venkat Kotam Raju Garu, and Dr. Rahul Rohan, and Dr. Karthik Ravikanti sir. So we express our deep gratitude to Mr. Satya sir from academics and Mrs. Dhanalakshmi ma'am for their unwavering support in providing the auditorium and patiently accommodating our countless requests. We also thank Satya from academics for facilitating the TSMC points that we are going to get, the 2 points that for all the participants. And a big thank you for Mr. Robin sir, who led the branding team along with Mrs. Dhanalakshmi and the dedicated team, Mr. Bhargav and Anuradha. And Bhargav, whom we all know, we've known him since our ED days. He's been incredibly helpful, not only with photography, but he was also remembered as one of our best and favorite coordinators back in the day. So we are grateful to all our sponsors for their generous support in making this event come true. That is Serum Institute of India, Dockland Insurance Services, and Reliance. To all our esteemed speakers and panelists, we extend our heartfelt thanks, and a special mention to Kepri sir, whose unwavering support, approachability, experience, and enthusiasm. This has been a driving force for us behind this event. A big thank you to our medical director, Dr. Naveen sir, and his encouragement, his wisdom, and invaluable guidance. Our gratitude also extends to the consultants, residents, and the ED staff for their dedication and relentless efforts. A special note of appreciation to those who are currently on duty and to those who have attended and are going in night duty, that is Dr. Karthik sir, Dr. Vamshi sir, Dr. Shiva sir, and Dr. Meghna and Dr. Pavan, who are our first year residents who've been awake since more than 24 hours to run events smoothly. So this event would not have been possible without the leadership and vision of our very own organizing chairman, Dr. Ratna sir, and his relentless efforts, and more importantly, our organizing secretary, Dr. Sarath sir, who has enabled us to conduct our first ever emergency medicine CME in AIG Hospitals. And honestly, he has been the backbone of today's event. Finally, a big thank you to each and every one of you for your participation and support. And to anyone's name who I may have unintentionally missed, please accept my sincerest apologies. Your contributions have been invaluable, and we extend our deepest heartfelt gratitude to you. Thank you. Okay. All the diluted people who are left at the end of the CME, can everyone assemble on this huge stage so we can all take a group photo and then we can leave? Thank you. Can I request everyone that's sitting in the back, all the young men over there, please come in. The one wearing scrubs who's leaving too. You can come in. Yeah.